No, it doesn't matter.
All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, February 27th, 2024. We have 13 bills on the docket. The first 5 of which are Senator Shelley Heddleman, who is here. Welcome to JPR. So we'll go first with Senate Bill 752, Senator Heddleman. Would you like to bring up your sponsor panel?
And sweet, given that this committee heard this bill last year. But we are back. For the record, I'm Shelley Heddleman from District 11 in Baltimore County, and I am happy to be here before the Judicial Proceedings Committee. Thank you, Mr. Chairman and members. Senate Bill 752 is really a suicide prevention effort that empowers those who may be experiencing a severe mental health crisis. It empowers them on their own to voluntarily put themselves on a list so that they are prohibited from purchasing a firearm at a time when they may be at heightened risk for suicide. It is our hope, and many individuals who suffer from episodic mental illness tell us that when individuals with mental illness are in periods of stability, they would take this effort to protect themselves. There are over 26,000 people who died by suicide using a firearm in the United States in 2021. And that includes, over the past 15 years, the veteran firearm suicide rate, which has increased nearly every year, where we lose an average of 4,500 veterans every year, about 12 deaths a day. And that is why this year, the Veterans Caucus has endorsed this bill. This bill requires the Maryland Department of Health to create and maintain a voluntary do not list firearm list by the end of this year, and prohibits dealers or other persons from selling, renting, loaning, or transferring a firearm to those who are registered. And to be clear, this year, this bill differs slightly by it only applies to state regulated firearms. Firearms are the most common means for suicide, and access to them is quite high and is a concerning public health record. A public health matter. In gambling, we enable Marylanders to put themselves on a list to restrict their access to casinos. Why shouldn't we do the same here when the stakes are even higher? It is imperative that Marylanders have the opportunity to restrict their own access to firearms ahead of time if they know it will protect them. And they also have the ability to take themselves off of the list after a 21-day waiting period. We have been in discussions with the Department of Health. There are a lot of protections in this legislation as introduced to protect identity, an identity verification system through the Comptroller's Office, through the MVA and the Department of Health. This really piggybacks onto a process that the Department of Health uses now for consideration of whether a firearm applicant has spent more than 30 days or more in a mental health institution, which precludes them from purchasing a firearm. So it really piggybacks on an already existing system. I urge your favorable report, and we'll turn it over to my witness here. And I believe we have one virtual also. Thank you very much.
Good afternoon. I am Karen Herron, Executive Director of Marylanders to Prevent Gun Violence. I'm here in support of SB 752 to establish a voluntary do not sell firearm list. Every year, around 24,748 people die by gun suicide. About 57% of the gun deaths in the United States are by firearm suicide. In Maryland, our homicides outweigh our suicides, and the rate is lower at about 35%, but that's still around 278 deaths per year. That is a gun suicide death every 32 hours. Suicides and suicide attempts cost Maryland taxpayers around $3.8 billion each year, or around $625 per resident. Every study that has examined the issue of firearm access as a risk factor for suicide has found that within the U.S., access to firearms is associated with increased risk. Guns are simply more lethal than other means. They're quick and they're irreversible. About 85% of attempts with a firearm are fatal. That is a much higher fatality rate than basically every other method. Many of the most widely used suicide attempt methods have case fatality rates below 5%. And critically, 9 out of 10 people who attempt suicide and survive will not go on to die by suicide at a later date. So reducing access to lethal means really matters. This bill is about reducing that access to those who need it the most and who choose to do so. MPGV urges a favorable report on SB 752. Thank you.
Thank you very much. We'll hear from the virtual panelists and then we'll turn it over to the committee for questions. All right, Karina, you're up. Welcome.
Hello, my name is Katrina Breeze. I want to express my strongest support for this bill. My mother recently died by suicide with a handgun that she had just purchased that same day. She wanted to live. She wanted to play with her grandchildren. She definitely did not want to die. She had a very extreme side effect from an antidepressant that increased her psychosis and impulsive suicidality. She was aware of this and frightened by her state. She immediately took proactive steps to protect herself from suicide every single way that she legally could. She went to her doctors and psychiatrists regularly and maintained almost daily contact with them. She then voluntarily committed herself to inpatient psychiatric care multiple times in a row. She tried everything she could to not kill herself. Despite the best psychiatric care, my mother ultimately graduated from her hospital programs and impulsively searched for nearby gun stores on her iPhone. She drove to a gun store and bought her first gun and shot herself. Our family called the police 5 times that day to prevent the tragedy that was unfolding. My mom had never even held a gun before. She took that gun to the public park and she shot herself there. My mom would have signed up for this list because she did not want to die. Had she been involuntarily committed to the psychiatric hospital, she would have been protected from an impulsive suicidal gun purchase. But because she took the initiative to voluntarily commit herself to a psychiatric hospital, she was not protected from purchasing a gun. A voluntary waiting period to purchase a gun could have saved her life. I want to be on this list too. Thank you very much.
Ms. Breeze, thank you very much for taking the time to testify here with us in Maryland, and thank you for sharing your story. I'm going to turn it over to the committee for questions. We have Senator West.
Thank you, Mr. Chair. So for the sponsor, I've got a couple of questions. Firstly, I need to stand up at the podium, I'm afraid, in this committee. Are these registration lists publicly accessible if I wanted to go online or go in person? And
No. It's held by the Department of Health, and each week they get a list of people that are precluded from purchasing because they've been in a mental health institution, for example, for more than 30 days. So it's held in the Department of Health.
So how is a gun shop owner going to know that someone has had their name added to the list and therefore should not sell the gun to that person?
The same way they do for someone who's precluded because of institutionalization. The FFL, once someone makes the request, the MDH will verify want me to walk you through the process?
Yeah,
Because
when you go to a gun shop, they check whether you're prohibited against the federal list. And this registration would be with the state, correct?
Well, we have, right, there are certain people who are prohibited from purchasing a firearm now in our state law, including someone who's been in a mental health institution for more than 30 days, right? So somebody fills out the 77R application. This would be another question on that application. Are you on the do not sell registry, for example? And then you go to the FFL to buy your firearm. You complete the application. MSP, the state police, will use the same exact system to determine whether someone's on that registry that they do right now to determine if someone is a prohibited purchaser. right? If they were voluntarily or involuntarily committed to a mental health institution for more than 30 days. Then the FFL submits that application. Within 7 days, MSP does their check. Yes, they're okay to purchase. No, they're not okay to purchase, just like they do now with all of the other checks. And that's how it works.
Okay, so the gun shop owner would not see.
They
the
don't have to
list.
do anything more than they currently do.
Gotcha, okay. I'm wondering who would actually take the time to go and register with the state? Do we have?
Person who testified.
Well, there was one person who testified. Has this bill or something like it been enacted in other states?
Yes, it
Do you
has.
have any statistics showing that a lot of people have taken this time and? effort?
It has in 3 other states, in Utah, Virginia, and Washington State. I don't have updated numbers. I know that there have been over 40 people in Virginia who've done it, and I believe it's only been around for 2 years in Virginia.
So I note the fiscal note says it's going to cost $367,000. So if we have the same results in Virginia, we're going to spend $367,000 and 40 people are going to take advantage of this system?
Well, 2 things. One is that's a one-time cost to change the computer system. And I believe we can get that down if we change some dates. And in fact, on the House side, we extended the implementation and it brought the fiscal note down under the committee's limit. So I'm happy. I think you have that amendment before you. So I'm happy to do that. Again, it's, a computer or technological change, and I would not want to put a price on the potential of saving lives.
Well, I guess my last question is, of the 40 people who did it in Virginia, do we know how many of those 40 people were concerned about committing suicide as opposed to people who were just against guns and as an exercise in virtue signaling decided, I'm going to put my name on this list?
I do not know that, but I have never heard of that type of virtue signaling.
Okay. Thank you very much.
Thank you.
Further questions from the committee? All right, seeing none, thank you very much. Thank you.
Thank you.
Thank you, Senator. All right, that completes the testimony for the proponents of the bill. We'll now switch to the opposition panel and we'll hear from John Jocelyn and Taylor McKee.
Good afternoon, Mr. Chairman, members of the committee. John Jocelyn, 2A Maryland, speaking in opposition to Senate Bill 752. Question would be, how effective will be the bill? As was noted by the sponsor, it applies only to regulated firearms. It does not apply to any firearm you already own, and it doesn't apply to any non-regulated firearm that you could go out and purchase, because the NICS system will not report the fact that the person's put themselves on the list. We have some concerns procedurally on the bill. It says that the state has 5 days to put you on. And if you decide you want to opt out, they give you forms that you can fill out. The state then has 21 days grace period before they do anything, but they must remove you promptly. And as I've testified before, promptly is a nebulous term. It's not defined in this legislation. So if they do nothing, you have no recourse. You have no procedure in the bill that says this is how you appeal if they haven't taken you off. One of the other problems that we found was we were told that it was going to be private. According to the bill, the Maryland State Police, the Voluntary Do Not Sell Registry, the Central Repository, the Motor Vehicle Administration, the Office of the Comptroller, and the Maryland Department of Health will all be involved. That's not exactly private. The bill does provide in 5-905 a penalty for anyone who is discriminated against in various occupations. My question would be, rhetorically, if we have a penalty provision, it anticipates that your material information will not be private. So the question before the House is, if we have a penalty, then obviously we've said somewhere along the line someone can get access. We don't have so much of a problem with the concept as in the procedure that we've built. And on those grounds, we oppose this legislation and ask for an unfavorable report. Thank you.
One minor correction. This is the Senate, not the House, but I always have to make that correction. All right. All right. Thanks.
Mr. Chairman, members of this committee, my name is Taylor McKee with the National Rifle Association. We have some procedural concerns with the bill more than anything. I don't see any recourse if the agency fails to remove a person from this list. Just wanting to make sure this information is confidential if someone's placed on it. To improve the bill, we'd suggest you require a prospective applicant do so in person. The language of the bill says the application submitted to a department that the secretary provides. I'm not sure if this is physical or electronic. And to make sure it's the person who is actually applying for this process, we would like for it to be in person with a license, with a state issued photo identification involved in this process. That way we're ensuring those who want to be on it are the only ones that are on it, and also provide a civil remedy in addition to the criminal remedy. And then provide a concrete time frame for removal. Ideally, the time to get on the list and get off the list would be the same. There's a discrepancy there. You got 21 days or no sooner than 21 days, leaving that open indefinitely. We'd like to at least see a hard and fast termination date on getting off that list, but ideally it'd be the same number of days to get on as it would get off. And then there's also some concerns with criminal justice system potentially abusing this, where judges may pressure individuals when it comes to bond or parole or probation or make part of a plea, asking someone to get on this list. So for those reasons, sir, we'd object. Thank you.
Excellent. Thank you very much. Questions on the committee? Senator Folden.
Thank you, Mr. Chairman. John, I guess if you want to come up to the podium, please. So on I guess it's the federal form, the 77.
4473.
44, yeah. What? That's about the 30-day mental, if you've been in a mental institution for 30 days or longer. If they check that block, is it an automatic disqualifier?
If it's been involuntarily confined, yes, it's probably going to be a prohibitor.
Okay. And then if they have been and they don't check that block in the affirmation, but they say no,
They'd be open to a federal charge of perjury.
federal charge of perjury, but this is what I'm saying is, would that still stop them from being able to purchase even with the 7-day wait period?
If they perjured themselves and for some reason Nix wasn't up to date, and this does happen, I mean, it's human driven.
Okay.
Yes, they could in fact purchase when they should have been denied.
Right. And then, the reason I ask is because I find it interesting that we're asking someone that is in emotional or mental crises, their competency to take away one of their own constitutional protections. So can you give me an example of some of the can you give me an example of a non-regulated firearm?
Any rifle or shotgun that is not listed as a regulated firearm in Maryland.
So
Any hunting rifle, any hunting shotgun, they would not be regulated.
so the way that this list is set up, it would only be regulated firearms, but they could still go in at any given time and purchase shotgun, rifle, and the like.
That is correct. They could purchase any long gun that's non-regulated. They would be prohibited from purchasing any regulated firearm, which would be all handguns
Yes.
and some long guns.
So as it's written, it's not an absolute.
It's the analogy is the submarine with screen doors.
Yeah, it is. So I look, I think that it's important that we're trying to meet the objective of what the intent of the bill is. And it sounds like even you guys coming up and testifying that you recognize that there might be some way that people want to be on this list, right?
Absolutely.
But in person is paramount to ensuring that the person that comes in is the actual person that's removing themselves.
I would agree with that. And I also think there should be a provision that whatever they're signing be notarized.
Okay. Well, look, I appreciate your time. Thank you. Thank you, Mr. Chairman.
I'll ask the sponsor panel this question as well, but in terms of suicide by a firearm, I would assume most of them are done with regulated firearms, meaning handguns, not shotguns and rifles. I mean, it's just seems like that would be the case. I don't, if anyone has that number, I mean, I think that's why that was probably curtailed that way, but if anyone has that information, that would be helpful.
I don't have any, sir, but I could look and try and get it to you offline.
For sure. Thanks. Okay, further questions from the committee? All right, thank you both very much. With that, that'll conclude the hearing for Senate Bill 752. We'll now move on to Senator Heddleman with Senate Bill 755.
Thank you, Mr. Chairman. Members of the committee, for the record, I'm Shelley Heddleman from District 11 in Baltimore County, and I am here to present Senate Bill 755. This bill will create a Maryland Department of an Office of Domestic Terrorism. As the bill is currently constructed, it would be placed in the Maryland Department of Emergency Management. We have had some discussions with them and the Office of Homeland Security, and would like to continue those discussions with the executive branch to find a home. I'll give you a little bit of context. You've heard this bill before. And in fact, back a few years ago, this committee created a task force that had some responsibilities for reporting out and making recommendations about domestic terrorism. And a couple of the recommendations is we wanted to maximize the assets that we already have in our communities. For example, in our colleges and universities, we have the University of Maryland that has done quite a lot of work and has a center on studying violent extremism. And we want to raise awareness among the public about violent extremism, especially with regard to hate crimes and domestic terrorism. This is an issue that has only, it seems, grown. And we just believe it deserves highlighting and it deserves attention and really coordinated responses. So if with the committee's indulgence, we would like to continue those conversations with the administration. And I think we're all on the same page in terms of supporting the implementation of the task force's recommendations and the increased threats that domestic terrorism poses to our communities. So without further ado, I will turn it over to my panel, one here and one virtual. Thank you.
Thank you. My name is Howard Libet. I'm Executive Director of the Baltimore Jewish Council. And I served for 2 years on the task force that you all as General Assembly created to look at this issue and come up with recommendations. I'm not going to repeat what Senator Heddleman said, other than to just emphasize we are in conversations with the executive branch. This might be done through executive order. If we can all agree, we think, and they agree, there needs to be some more explicit implementation of the recommendations from this 2-year task force. You heard this bill last year. It is not a criticism of the existing work that is going on. It is just a recognition of the growing urgency of the issue. October 7th and some of the fallout from that only increased it, but many other incidents do. And the number of high profile targets we quite frankly have in our state that could be targets of domestic terrorism, everything from the port to LNG facilities to just the high number of federal officials that we know live in our Washington suburbs. And it's something we ought to think about more explicitly and ensure that all of the resources we have in our state are coordinated. Thank you.
All right, we'll turn to Miss Weisel, you're up. Good to see you.
Thank you, Senator, Chairman of the committee and members of the committee. I'm not going to repeat everything that Senator Heddleman and Howard have said. I'm just going to add a little bit more context to this. So we have had this discussion for a couple of years, not just last year, just about the risk and the threats that we're seeing continuing with domestic terrorism, which is why we had the task force that I also had the privilege of sitting on. The three main items, and that's where I think it's important to understand of the task force that came out specifically. One was creating an Office of Domestic Terrorism, specifically a permanent coordinating office that would be equipped with financial and personnel resources to look at a multidisciplinary and multi-sectoral task force to look at this issue, specifically also taking into account violent extremism and then an approach to violence prevention and how to look at aspects between the private sector, the public sector, the work that government is doing, our local governments, better communication, and also looking into what our academics are doing. And as has been noted, University of Maryland and individuals there really have been doing a tremendous amount of work on this that is noted nationwide. And so I really think it's important that we continue the conversations with the Governor's Office of Homeland Security and get them to strongly commit to making sure members of this task force are continually brought together to monitor, to look at the trends that we are seeing, and to be quite honestly, just implement best practices to combat the extremism that we're continuing to see increase in Maryland and nationwide. And we really thank Senator Hedelman for championing this the past few years. And we ask for either a favorable report or allow us to continue this conversation. Thank you.
All right, thank you very much. All right, questions, Senator Folden.
First, Senator Hedelman. Senator, I just wanted to thank you for bringing the bill forward. I think it's a really good bill. And I think that when we're talking about the domestic terrorism, the preparation, prevention, and even going beyond that for the strategies for recovery, it's a really good bill. I know that like even where I'm at, we're talking about with the Joint Strategic Operations Command Center and having that established and having some of these same components as a part of that nexus is really important. So without any further ado, I'll just say, isn't that so? But thank you.
Thank you very much, sir.
Thank you, Mr. Chair. My questions maybe are a little tougher. So, first of all, will this office use its own definition of domestic terrorism, or will it use the one that's currently in the federal code?
We don't spell that out. I think it would be incumbent upon the group to make that decision.
Okay, I'm interested in your decision to, at the moment, at least in the bill, put this office in the Department of Emergency Management as opposed to the Governor's Office of Homeland Security.
Right.
Why did you make that decision? And is that a final decision or is
No.
it still up in the air?
So I said at the beginning that we believe it should probably be in the Governor's Office of Homeland Security. So
Okay.
we originally, MDEMS had staffed the task force, and in discussion with them, we've come to a new understanding.
Okay. Thirdly, I noticed that the fiscal note indicates that this bill is going to cost over $250,000 in each of the next 5 years and presumably in the out years as well, because the cost increases from year to year. So what, for that kind of money, what would a Maryland Office of Domestic Terrorism do that the federal office is not doing for the state of Maryland?
Well, I think, again, it is highlighting what's happening here on the ground, and it's bringing together our law enforcement, academic, other assets in the community, in state, and it's to coordinate among the federal, state, and local authorities. As far as fiscal note goes, I think that if in our discussions, I think that would come down quite substantially if we have the goals articulated in this legislation incorporated into pretty tangible goals in the governor's office. So I think that would come down quite a bit.
Okay, lastly, are there any specific areas in which you feel the Federal Office of Domestic Terrorism is not doing the job in Maryland that it should be doing, that this office would take the place of?
Again, I don't want to cast aspersions on our hardworking public officials who are at any level who are already doing this. I think people do have a tendency to stay in their silos, and this is meant to break some of those silos down and provide further coordination and focus.
Great. Thank you for your answers.
Thank you.
And good afternoon. This is for Mr. Libet. You had mentioned October 7th in your testimony, and I know we've seen some demonstrations down here for people who were, for lack of a better term, pro-Palestinian. Throughout the whole conversation and discussion, some of my colleagues have made comments on behalf of Israel. Others have made comments on behalf of Palestine. A number of us have said nothing, because it seemed that no matter what you said, you were going to cause some sort of issue. So I'm wondering, because I think when we've heard comments coming from both sides, whether it was people who are pro-Palestinian, I'm using those terms just because it's easy.
I understand, sure.
Pro-Palestinian, that some who are pro-Israeli would deem to be anti-Semitic and hateful. And I've had people within my district or constituents within my district who were upset with me because I said nothing. And I'm like, what am I to say? I'm a state legislator. But you've had people who are pro-Israeli who have made comments that people who are pro-Palestinian thought were hateful. How does that square with what's going on with the legislation in terms of the hate crimes?
So I think when we're talking about comments or language, that is separate and distinct from actions. This is looking at actions. I mean, we get alerts of reports of threats against Jewish institutions. I think there are also reports of that may be threats against mosques or other places, and that is the kind we're worried about actions. There are separate entities that deal with anti-Semitic or anti-Muslim language and separate protections there. And yes, sometimes that language can be a sign that we need to be aware of a particular organization, but clearly we're worried about threats to human life that might create that might feed into extremism and extremist behavior, whether it's for younger people. You know, we've had threats in our schools of threatening to hurt a particular people on social media. That borders into it and is a concern to all of us, particularly those of us with parents in the schools.
Thank you. I appreciate that.
Thank you, Senator.
All right, further questions from the committee? Seeing none, that'll conclude the hearing for the testimony for the proponents of the bill. We have one person signed up in opposition, but they are not here. But I'll call the name anyway. Vince McAvoy. Actually going to make an in-person appearance this time. Yeah, well, not here though, so. All right. So no joy on that one, but all right. All right. So with that, thank you very much, Senator Hedelman, and Mr. Lewitt and Ms. Weidel. That'll conclude the hearing for Senate Bill 755. We'll now move on to Senator Hedelman with Senate Bill 753.
Thank you. If I could call up my panel, please. Good afternoon. For the record, I'm Shelley Hedelman, Senator from District 11 in Baltimore County, and I'm here today to present Senate Bill 753. Thousands of Marylanders, as we all know too well, experience intimate partner violence. And when we do, we trust our law enforcement to protect and our judicial system to protect us from abusers. Many survivors of abuse petition the court for protection from abuse and are granted a civil protection order, where a court may also require an abuser to relinquish their firearm. Unfortunately, right now, we don't have a process where law enforcement can notify a victim when a prohibited person attempts to legally purchase a firearm. When I first started looking at this issue, I was like, how many people who are prohibited from buying firearms actually attempt to purchase them legally? And what I discovered was many, many people do this. This bill would require the Maryland State Police to notify the Maryland State Police Gun Center and subsequently local law enforcement and survivors when an abuser attempts to purchase a gun and is denied by our state background check system. Firearm background checks are a critical step in preventing crime and protecting communities. And you'll hear some statistics, so I'm not going to go through them now, from folks who are involved in this kind of work on a daily, hourly basis. Just think of the violence that could be prevented if a survivor could do appropriate safety planning after having knowledge that an abuser was seeking a firearm. We, as you know, in this committee, are a partial point of contact state. Maryland operates some firearm background checks, while the federal system, NICS, operates others. When a prohibited person attempts to legally purchase a firearm, 5,000 times in Maryland over the past 3 years, the FBI notifies local law enforcement who can then investigate. NICS has denied more than 71,000 sales to abusers subject to domestic violence restraining orders and 178,000 sales to domestic abusers convicted of misdemeanor crimes. Unfortunately, a similar system is not set up for state-regulated firearms. As this legislation would promote this communication among state and local law enforcement, the Maryland State Gun Center, the FBI, and federal law enforcement agencies when a prospective purchaser failed a background check, and it sets up these systems for notification. This is an issue that is already being addressed in many other parts of the country, and the federal government passed the Violence Against Women Act reauthorization in 2022, requiring that NICS notify state and local or tribal law enforcement of rejected background checks within 24 hours. And unfortunately, Maryland conducts some of our own background checks, but all rejections do not get communicated to local authorities. We have a number of amendments and we're working to fine tune them with the state police and others to work out some of the logistics of this system, but we really believe that it has the capacity to save lives. We have to do our best to protect survivors of intimate partner violence, and in many instances, time is of the essence. I'm going to turn this over to my panel now, and people that we've brought up can share their personal experiences as well as professional. So I thank you for the opportunity to present the bill.
Chairman Smith and Senate members, my name is Shelley Rose Magrabi, and I am a resident of District 40 in Baltimore City. 56 years ago, my mother and her family, Lebanese Jews, fled Beirut with nothing but the clothes on their backs and one small bag per person. They escaped to the United States in search of a better life. I never imagined 56 years later, right here in Maryland, that I too would find myself hurriedly packing a bag, fleeing my home with nothing but the clothes on my back and one small carry-on bag, and boarding an aircraft bound for out of state because I too feared for my safety. That won't happen to me, I said. I'm not of that race, ethnicity, nationality, religion, sexual orientation, or socioeconomic status, nor do I have that disability, and so I did not speak out. It'll never happen to me, I said, until it was in my face, had me backed into a corner, and was spewing vitriol at me. It'll never happen to me, I said, until I found myself on the phone with a domestic violence hotline. It'll never happen to me, I said, until I watched him get arrested for improper registration and transportation of his personal gun, and subsequently get bailed out with no consequences for his actions. I sat at the provost marshal's office, frozen in horror. How are victims to feel safe when the threat of intimidation and violence still exists? The federal requirement to notify local law enforcement when a prohibited person attempts to purchase a firearm and fails the background check fails to protect victims of violence of their abusers' potential intentions, making this bill a crucial legislative priority as people experiencing abuse turn to agencies for support, guidance, and resources, and to better understand their rights. Even testifying here today, I am potentially jeopardizing my own safety and risking potential legal and financial implications. Yet, if not for me, then who? I shouldn't still feel afraid to speak. I did not speak up, and when violence quietly whispered its way into my own home and wrapped what felt like an invisible chokehold around my neck, I felt hauntingly alone. So today, I'm speaking out and asking you to please prioritize this legislation. Domestic violence doesn't discriminate against anyone. Together, we can empower victims and stop this deadly cycle. Thank you.
Good afternoon, Mr. Chair, members of the committee. Melanie Shapiro. I'm the Public Policy Director with the Maryland Network Against Domestic Violence, here in support of Senate Bill 753. I'd like to thank Senator Hedelman for her leadership on this issue. I want to be clear about what the bill does and what it does not do. It does not change who is a prohibited person. It does not change the background check process. It does not change any of the laws related to the unlawful acquisition of a firearm. What it does do is ensures that a victim of domestic violence who holds a final order of protection or a victim who has had a final order of protection that was subsequently violated, made aware that their abuser is trying to lawfully purchase a gun. The presence of a firearm in domestic violence increases the risk of lethality by 500%. Many of the states, as Senator Hedelman discussed, there are partial point of contact states, there are full point of contact states, and then there are states that rely fully on the federal government through FBI and NICS to do the background checks. Maryland falls into the smallest category, those of partial point of contact. So in the Violence Against Women Act reauthorization in 2022, there was a bipartisan bill that was incorporated into that says that if a prohibited person tries to lawfully purchase a gun and is denied, then we're going to tell local law enforcement. There is not comparable legislation in Maryland that relates to the state background check process, which is done by the Maryland State Police. We would like those processes, to the extent possible, to be parallel to one another and ensure that whether there's a federal denial or if there is a state denial, that the victim who holds a final order of protection is made aware that there was this attempted lawful purchase of a firearm. And why? So that they can protect themselves. They may be having exchanging a child for parenting time just the next day, and that person might have attempted to purchase a firearm. And in order to safety plan for themselves and in order to make those necessary steps to intervene for their own safety, this information is crucial. So we urge a favorable report on Senate Bill 753.
Good afternoon, Chair and members of the committee. My name is Spencer Cantrell, and I'm a Senior Advisor for Implementation at the Johns Hopkins Center for Gun Violence Solutions, and here today in enthusiastic support of Senate Bill 753 and urging a favorable report on the legislation. Like the Senator and my colleagues have said, if a respondent in a final protective order attempts to purchase a firearm from a licensed firearms dealer, then this bill would require the firearms dealer to report the attempted purchase to the state police, who would then be required to transmit that information to local law enforcement and provide notice of the attempted purchase to the victim in the protection order. The notice would occur using the VINE system, which automatically notifies victims through email and telephone alerts they can enroll in. Many victims and survivors of domestic violence are already otherwise enrolled in the VINE program, and this is a system that victim advocates are already quite familiar with. The bill works to close a critical implementation gap of notifying authorities when individuals are attempting to purchase firearms. By providing law enforcement and petitioners with this information, it allows for law enforcement to follow up with the respondent if needed to ensure compliance. More importantly, it gives the victim critical information and safety planning, since the respondent's attempt to purchase a firearm could be a signal of an escalation of violence. Notably, this bill does not create a new crime, but rather works to close an implementation gap by holding prohibited individuals accountable when they attempt to purchase a firearm. Echoing what others have said, research from my colleagues at Johns Hopkins has shown the clear risk presented by abusive partners having access to firearms. Women are 5 times more likely to be murdered by an abusive partner when they have access to a gun. The threat also puts the wider community at risk. Research shows that in 2/3 of mass shootings, the shooter either had killed family or partners as a part of the shooting or had a history of domestic violence. Notifying victims or petitioners is a key part of safety planning. Prior to my role at Johns Hopkins, I worked directly with survivors, and I would have wanted to have this information and working with my clients so that they could respond and take steps to make themselves safe. In my role as Senior Advisor for Implementation, I work with jurisdictions around the country around effective implementation, and this is a key part of implementation work to notify those involved. Accordingly, I request a favorable committee report on Senate Bill 753. Thank you.
Good afternoon, Chair Smith, members of the Judicial Proceedings Committee. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I'm also the co-chair of the Maryland State's Attorneys Association Subcommittee for Special Victims Issues. On behalf of the MSAA and my office, I'm here to testify in favor of SB 753. The Solicitor General of the United States recently observed during oral argument in a case about firearms and protective orders that, quote, all too often, the only difference between a battered woman and a dead woman is the presence of a gun. In Maryland, in 2022, 35 adults and 5 children were victims of domestic violence homicide. An additional 16 people were killed as a result of domestic violence, including abusive partners. 75% of these deaths were caused by a gun. It is important to make sure that when a respondent tries to obtain a firearm, we notify both local law enforcement and the individual who obtained the protective order. Senate Bill 753 accomplishes that purpose. As was noted, Senate Bill 753 requires notification. That's it. And only if a respondent has an active protective order against them and they try to illegally get a firearm. Percentage-wise, the weapon of choice in the vast majority of domestic violence homicides in Maryland. Firearms and domestic violence are a deadly combination. Senate Bill 753 makes sense, and I urge a favorable report. Thank you.
Good afternoon, Karen Herron, Executive Director of Marylanders to Prevent Gun Violence, here in support of SB 752 to provide for better notification of law enforcement and victims of interpersonal violence when a relevant prohibited person fails a background check while attempting to purchase a firearm. In the current process of purchasing firearms in Maryland, potential buyers must complete a federal form, which will lead to a background check under the National Instant Criminal Background Check System, or NICS, or a Maryland form, which will be followed by a background check by the Maryland State Police. If a person fails the background check, the dealer may not proceed with the sale, but law enforcement is currently only notified when under the NICS system. And in neither NICS nor the state system are victims notified that their abuser is attempting to acquire a gun, leaving them uninformed and vulnerable. This legislation would close those gaps and provide both local law enforcement and victims with critical information that will allow them to make informed decisions about their priorities and, in victims' cases, their safety. Intimate partner violence and gun violence are deeply intertwined, affecting countless women, families, and communities nationwide. Firearms escalate danger in abusive situations, making victims 5 times more likely to be killed by their abusers. It only makes sense that we create structures that ensure that when we know a high-risk individual is attempting to secure a firearm, that we inform those that are most at risk, victims and law enforcement, of that escalating threat. MPGV urges a favorable report on SB 753. Thank you.
All right, thank you very much. We have one more guest joining us for the sponsor panel virtually. Ms. Bickoff, you're up. Welcome.
Thank you, Mr. Chairman and members of the committee. My name is Alicia Bickoff, and I'm the Deputy Director of HANA, an agency of the Associated Jewish Community Federation of Baltimore. I'm testifying in favor of SB 753. HANA is a domestic violence, sexual abuse, and elder abuse agency that serves the citizens of Baltimore County and City. HANA provides safety planning, emotional counseling, shelter, and legal advocacy. We also collaborate with the Baltimore City Police Department to respond to all lethality assessments in the Northwest Precinct. One of HANA's core services is safety planning. Safety planning is a highly customized and ever-evolving process between the advocate and the victim. It relies on the unique circumstances, risks, and experiences of the victim to create a plan to mitigate harm. It is constantly being practiced, adjusted, and refined based on the information that is available to both the victim and the advocate. If a victim were to learn that their abusive partner had filed for a gun license, that critical information would be immediately incorporated into their safety plan. It would show that their abusive partner lacks concern with violating the terms of their protective order. It would be an indication of escalation and growing risk of lethality, as you've heard, the presence of a firearm makes it 5 times more likely that a woman will die at the hands of a domestic abuser. The victim may choose to move their custody exchanges to a police station or a supervised visitation center rather than a store parking lot. They may decide to notify an employer or a school so that they can call the police if the abuser is on the premises. They may restart safety practices that they had retired, such as packing a safety bag in case they need to flee rapidly, changing driving routes, or even relocating permanently. Without accurate current information, a victim cannot proactively keep themselves safe. For the state to have this information and not share it with the victim would be to tie that victim's hands and put them in more harm unnecessarily. We ask you to support this bill so that our clients can receive the full information that they need to protect themselves and plan for their safety. Thank you.
All right, that'll conclude the testimony for the sponsor panel. Questions from the committee. Senator West.
Thank you, Mr. Chair. Once again, for the sponsor, if she could stand up. So once again, I'm trying to figure what the cost of this will be compared to the benefits. The fiscal note suggests the cost in the first year would be over $650,000 for this system. And then I'm trying to take a look and see what problem we're trying to solve. In your testimony, you state that 5,000 times in Maryland over the past 3 years, a prohibited person has tried to legally purchase a firearm. So that works out to over 1,800 times a year. On the other hand, 2A Maryland, which is opposing the bill, indicates that in 2023, a total of 24,892 final protective orders were issued, nearly 25,000 final protective orders. But in only 23 cases were there attempts to purchase a firearm by persons subject to a final protective order. So the disparity in these numbers is pretty striking. Do you have an explanation?
Yes. So the first number you mentioned are the federally regulated firearms. Those are the long guns, right? And the NICS system, and they are tracking them. The second number you mentioned are the state regulated firearms. That's the difference.
Okay, and your bill would apply to both the federally
Yes.
regulated and the
Yes.
state regulated?
Yes,
firearms?
and to be clear, we have some amendments too to clarify that the bill as constructed right now goes beyond just protection orders. We would narrow it further to limit it to protection orders, violations of protection orders.
Okay,
So I think that fiscal note will come down, but it's also a one-time cost to do some technological changes so that the state police database that they're already in the middle of constructing can be tweaked to accommodate what we're trying to do here.
okay. Thank you for your answers.
Thank you.
Thank you very much, Senator. Additional questions? All right, seeing none, thank you all very much.
Thank you.
Is Miss Diana Beeson here? Welcome.
Good afternoon. Mr. Chair, members of the committee, my name is Diana Beeson, and I currently have the pleasure of serving as the Engagement and Policy Initiatives Manager for Turnaround. Turnaround is the designated rape crisis center for Baltimore City and Baltimore County and a comprehensive domestic violence center. Crisis response, safety planning, victim-centered advocacy, legal referrals, trauma therapy, and community education are core components of the agency's work. Turnaround is the designated regional navigator for Baltimore County and Howard County, providing services to human trafficking survivors. Turnaround is a member of the Maryland Coalition Against Sexual Assault and the Maryland Network Against Domestic Violence and the Maryland Human Trafficking Task Force. Turnaround respectfully requests a favorable report on Senate Bill 753, requiring a law enforcement agency that receives a report of a prohibited person failing a background check to immediately notify certain victims could quite literally be a matter of life and death. Intimate partner violence perpetrators who have access to firearms also have the ability to use those firearms against their partners. Firearms coupled with intimate partner violence creates an incredibly dangerous situation. In violent relationships where one partner has access to a firearm, there is a 500% increased risk of death. Over 1/2 of intimate partner homicides are committed using firearms. Over the past 5 months, Turnaround has enrolled 301 new clients. When asked, does your abuser have or can they easily access a gun? 42% responded yes. Knowledge is power. Survivors have the right to know if the person who victimized them has attempted to obtain a firearm and failed the background check. Turnaround appreciates the thoughtfulness of this legislation and requests a favorable report. Thank you.
Excellent. All right, thank you very much. That'll conclude the testimony for the proponents of the bill. We'll now switch to information, and that's Mr. Hamill. Russell Hamill coming up. Welcome.
Good afternoon, Chair Smith and the committee. Russ Hamill here representing the Maryland Chiefs and Sheriffs Associations. We're providing a letter of information to this committee regarding this Senate Bill 753. We've been working with, as Senator Hedelman mentioned, we've been working with the sponsor to try to work through some logistical issues, as we too want to protect these victims from being victimized again, keep them as safe as possible. This bill would establish a process whereby a victim who holds a final protective order is notified by law enforcement if the individual who is subject to the final protective order is denied from purchasing a firearm because of a background check. The Department of State Police Licensing Division processes all firearm purchase or transfer applications. Under current law, when an applicant's firearm purchase application is denied, The applicant and the dealer are both notified, and all those denials are referred to the gun center for criminal investigation. Upon completion of that investigation, if further action is warranted, the case is sent to the Firearms Investigation Unit. 753 would require the gun center to notify the local law enforcement agencies in the address and zip code of the dealer and the person that's prohibited within 24 hours by the licensing division. This notice includes personal identifying information as well as criminal record information, and the legislation does not guide as to what the local police agency is supposed to do with the information once received. Additionally, civil liability is created if the notice is not performed timely or the local agencies fail to provide notice to the victim as defined in the bill. I know advocates anticipate the Vine system being used to provide notification. However, that is a publicly accessible system and does not interact with the gun center's application and licensing system. Further complicating this matter is MSP and local law enforcement agencies use encryption programs for their secure communications that Vine does not use. Lastly, MSP does not maintain encryption programs to comply with each other agency's requirement. To comply with the requirements of 753, MSP will have to develop an automatic notice upon denial, so the gun center and local law enforcement agencies are informed in an accurate and timely manner. The sheriffs, the chiefs, and MSP want to work with the sponsor on further amendments to get this across the line, and thank you all for your time today.
Thank you very much. Questions on the committee? So the statute, I think it was your testimony or which else? What testimony was that? Was MSP mentions that you're prohibited from sharing some of that information. And I'm wondering what the genesis of that statute was. It predates my time here.
I don't know, sir. I'm sorry. I can find out for you.
Okay.
Would you prefer?
I mean, I've an inclination, but I'd love to hear the kind of the legislative history behind that. But okay, thank you very much.
Thank you.
All right, we'll hear from the opposition panel. Is Mr. Jocelyn here?
Good afternoon, Mr. Chairman, members of the committee. John Jocelyn, speaking for 2A Maryland, in opposition to Senate Bill 753 as it's written. Our objections are procedural. The bill provides that if a licensee does not sell or transfer a regulated firearm, they are then required to notify the Maryland State Gun Center of the identity of the prospective purchaser, lessee, or transferee, the date and time of the denial, the location where the purchaser, lessee obtained the firearm, and the reason for the denial. They don't receive this information. They are told the person is denied. So they don't have the information they're being required to provide, nor do they have access to the Maryland Gun Center because it is a law enforcement only facility. They cannot comply with this bill as written. In terms of sharing information, there are concerns that it may violate General Provisions Article 4-325. I would point out to you that while we do understand the severity of this problem, those of you who have been here for a while know that for decades, we testified in support of having domestic violence protective orders as a good and substantial reason for the victim to obtain a wear and carry permit. Every time the bill failed, no action was taken. So we find it interesting that now it's important. Now on some numbers. The numbers that I have in my testimony, the written testimony, are for Maryland, and they are for the data only for Maryland. I did not confuse it with any of the federal numbers because this is a Maryland bill. The number is 24,982 protective orders that were final orders that were issued. According to the Maryland State Police Licensing Division, there were 23 denials in 2023. And for that, the cost is $651,000. We find that this is an interesting idea. We see some impediments to carrying it out, and we believe that there are some procedural things that must be addressed, and we ask for an unfavorable report on this bill as currently written. Thank you.
Thank you very much, Mr. Jocelyn. Questions
Thanks.
from the committee? Senator James.
Thank everybody for their testimony. I learned a lot. One question, I didn't quite understand the point you were making about the good and substantial reason for wear and carry. Of course, Bruin has changed that. And the reason I'm not sure I understand the comment is I can imagine that certainly some women would want that. Other women may not want to be anywhere near a gun. but they would still like the ability to have notice, take action to protect themselves, reach out to people. So I'm not sure I understand what your point was.
It's important enough now that we notify them. And certainly knowledge is power. I agree with you on that
Okay.
point, 100%.
Okay.
And I agree that some women would never want to own a firearm. I understand that, their choice.
Right.
The problem is, how do we get there from here? And what we have is a system that's being asked for that puts a burden on the licensee to provide information he never receives and has no way to deliver. And there's also a passage in the bill that
I understood all
protects
that.
law enforcement, but not the dealer.
Your other technical objections are well noted and shared by even law enforcement. So obviously the sponsor and others will have to work out the amendments. I just literally did not understand how you connected the wear and carry position you had for women with the idea that it somehow contradicts support of this bill.
Oh, there's no contradiction.
All right,
There's no
that's all I need.
contradiction whatsoever.
Very good.
It's a point of knowledge is power, but you also have to have the ability to go with that knowledge.
Very good. I now understand. Thank you.
All right, seeing no further questions, thank you very much. With that, that'll conclude the hearing for Senate Bill 753. We'll now move on to Senator Hedelman with Senate Bill 949.
I promise this is the last one from me. I think it's the last one
Senator
for the
Gentleman
whole.
Day.
It's almost like you're a member here again.
Yeah.
You're always welcome back.
Thank you,
Roving
Mr.
senator.
Chairman.
Mm.
I think this might be the last bill of mine that you will hear for this session.
Oh,
So,
I think it'll be for the term.
thank you very much. My name is Shelley Hedelman, for the record, Senator from District 11 in Baltimore County, and I am happy to be here today before JPR presenting Senate Bill 949. In 2017, the General Assembly, with this body's help, enabled the creation of the Sexual Assault Evidence Kit Funding and Policy Committee. We call that the SAKE Committee in the Office of the Attorney General. Assistant Attorneys General, states attorneys, forensic nurse examiners, law enforcement personnel, hospital representatives, and I and other legislators serve on the SAKE. It has a broad policy mandate to develop best practices related to the preservation and testing of sexual assault forensic exams, safe kits, access and support of forensic nurse examiners, providing services, including information, mental health, legal support, and preventive medication to survivors. Just last year, this committee, in a bill that I presented to you, considered Senate Bill 789, and it passed, and it requested, among many other things, that the SAKE, with input from the Consumer Protection Division of the Attorney General's Office, make recommendations about the provision of do-it-yourself rape kits. And I hadn't even heard of these until about a year and a half ago. After many, many months of very thoughtful consideration and discussion, the AG's office issued a report in early February, just a few weeks ago, that recommended three things: that the state ban the sale, offer for sale, or distribution of self-administered sexual assault kits in the state unless they're state issued, that any person who sells, offers for sale, or distributes non-state issue kits should be subject to an enforcement action by the Consumer Protection Division or a civil fine, and that kits should not be excluded from use in a criminal prosecution if they are brought to law enforcement or prosecutors by a victim. We have significant concerns over whether any evidence collected via the kit would be admissible in a court of law, whether they provide survivors with a false sense of hope of accountability, and whether the genetic material that they have collected would have any privacy protections. And finally, whether survivors would receive the support and medical care so desperately needed after trauma. Hospitals right now, and you'll hear from some of the panelists who do this work, provide safe exams by very highly trained forensic nurse examiners for free. There is no cost to the survivor, and the hospital is reimbursed by the Criminal Injuries Compensation Board. At each step in the process, a survivor has the autonomy and self-direction to proceed or stop as they determine. They also decide whether they want to call in law enforcement, and there are a very careful chains of custody that are followed to ensure that evidence is handled properly. Under the bill, survivors will still be permitted to present evidence obtained by these kits in court if someone was to obtain a kit from somewhere out of state, for example, but it would be up to the discretion of law enforcement and the prosecutors as to whether or not it was permissible. There is no guarantee that evidence would be admitted. And there has not been a single case in the 5-year existence of any company selling this product in which a kit has been successfully used in court. In fact, the company would need to use a laboratory for the testing of kits that has a detailed agreement with our state in order for it to be accepted in Maryland, which to my knowledge, they don't have. Attorneys general from 8 states across the country, including Maryland, have issued cease and desist letters or warning letters attempting to halt the sale of these kits. Washington and New Hampshire have already banned the sale of this product as this bill proposes. We agree, and you'll hear from the opponents, that it can be extremely challenging for sexual assault survivors to get the help they need. That is why we have worked, and you all, along with us, have worked tirelessly to expand access to services for sexual assault survivors. This year, we have another bill that is going to another committee to expand access to telehealth so that survivors who might go to a hospital where they don't have those very highly trained forensic nurse examiners would not be turned away, and they would still be able to get the help they need via telehealth. We are in complete alignment with the intent to increase access to evidence collection for sexual assault survivors. Unfortunately, these kits do not accomplish that goal. Survivors may put their faith in this product, collecting evidence and showering instead of going to the hospital, making permissible evidence nearly impossible to recollect. Instead of offering survivors false hope and potentially re-traumatizing them by ruining any sort of criminal case, there are other ways that we can support survivors in their sexual assault cases. The risks of these do-it-yourself cases far outweigh their benefits. We continue to search for new ways to better support sexual assault survivors, but these products do not serve that purpose. And I respectfully ask for your support of Senate Bill 949. Thank you very much.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. My name is Carissa Hatfield, and I am an Assistant Attorney General and counsel to the Sexual Assault Evidence Kit Policy and Funding Committee. As Senator Hedelman referred, we shortened to the state committee just to save everyone the headache. In 2023, the legislature, as acknowledged by the senator, gave us the opportunity to explore the future of these kits in Maryland. And if you take nothing away from my testimony today or the testimony of my colleagues, please understand this. We took every opportunity to try to find a way for these kits to work in Maryland and for these kits to work for Marylanders. And it just did not happen. It was not possible. You will hear from the folks on this panel about the committee's concerns regarding these kits from folks who are much greater experts than I. What I want to talk to you about today is basically the history of these kits. As acknowledged, they started in 2019 as Me Too kits. They were immediately issued cease and desist letters or warning letters from 8 states. And then they were ultimately banned in 2 states prior to this legislation. These attorneys general and the legislators in these states had the same concerns that we do. Basically, that we are giving survivors false hope, that we are leading them to believe that something that could work for them will actually work for them. And that is not what these kits can actually provide. What will help a survivor is going to a qualified healthcare professional and receiving the care that they need. As Senator Hedelman said, we are constantly exploring options as to how to better help survivors in our state. To that end, we do have SB 950, which will be heard in finance next week. And we look forward to that hearing, and we look forward to continuing to innovate for survivors. Thank you very much for your time, and I urge a favorable report on SB 950. Thank you, 949. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Jessica Bowles. I'm a nurse practitioner and serve as the clinical director of the Forensic Medical Unit at Adventist Healthcare Shady Grove Medical Center. I'm also a member of the Maryland SAPE Committee. The Forensic Medical Unit at Adventist Healthcare Shady Grove Medical Center provides sexual assault medical forensic exams for people of all ages. In 2023 alone, the program performed more than 200 of these exams. I'm here today in support of Senate Bill 949 with amendments. In Maryland, sexual assault forensic exams, or SAFEs, are provided by licensed forensic nurse examiners, or FNEs. These FNEs provide medical care to patients who have been sexually assaulted. Examples of this care include taking a detailed history to guide the physical examination, providing medical interventions like STI and HIV counseling, and administration of preventative medications. Emergency contraception to prevent pregnancy, wound care, medical forensic photography of bruising, injury, and genital trauma, and collection of biological and toxicologic evidence from the living victim. Legislative changes in recent years have allowed programs like the one I serve to provide access to this care for patients, Marylanders or not, in our state for 15 days, an evidence-based and progressive timeframe that we should be proud of. Some programs, including the one I serve, have access to follow-up care for up to 90 days after the assault and are actively implementing and researching methods to increase options for accessing care and improving options for our patients that increase informed decision-making in our state. Another example of the progress that's being made to expand access to SAFE exams. Maryland FNEs are dedicated to providing these exams in a trauma-informed way that preserves autonomy of our patient population. Patients are allowed to participate, decline, or withdraw consent at any time during the exam and are not required to report to the police unless meeting well-established mandatory reporting requirements. For these reasons, I ask you for a favorable report on Senate Bill 949 with amendments.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of Senate Bill 949 with the sponsor amendments. So look, Maryland has a serious problem. People who have been raped and sexually assaulted face unacceptable barriers to access to rape exams. We don't have enough forensic nurses. Survivors are expected only to go to particular hospitals, and even those hospitals sometimes don't have someone available. So there is a serious gap in access to rape exams. But commercial do-it-yourself rape kits are not the solution to this problem. They're an attempt to have financial profit by misleading survivors, and they seek to take advantage of a malfunctioning system and use it for purposes of financial exploitation and gain. The one company that we've seen in Maryland cloaks itself in the language of survivor empowerment and says it's trauma informed while marketing a virtually useless product. Commercial kits have not been introduced in court. Unlike actual sexual assault forensic kits, they lack the integrity needed to be used in the CODIS system to help identify serial rapists. They don't fall under the HIPAA requirements, so there are risks to people's privacy, both for the survivor and for the alleged assailant. And purveyors compound these shortcomings with fine print and disclaimers that will protect the company from legal actions against them. Finally, let me say that these products are best analogized to like bed sheets or clothing that may have been exposed to bodily fluids. But this bill protects that usage. And that's been very important to MCASA. We do not want to be in a situation where we ban these kits and then there's some fluke where they can be useful and somehow we can't use them in court. So the bill has provisions that allow the introduction in court if necessary. In summary, these kits are an attempt to profit off of survivors using fear and misinformation. They create a false sense of hope that saving swabs somehow provides access to justice. So we urge a favorable report banning these kits. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. I'm Laura Jessic, the Sexual Assault Kit Initiative and Response Team Program Manager with the Maryland Coalition Against Sexual Assault. I'm here at the invitation of our director, Lisa Jordan. CASA is the Coalition of Rape Crisis Centers across the state of Maryland, and our office includes the Sexual Assault Legal Institute, where we provide direct representation to survivors of sexual assault in Maryland. We are here in support of Senate Bill 949 with the sponsor amendments. During a traumatic event like sexual assault, the brain and body respond in ways that are designed to increase physical safety and survival. This response is evolutionary and involuntary. Unfortunately, the response includes the shutting down of the prefrontal cortex, the part of the brain that is responsible for higher level thinking, planning, and decision-making. It is irresponsible for companies to expect survivors who have just experienced trauma to read 4.5 pages of fine print to understand that using a self-administered sexual assault evidence kit is not equivalent to receiving medical health care or healthcare advice. Per one company's user agreement, which states the company is not permitted to engage in the practice of medicine. This company's user agreement further states that survivors agree to defend, indemnify, and hold the company harmless against all losses, damages, or expenses, further noting that survivors understand that they are, quote, waiving their right to have claims heard in court, are prevented from participating as a plaintiff or as a class member in any proceedings, and requiring all claims to be resolved through binding arbitration. Survivors of sexual assault should not be expected to read these conditions and understand these implications after a traumatic event. Further, survivors should not be expected to not only waive their rights, but defend the company preying on their trauma. It's important for the state of Maryland to prioritize options for medical forensic care and seek to fill the gap in access to services with proven solutions that ensure survivors are informed while still empowering choice. For these reasons, CASA urges you to report favorably on Senate Bill 949.
Excellent. Thank you very much. We have we're just going to take questions. It's the end of this first panel. We'll take questions and then we'll bring up the next folks. All right, excellent. Senator Kelly has a question and then Senator James has a question.
Thank you so much, Mr. Chairman. I have a question, I think for Ms. Hatfield would be best. And then a quick question after that for the sponsor that'll be super quick. Okay, so Ms. Hatfield, thank you so much for the work that you do. I wanted to know, it's sort of a two-part question, what factors the committee used when making the decision to recommend banning the kits? And then also sort of the flip side of that, which is we have heard, and this was addressed a little bit, that there's gaps in accessing sexual assault forensic exams. So what are other things that we're doing to address that?
Sure. Thank you so much for your question, Senator Kelly. So firstly, the committee considered a multitude of factors when thinking about what to recommend ultimately to the legislature regarding these kits. We considered whether these kits are admissible in a court of law. Have these kits ever been admitted in a court of law, and whether we believe that those kits would be maintained within a proper chain of custody. The answer to all of those questions was no. We consulted both with state's attorneys, as you will hear, and law enforcement regarding their opinion on those issues. We have representation on the committee from both, and the answer was a resounding no. We additionally considered whether these kits would be admissible into CODIS, which is the Combined DNA Index System, either on a federal or state level. We spoke with our forensic experts on our committee, and again, that was a resounding no, without a great deal of conditions that would take an extended amount of time to take care of. We spoke with victim advocates and forensic nurses to determine whether we believed that these kits provided sufficient medical care in the aftermath of a sexual assault. Again, the answer was no. As you heard from Ms. Jessic, these kits do not profess to have medical advice or medical care provided within the exams that they purport to provide. What we determined from these factors, in addition, we also spoke with our Consumer Protection Division to determine whether these kits had sufficient warnings to make survivors understand the implications of using them, or whether these kits met any standards that the state would have under the Consumer Protection Act, or whether they even met basic privacy standards under Maryland law and under the Maryland Consumer Protection Act. Once again, the answer was no. I think you're probably sensing there's a common theme here, and that's that we found that there wasn't a way for these kits to work in Maryland for survivors, at least not in a way that would be legally or in any way really effective for them. And we felt that ultimately that these kits promise more than they can deliver. And for that reason, those are the factors that we considered when we thought about whether or not to ban these kits. On the other hand, what we're doing for survivors, as mentioned, I think by a few folks here, we've introduced SB 950, which is House Bill 1127 on the other side. That is a peer-to-peer telehealth bill. What that bill will do will allow the committee to study the feasibility of peer-to-peer telehealth. For folks who are not familiar with this term, basically what this means is that a forensic nurse examiner in one location would be able to provide peer-to-peer consultation and mentorship to an RN or physician on the other end of either a telephone call or a teleconferencing software, and guide them through the exam with a survivor. This would allow for hospitals that are historically underserved or non-served to be able to provide care to individuals so that no one is turned away when they show up at a hospital and request services. Additionally, the committee has spent a very long time and will finally be launching in March a sexual assault evidence kit tracking system. This is a digital tracking system that will allow a sexual assault evidence kit to be fully tracked through a software system from point A all the way through to point Z. So that way it is fully tracked. A survivor can always find out where their kit is and what the status of their kit is at any given time. Additionally, we receive funding on an biannual basis to be able to assist with continued testing of sexual assault evidence kits. And we are continuing to do peer research in areas around things like providing sexual assault consultation with a physician with reimbursement by the sexual assault reimbursement unit without ever having to go to a hospital and submit to a forensic exam. And these are just some of the examples of things that we're doing. So we are constantly working to innovate and do something better for survivors. And we acknowledge the gap, but we also acknowledge that we're working to close that gap.
Excellent. Thank you so much for that thoughtful answer. I have a really quick question for the sponsor, if you don't mind. I'll ask it while you walk over because I think you'll have a quick answer. I was shocked but not shocked to go through my file here on this bill and see an opposition statement from Maryland Right to Life. I just wanted to ask you to make it clear because this is generally supporting sexual assault survivors, been a bipartisan issue in this committee. I want to make sure our friends on the other side of the pro-choice, pro-life conversation understand there's no secret abortion rights agenda here.
None whatsoever. I was pretty shocked to see that as well.
Excellent. So I think we have been seeing anything related to hospitals and reproductive health care gets this letter, but just to be clear, there's nothing that this bill does that will in any way expand abortion access.
Has nothing to do with it.
Great. Thank you so much.
Thank you.
It's more of just a Pavlovian response. Just you gotta issue that letter, get it out. All right, Senator James.
Thank you. And thank you, Senator, for bringing this important bill to us. I really appreciate it. I've just learned a lot. I had no idea this product or products exist. So bear that in mind when I ask you a few technical questions about the bill, about how it would work and whether it's the right approach. I guess the first thought I had was there are an awful lot of awful products out there. Some of them very seriously awful. And I'm a little worried that if we were to ban upfront their evidence, them being admitted to court, as opposed to the court going through the process, and I'm sure at this juncture find that these are incredible, scientifically reliable, etc. And the only reason I bring that up is allowing the court system to do it that way. Is that I don't know if in the future, but we may get advances. We used to have to go to the doctor and hospital, have a pregnancy test, right? Over the many years, we can now very reliably have them done at home, and it is helpful. So I don't know if, just banning this and then science and quality catches up. So all of a sudden we've done this rule that says you can never use a particular product in court. I'm not aware that we have done that in any other area, even though I'm all with you that it's an all product based on what you said. So that was my first question. I have two others. So thank you.
Thank you, Senator James. I really appreciate that question. I think it reflects very much some of the debate that we had.
Okay.
And so I do want to clarify that the bill does not say they're automatically banned in court. Because if you look on page 5 from lines 6 through 20, there are actually provisions. And like you, I was very concerned about this. We wanted to make sure that we're not in a situation like we are with the wiretap bills, where things are banned and then you can never use them in court. So this would allow the kids to be treated the same way we treat bed sheets, the same way we would treat, someone's intimate garments, something like that. The court would be able to look at this. I also really appreciate your question about pregnancy tests, but I think that the distinction is a really important one, is that the consumer of this is not someone who's looking to see if they are pregnant. The consumer of this is someone who was just very recently traumatized. And the pregnancy test, it was not a question of misleading people. The marketing for these kits are really deeply misleading, and they're taking advantage of people in a time when they're really traumatized. And so the analogy to pregnancy tests, it just doesn't
I only
work.
made the analogy. It wasn't for that. It was the analogy. It was simply there was a time when we did not have any product like it, and then maybe they weren't very reliable, and now they're incredible. So my only point was we could have an evolution in this area. So I don't know if if you wholesale ban it as opposed to what I think would be any attempt to have it introduced would be probably fail miserably, because it's not even going to come close to passing the kind of things that you need to pass to have evidence introduced.
Completely, except that what I would say again is I don't want to wait until we're in court trying to introduce these products because of the trauma. The other thing is that the bill actually does allow the state of Maryland to produce the kits themselves. And it was exactly for the reasons that you're raising, that perhaps 5 years from now, 10 years from now, the kits will be in a place where we could do some portion of it at home. So it has that kind of safety valve built into the legislation today. And I would also just say that we've both been here for a number of years, and I suspect that the General Assembly will continue to operate long after we're gone. So if things change, I think that we would be able to bring it.
I'll
back
read
to
it
this
that
body.
those lines on 5. It does say to me, and I'm sure I don't understand you don't have to answer this, but there is this reference to 14-4602. But if not knowing what that says, it does say it's not admissible. And I'll have to read that to see how that works. And unless there's an amendment. And actually the bill summary says that as well. The other
But I'm sorry, Senator.
No,
I don't want to leave the committee.
Ms. Jordan, I also want to, I know where you're going here, and I'll have committee do it. But
I'll educate myself.
No, 'cause I read it to say that it's admissible under the normal rules of evidence in Maryland, but that the fact that it's banned in Maryland is not. And so.
Oh, you mean a banned product,
Correct.
this rule, you never put them into.
It would be
evidence.
still subject to the normal rules. But so
That's
practically speaking, I guess you'd have to obtain it in like Pennsylvania or Delaware or something.
Right.
Bring it back here, use it, maybe offer it for evidence. It gets in, it doesn't get in. If it gets in.
Right.
The fact that it was banned in Maryland cannot be used. That's what can you count, let's speak
Okay,
through council,
that's
so it's not
helpful.
me
Thank you.
to say, can you, Jamie, please?
Sorry.
Thank you, Mr. Chair. That's correct. So the fact that the kit was obtained in what would be a violation of the ban is what's not admissible. That provision doesn't say that the kit itself is not admissible. It's just that the fact that it would have been a violation or is what's not admissible.
All right. Thanks. I'll read it first. Yeah. And then just the 2 other issues that if this is taking too much time, get back to me. But we have both probably federal and state consumer protection laws. We have federal, I don't know if we have state sort of federal trade regulations, so again, I don't know where this product is under there, like if it's been reviewed. I mean, I'm listening to what you're all saying. I don't know if they have not weighed in, if they have not banned it, if they have not gone after them for highly deceptive practices. I don't know if we've ever done something like this before in Maryland, and I just don't know how well it gets held up if no other entity with the expertise to look at a product like this, as awful as it is, from what you all are saying, how we would justify that, and what is the defining principle? So in case we get other bills not even relating to, you know, women's issues, we have some defining principle about how we decide that a product's so darn bad we're going to do something like this.
Yeah, Senator, thank you so much for that question. If I may, and if it's acceptable to the chair, we have someone from the Consumer Protection Division who will be testifying next, who is much more expert in this than I am.
Thank you very much. Thank you, Mr. Chairman.
No, actually, I'm very interested in hearing what they have to say.
Yeah,
about
me
that
too.
too. That's great. All right, seeing no further questions, thank you very much. Thank you. All right, we'll bring up Mr. Schellenberger, Daniel Katz. Is Amanda Rodriguez still here? I think I saw her. There you go. And then Heather Force.
Yes, I'm Heather.
Oh, hey,
Good
how are you?
afternoon.
Good afternoon.
Good afternoon, Chair and members of the committee. My name is Heather Forsyth. I'm an Assistant Attorney General, and I'm offering some comments on behalf of the Consumer Protection Division of the Office of the Attorney General in support of this bill. We, as you heard, we're not a member of the SAIC committee, but met with the committee to provide input on consumer protection concerns. During the course of multiple meetings, we had 3 primary consumer protection concerns that came up. First, the commercial sale and distribution of these kits purport to provide victims with the ability to collect evidence without evidence that any material self-collected is admissible in Maryland courts. Second, consumers who provide physical material to purveyors of such kits lose privacy control over their genetic information. And third, reliance on these kits means the user does not have access to all the advocacy and medical care needed after a sexual assault. The Consumer Protection Division in Maryland is not alone in its concerns. Right. As you've heard, the attorneys general of 8 other states have issued cease and desist or warning letters, and the sale of these over-the-counter kits have been completely banned in New Hampshire and in Washington. Commercial kits are presented as if to offer an easy do-it-yourself alternative to legal and medical intervention after an assault, especially for consumers who may not feel comfortable with law enforcement or traditional healthcare institutions, particularly in underserved areas. However, as much as we understand this discomfort, we think fixing a systemic problem by offering a solution that has no legal or medical value, however well-intended, may well result in more harm and is not protective of consumer interests. For these reasons, we urge the committee's support and hope that you'll issue a favorable report on SB 949.
Good afternoon, Mr. Chair, members of the committee. My name is Amanda Rodriguez. I'm the Executive Director of Turnaround for the Rape Crisis Center for Baltimore County and City. We are testifying favorably on SB 949. Survivors are already calling our 24/7 hotline asking for information regarding self-administered kits. As you've heard from Ms. Jordan, a survivor immediately after a sexual assault often experiences a period of heightened vulnerability. They're searching for what to do next and also grappling with what has just happened to them. Presenting self-administered kits as a viable option to a survivor is simply predatory. Where we're seeing this most often is college students who, for a variety of reasons, are seeking an easy option so that they don't have to tell their parents or that they don't have to engage with the criminal justice system yet while they figure out what to do. Imagine the horror of finding out that not only is this kit that you've taken as a result of wanting to pursue a criminal case cannot even be tested, let alone introduced in Maryland courts. The Wikipedia article that's written about one such organization that's selling these self-administered kits in Maryland touts Maryland legislation as one of the reasons that it is able to move forward. They call it a significant event in their company's history, that they tout that legislation acknowledges the potential benefits of these kits. Survivors deserve justice, and if they decide to get a rape kit, they should not be preyed on by an entity during an extremely vulnerable time and difficult period of time for them. Thank you so much.
Good afternoon, Chair Smith and members of the committee. My name is Dan Katz. I'm the Director of the Maryland State Police Forensic Sciences Division and a member of the Maryland Sexual Assault Kit Policy and Funding Committee. I'm here today in strong support of SB 949, which makes it illegal for a person to sell, offer for sale, or distribute a self-administered sexual assault evidence collection kit in the state of Maryland. I've provided written testimony that details how the use of self-administered kits negatively impact forensic DNA testing, resulting in one of three undesirable outcomes. 1, not being able to generate a DNA profile. 2, being able to generate a DNA profile, but that DNA profile not being admissible in court. And 3, being able to generate a DNA profile, but that DNA profile not being eligible for entry into the DNA database. I want to dive a little bit deeper into the third outcome I mentioned about a DNA profile obtained from a self-administered kit not being eligible for entry into the DNA database. This is critical because unless there is a known suspect, the potential for identifying a perpetrator depends primarily on the DNA profile from the evidence collected in the sexual assault kit hitting in the DNA database to the DNA profile of a known offender. It is important to know that only public forensic DNA laboratories have access to the CODIS software that is used to operate the national, state, and local DNA databases in the U.S. Private forensic DNA laboratories do not have access to CODIS. Furthermore, the public labs have very stringent requirements that they must follow in order to use CODIS. One of the most notable is that only DNA profiles obtained from evidence associated with a crime can be entered into CODIS. The problem is that when evidence is not collected in a controlled environment by an independent third party, it is impossible to confirm that the DNA profile is actually from evidence associated with a crime. And the reality is that a public laboratory would not test that evidence for CODIS entry. The other option is to pay a private laboratory to test the evidence, which they will do because they are a business, but again, they do not have the ability to upload it to CODIS. Anytime a private laboratory produces a DNA profile from evidence, the only way it can get into CODIS is if a public laboratory is willing to take ownership of the DNA profile. In this particular instance, we already established that a public laboratory would not be willing to take ownership of the DNA profile. It's a catch-22. For these reasons, the Department of State Police urges the Commission to give Senate Bill 949 a favorable report. Thank you.
So a little different approach. Scott Schellenberger, State's Attorney for Baltimore County, also a member of the committee. Senator James, to respond to your question, that home pregnancy test that is so available that everybody believes is good, you're not getting that into evidence in court because typically a doctor is going to want to have a lab-induced test. And that's what this is all about. It's not just about CODIS. It's about getting it into evidence in my courtroom. And so what I'd ask you to ask the opponents of this bill is ask them today if there is one case in this entire country where one of the results of this kit was introduced into a criminal matter. And I'd also ask them if this week they started giving out some of these kits at a Baltimore nonprofit, because that's some of the things that have happened. But let me tell you what this is really about. It's 2 o'clock in the morning. You've been in you're a woman, you've been in a Towson bar, you've been drinking, you meet Matt, you give Matt your address, and you plan on seeing Matt sometimes next week. But unfortunately, you go home and Matt's knocking at your door. And the next thing you know, you're being sexually assaulted. And then after Matt leaves that apartment, you suddenly remember that you got one of these kits because they give them out at the colleges. And so you use the kit, but you're not sure what to do with it. So you decide to put it in a drawer somewhere, and there it stays for a couple of weeks. And that can happen. And then all of a sudden you talk to your friends and you decide to mail that kit to the company that they're sponsoring. And then you get the results back. You finally have the courage to come to the police. You finally have the courage to walk into the state's attorney's office. You hand me the results and they say, can you figure out who Matt is? And the answer is, I can't. I can't send that to Dan Katz to find out whose DNA that belongs to. And more importantly, if we ever figure out who Matt is because she sees him at another bar or sees him at a school, I have to try and get that into evidence. And it's called chain of custody. And chain of custody is so important. And the defense attorney is going to be like this. So you did the self-administered kit, right? Right. Did you do it that right after it happened? No. When did you do it? I did it 2 days later. That might be okay. It might be admissible. Then what happened to the kit? I put it in a drawer. And did you keep an eye on that drawer the whole time? Was that a drawer secure? Well, my roommates had access to that drawer. And I went and visited my parents up in another state. And I was away for 3 weeks while I was trying to recover from this. And then when I came back, I decided to finally submit the kit. So I mailed it using an envelope to the company and I get the results back. And now I have to look at them and say, I am sorry, but that is not going to be admissible in court. Not only can't I find out who Matt is, but I can't use that in a court of law because chain of custody is so important. When we get them from the hospital, a police officer gets them, they sign that they're the ones that picked it up. They go to an evidence room that's purely locked, that only police officers can get in. They lock that up. They want to send it for DNA testing. They bring it out to the lab. They sign for that. This is not a good deal. And we are subjecting victims at their most vulnerable state, and giving them a false sense that they've done something. Please ban the kits, vote in favor of 949. Thank you.
Excellent. Thank you very much. Questions from the committee? All right. Thank you all very much. Thank you. That will conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. And is Mr. Johansson here? Yeah. Jacob Madden? Yeah. And then Sean Bogle? And Deepa
She
Gasanan?
was in a car accident. She could not make it. Yeah, she's fine, but yeah.
Okay. We hope she's okay. Please send her our regards.
And Mr. Aborn is virtual, Mr. Chairman.
Okay, yes, excellent. We'll hear from our virtual panelist after in person. Thank you.
Thank you. Well, hello, my name is Jacob. First off, I'd like to thank everybody for being here. And I do believe, despite our differences in opinions, that we are all here to try and help sexual assault survivors. That being said, despite the sort of story that was just told, I hate discussing these sorts of things because these are realities for people right now. And it was a reality for me. I was raped when I was 18. It was my first experience at all sexually. It shattered everything I knew about humanity, my trust, everything. And in that moment, there was simply no reality in which I would have felt comfortable going into a hospital, being photographed, being questioned, being touched, being handled. It just was not a possibility for me. On top of that, you know, it is not just women who are raped. It is men, and I was not out. So I would have had to deal with that as well. It felt totally unfair in the moment. And it feels unfair to ask victims that the only way in which they can collect DNA evidence in the 48-hour period in which it is detectable to go into a hospital. And the reason that we are here in opposition is not to argue. It is to offer more options. It is to work with you guys. I haven't spoken to anybody that just testified. We would love to figure out ways in which we can solve some of these very real concerns. However, the reason that I'm here testifying and the reason that this really exists is because there is a problem. And we are trying to solve that problem and expand the possibilities for survivors. You yourselves in the report have admitted that these might be helpful. And if there's even a chance that it is helpful to an investigation, then I truly believe this is something that we have to at least consider. So thank you so much for your time.
Good afternoon. Thank you, Chair. Thank you, members of the committee. My name is Dr. Sean Bogle, and I'm the Chief Operating Officer for Leda Health. My background professionally is working as a Title IX coordinator at colleges and universities. My dissertation focused on contemporary federal guidance for campus sexual assault. In regards to my work with Leda Health, our role and our mission is to increase autonomy for survivors of sexual assault and to provide them with a greater sense of self-agency. Earlier in this hearing, it was referenced that our company is partnered with a nonprofit in Baltimore. That's absolutely correct. How that partnership came about was the recognition that there are simply some survivors who do not feel comfortable going to the police or going to a hospital to seek care. The organization that we're partnered with represents organizations that are similar to those across the world or across this country, where they are women-centered and they provide holistic support to women in other areas beyond just sexual assault. They depend on these organizations for basic needs such as transportation, food insecurity, help with childcare. These are organizations that are reputable and have been in your state for several years. So for them to even think about compromising their ability to help and support women who trust them for resources means that they understand the magnitude and seriousness of this issue. And they understand, they've told me personally, they've had women come in and say, I don't want to go to the hospital. I do not want to go to the police and report my matter of sexual assault. And they're left with no option for them. So just to echo what has been said earlier, we desire to work with the state of Maryland to increase access and increase resources for survivors of sexual assault. And we want to work with you to ensure that we can do this together, because we realize that not everyone has the privilege to feel that they can go and report to the police. Not every underserved community in Maryland feels that they have access and feels safe to go to the police and report sexual assault. Thank you for your time.
Samantha.
Good afternoon, Chair Smith and committee members. My name is Samantha Escobar, and I am a sexual assault survivor, as well as the former president for Penn State University Latino Caucus. For 3 years, I dedicated my time and efforts to advocating for the needs of over 6,000 Latinx students there. One of the harsh realities I faced during my tenure was the alarming rate at which sexual assault cases went unreported within our community. Latinx individuals, like many marginalized groups, are disproportionately less likely to report instances of sexual assault or seek government intervention due to many complex circumstances and reasons. A 2010 study revealed that 1 in 6 Latina women will be sexually victimized, and only 20% of Latina survivors will seek formal support. For Hispanic victims, the prospect of dealing with law enforcement and authorities after an assault is even more daunting due to the heightened discomfort and fear. Cultural and language barriers, fear of deportation, and distrust of law enforcement are just a few contributing factors to sexual violence underreporting within the Latinx community. Of course, there is importance in encouraging all survivors to report. However, for individuals who refuse to do so, a self-administered kit is better than doing nothing at all. For those who fear being misunderstood or mistreated, the importance of the rape kits cannot be overstated, especially for marginalized communities. Some of these groups include women of color, people with disabilities, Indigenous people, men, and religious minorities. A survey conducted by the National Violence Against Women concluded that Black, Hispanic, and Indigenous women are at a greater risk of being raped than white women. Leda Health's rape kits have a potential to remove biases and ensure a more equitable and sensible approach to validating an assault. In conclusion, I urge you to support the implementation of these rape kits in Maryland, and by doing so, we can take a significant step towards addressing the underreporting of sexual assault within the Latinx and minority communities and ensuring that all survivors receive the support and justice they deserve. Thank you.
Thank you, Mr. Chairman, members of the Judicial Proceedings Committee and the Senate Finance Committee. So, Mike Johansson on behalf of the Rifkin firm for Leda Health. If this were a situation where 85% of the people were getting the gold standard forensic exam, this product would get in the way. This is a situation where at best, 10 to 15% of sexual assault victims are getting the gold standard forensic exam. The policy committee that's been working on this for a couple of years is going to make improvements to that. I hope that they can double it. Now let's focus on the 70% of the people that are not reporting at all and not collecting any DNA evidence other than the article of clothing that everybody in the prior panel said, if you report to police 30 days later and you have an article of clothing that's been hanging in your closet, you live with 4 or 5 roommates, men, women, whoever it is, you've moved 6 times, bring that article of clothing in. We may get DNA off of it. Is there anybody here who believes that's any different than swabs that are in a bag that's brought to law enforcement, sent to a lab, whether it's in Florida? If the state police would accept the kits, we'll send them straight to the state police. Let them hold them. And if an investigator, which this bill instructs investigators to accept this material, if you find the kit in DC or some other location, the bill itself instructs people to consider it for the evidence it's worth. And if an investigator says, wait a minute, you sent the test into a lab, you got a result back that there was foreign DNA, what's the name of the lab? This kit actually submits 2 samples of the perpetrator's DNA, one of which gets tested to show there's foreign DNA, and the second one is sitting in the lab. If you're an investigator, what's your next step? You may seek that evidence from the lab. Now, if you have a potential victim and you get a swab, I don't know, I'm not a courtroom person. You get a swab from the guy you think is the suspect. You have a lab you have a test sample in Florida from some sample from DNA. You think you can send them both to the state police and have them look to see if it's a match? There's usefulness here. So we ask you not to support the bill.
Excellent. Thank you very much. We have a couple questions from committee members. Let's go with Senator Muse first, then Senator West.
Thank you. And this is to whoever may represent a company that sells this. One, how and good afternoon. I feel like it's evening. How is your company funded?
So we are funded by venture capital funding.
What's the annual budget?
What's the what?
Annual budget.
Annually, we spend around 800,000.
How does do these kits provide justice for a survivor of sexual assault, in your opinion?
Yeah. So again, and we have survivors here, so I don't want to speak for every survivor. I surely cannot do that. But I think in regards to your question, our number one goal is to ensure that survivors have increased autonomy so that if they don't feel comfortable or safe going to the police or to a healthcare agency, they can still have a way to self-administer the kit. In our instructions, and the kit is right here, the first thing that we do is we encourage them to go to the police. When I did an onboarding here in Maryland last week, the very first thing we do is we encourage them to go to the hospital or to go to the police. And we always emphasize that we do not intend to be in lieu of medical care.
Have any of these kits been admitted into criminal court at all?
Not that we're aware of. We are certainly a building company. We're growing. We recognize that this is a new opportunity to increase resources for sexual assault survivors.
Thank you. Thank you.
Thank you, Mr. Chair. Let me ask Mr. Johansson a question or two, if I could. And you need to go up to the podium.
Okay.
This committee is maybe the only committee in the General Assembly that requires you to speak from a podium.
I like it up there.
But you look distinguished up there.
Thank
you. Not a single one of these kits has been accepted in court, and you heard the testimony of Mr. Schellenberger, the Baltimore County State's Attorney, that he would not be able to get any one of these kits admitted into court because of the custody problem, the chain of custody issue.
Correct.
That being the case, what use are these kits? The whole purpose of using these kits, I assume, is to be able to establish down the road in court that you have been raped. And if you can't do it, why would we want to encourage people to use these kits?
My understanding with criminal investigations is there's lots of little bits and pieces of evidence. And everyone up here said clothing is potentially admissible. Always admissible? No. Are there chain of custody issues? I don't see any difference in chain of custody issues with DNA on clothing purportedly worn during the attack, purportedly from a non-consensual sex act versus a swab that was taken within the time of the purported incident and either kept and hand delivered to police like that piece of clothing or submitted to a lab.
Well, let me
No
suggest that
difference.
if I live in an apartment and I have a closet and there's clothing in the closet and the clothing has evidence of sex on it, and nobody else has come into my apartment in the 2.5 weeks since the incident occurred.
Correct.
And I took the clothing to the Baltimore County State's Attorney's Office. I think that the state's attorney might be able to make a case that the chain of custody was intact and my clothing can be admitted in trial. In this case, these kits apparently are mailed through the general mail to a company at some distance away. And then can't you see the difficulty in proving chain of custody in that situation as opposed to a piece of clothing that I keep in my closet?
I think chain of custody is difficult in both situations. And I think, just because it was put in a FedEx envelope and delivered, which obviously you have things like a time, that it was collected at a certain time. If the alleged incident was at midnight, there's a FedEx envelope the following day. That might be more indicative of relationship to the assault than a piece of clothing that you discover 30 days later. So there's other corroborating pieces of that. And is it admissible in the case in chief? I don't know. Is it helpful to the investigator to know that there's a DNA sample sitting in a lab, which knows how to take care of that? And if he chooses to seek it, and he does, can he use it? That might be more important than the article of clothing left there. So we're not deciding that. The bill itself says, bring us your evidence, victims, if you have it. And if it happens to be a kit, this bill says law enforcement shall consider it. What it does say is, don't distribute them in Maryland. There's something evil if you get one in the state of Maryland, but if you pick it up in DC, please bring it to law enforcement and we'll evaluate it for what it's worth.
Great. Okay. Thanks for answering my questions.
May I add one thing? Okay.
Thank you, Mr. Chair. I think this question is for Mr. Bogle. Is that right? Maybe you could go
That's right.
to the podium. I know there's a lot of discussion here about criminal procedure and rules of evidence, but my question is more related to the consumer protection side of this issue. And specifically, you said earlier that that sometimes people may want to use these because they don't feel comfortable going to the police. However, I think that some of the problem here is that this product is being marketed as an evidence collection kit. So it's almost contemplated that the whole purpose of it is ultimately to be used in some sort of criminal proceeding, whether it be to connect later with law enforcement. Is that fair to say?
Yeah, so I'll re-emphasize what I said earlier in the sense of we are a new company, relatively speaking, and we welcome the opportunity to work closely with Maryland to customize this resource in a way that makes sense. I can give you an example that I think will hopefully be a sufficient response. When we worked with a nonprofit in Baltimore, what we provided to them in the bag itself, it says Clarity Kit. And the reason why we put clarity there is because we desire for every survivor to have a sense of clarity. And in addition to providing them the kit that is here, we worked with the nonprofit to create a customized resource card that included information around free mental health resources in the Baltimore community. In addition to that, they included an at-home pregnancy test. So the idea for us is to provide holistic support to sexual assault survivors. So that is, in my mind, how we are working beyond just the sense of it being pure evidence.
Okay, all right. Well, and just one more question, Mr. Chair. I understand that. I think, some of the concern is if you're marketing this product as an evidence collection kit, when in reality, it can't actually be used for the purpose of that. That's where some of this is kind of problematic. What kind of warning do you have on your product? I know there's some discussion earlier about that, about what kind of warning is used, what kind of warning is communicated
to the consumer that this product may not actually be admissible in court?
Well, I'll preface my response by saying we do hope that it can be used as evidence one day so that survivors have a greater sense of justice beyond the 0.7 conviction rate that currently exists for sexual assault survivors with current mechanisms in place. That being said, we have a disclaimer right here on the box. And actually, we use some of the guidance that was provided in the Maryland report in February to create this disclaimer sticker. So it essentially provides a disclaimer letting the survivor know, not only in English, but in Spanish, as was advised in the report, of what the kit can and cannot do so that there isn't a sense of false hope.
Okay, so it says on there, like, it may not be admissible in court, correct?
Yes, as advised
Okay.
from the February
Okay,
report.
all right, thank you very much. Thank you, Mr. Chair.
Thank you, Mr. Chair. The gentleman that was just standing there. Hi. So I may have missed this, but how much is each of these kits?
So these kits are currently being provided at no cost to the nonprofits that we work with, directly to nonprofit organizations and not to individuals.
So you provide these kits that are not admissible, free of charge. That, for what purpose then?
So our ultimate goal is certainly to work with Maryland, other states, other agencies, so that they can be continually provided to residents throughout the state.
I understand what your ultimate goal is, but I'm asking you what value of the device or the kit you're providing right now is.
Yeah, so I think you can speak to sexual assault survivors who would tell you that just by taking the kit, it provides them with a sense of self-validation. So I've met with many women and oftentimes men as well who've been sexually assaulted, who, as I've pointed out already, quite frankly, do not feel comfortable going through a criminal justice process or making that decision immediately. The kit itself does not deter or is not intended to deter anyone from going to law enforcement agencies, anyone from going to a hospital setting. In fact, as I pointed out, we encourage that. But them being able to make that first step after being sexually assaulted provides them with a sense of self-validation that I'm sure if you speak with survivors, they can.
So
inform
how soon after they take this exam is the results available?
So they can get the results in as little as 72 hours, 72 to 96 hours, they can get the results back.
So 3 to 4 days. And in the interim, over that time, the results they get back are not admissible, and there's been a 3 to 4 day break from the time of the exam, not even the time of the assault. So there could have been time in the middle of, on the front end of this, that's creating an evidentiary hurdle. So I keep hearing, we're talking about like, right now they're not, but they may be, or there was talk even about like clothing may be admissible. The reality is the evidentiary value and the control of said evidence has to be followed appropriately, because many cases are lost on chain of custody issues. And there is no viable chain of custody issue available for the service you're providing. So I just want to be clear. You get nothing in return as a business. You provide these for free. They provide no evidentiary value currently. So for this, you're able to say that they get some type of peace of mind out of it when there is nothing that in this kit that helps them move forward any criminal case for their assailant.
So just to be very clear, we, as I've mentioned before, want to work with the state of Maryland to customize it so that this kit, and the state of Maryland has acknowledged in their own reports that the value of a self-administered kit is something that's being explored. So that within itself validates that a self-administered kit could be a resource by the state of Maryland's own wording.
You're not answering my question.
So in terms of the evidentiary component, we want to work there. It's not there yet.
I know. I've heard you say that like 4 different times to 4 different questions. But my question was, what does it provide? Well, and you're getting nothing out of this?
So I think respectfully, you're undervaluing what the kit could mean to a survivor for self-validation. And also getting something of this magnitude in terms of being able to collect your evidence, being able to put a pair of garment underwear inside of a garment bag is providing something.
Okay. Thank you, Mr. Chair.
All right, so thank you very much, Senator Folden. We'll now move on. There are no further questions for the in-person panels. Move on to our guest who's joined us virtually. Okay, we had some connectivity issues. His audio is not working. Can you pop him back on?
He's in the room. It's
There you
just
go.
audio. He's still not.
Mr. Bourne, can you hear us? Going once, going twice. All right, we tried. All right. All right, with that, that'll conclude the testimony and the hearing for Senate Bill 949.
Mr. Chairman.
Thank you very much. Thank you, Senator Heldman. We'll now move on to Senate Bill 1098. Hey, it's fine.
All right, Senator Smith,
All right.
you are
members
up
of
with Senate Bill 1098.
That's right, 1098. Remaining members of the committee, the Senator Smith, for the record, here to introduce Senate Bill 1098. On September 22nd, 2023, a bright young professional, Pavel Lapierre, who chose Baltimore as her adopted home, Baltimore City as her adopted home, was tragically murdered by an individual who was released after having served only 7 years of a 30-year sentence. A 30-year sentence with all but 14 suspended and diminution credits meant that Pavel Lapierre's murderer was out in only 7 years. Her murderer was convicted in 2015 of a first-degree sex offense, but his violent past extended back to 2009 and included charges for attempted rape, armed robbery, and false imprisonment. Now, last week, I watched intently as Pavel's parents testified on behalf of this bill in the House of Delegates. And I want to thank them for their courage and for their willingness to turn their anguish into activism and progress, not only for themselves, not for themselves, but for others. As a father of 2 young daughters, Mr. Lapierre's testimony struck me to my core, in particular part when he said that he knew that we could make progress because a mother should never have to nurse her son back to health after a horrific act of repeated violence. And a sibling should not have to lose his best friend and most trusted confidant when they're both in their 20s. And a father should kiss his daughter goodnight and not try to cry himself to sleep through avoidable loss. I also want to take a moment to acknowledge that the Baltimore Banner today published an article in which April Hurley's case was featured. She was also assaulted last September. She's a 25-year-old woman who was sexually assaulted. Her neck was sliced open and she was set on fire while living in a rented room in a row house on Edmonston Avenue in West Baltimore. Now, I am a proponent of diminution credits, and as chair, I've worked with many of you in this room, well, many of the chairs in this room, to expand opportunities for diminution credits because I believe in redemption and I believe in equipping people with the skills that they need to thrive when they return. So why the proposed change? We have to balance rehabilitation and redemption with the superseding weight of public safety. That's why. The crime of first-degree rape, which is the most violent of sex offenses, and for which recidivism rates have been found to have had a greater propensity to reoffend and commit future violent offenses, must be recognized, and the law must adjust to that understanding. Now, here's how the law currently works. To secure early release in Maryland, you have 2 options. You can earn diminution credits, DIM credits, through good behavior, classes, and then you're released immediately, automatically, once you earn enough of those credits. And no discretion is given to that release. Second, you can do it through the parole commission. The parole commission must consider the victim's testimony and input, their record, the incarcerated person's record and history of violence offenses is taken into account. If there's no history of a first offense, they'll consider if a person is taking advantage of their time in prison by learning skills and taking classes. They can learn from the lawyers and from law enforcement, and they can consider the entire package, the whole picture, the whole scope of the individual before considering release. For certain crimes, there is value in that discretion, and this body has already determined what that value looks like. The following types of incarcerated individuals may not earn DIM credits or diminution credits. For first or second degree rape against a victim younger than 16, this General Assembly said you cannot earn diminution credits. For a subsequent conviction of a third degree sexual offense against a victim younger than 16, this General Assembly has said you cannot earn diminution credits. An incarcerated individual imprisoned for a lifetime sexual offense may not receive diminution credits. So the bill before you proposes that discretion be reinstilled into those first degree sex offenses, regardless of how old the victim is, 16 or 80. And with that, I ask for a favorable committee report. And again, I want to thank the LePere family for their advocacy and for their hard work and their tenacity and for your presence here today. And for that, I ask for a favorable committee report. I'll turn it over to my panel. I'll sit tight for questions, but I'll invite the State's Attorney for Baltimore City up next.
Thank you. Thank you, Steve.
Thank you, Senator, also Chairman Smith, Chairwoman Carter, and Vice Chair Waldstreicher, as well as the members of the committee. Good afternoon. My name is Ivan Bates, and I'm here today to express my support for Senate Bill 1098, Correctional Services Diminution Credits, also known as the Pava Marie LePere Act. As Baltimore City State's Attorney, I believe that this bill is crucial in addressing the serious issue of early release for first-degree rape and sex offenders for our state's correctional system. Senate Bill 1098 aims to prohibit incarcerated individuals for these specific sexual offenses from earning diminution credits towards their terms of confinement. This reform is essential to ensuring justice for victims, preventing further harm, and protecting public safety. When I sit down and look around the state of Maryland, over the past decade, we have witnessed 11 individuals charged with first-degree rape released on parole, while 199 were released during that period due to diminution credits. By repealing and reenacting the specific provisions of Article 3-702 of the Correctional Services section, this bill sends a clear message that sentences for such heinous crimes will be fully enforced, and a convicted individual will face significant consequences for their actions that undoubtedly inflicted devastating trauma to both victims and their loved ones. However, those individuals that created and committed these crimes, they will still be eligible to come home before men and women and the parole board. The parole board will look at the information, will look at the background, and have a true understanding of that individual and what they can then give back to the community and society, as it should be in reference to this particular act. But they will no longer, meaning individuals released, no longer be arbitrarily released due solely to earning these credits without showing any real rehabilitative efforts of not reoffending. I commend Chair Smith for his leadership in introducing this legislation, his commitment to protecting the rights and safety of all individuals, especially victims of sexual violence. I sincerely hope you will consider supporting Senate Bill 1098 and advocating for its passage through the Judicial Proceedings Committee. This bill represents a significant opportunity to make our correctional system more just and equitable for all. Thank you very much for your attention.
Good afternoon, and thank you for this opportunity to provide testimony to you in favor of Senate Bill 1098, the Pava Marie LePere Act. I'm Pava's proud mother. I speak on behalf of myself, my husband, my son. We're committed to turning our horrific tragedy into a positive good. Pava was born in 1997. She was beautiful and healthy, had boundless joy, and we had a lot of hope for our daughter. She never disappointed. Being bright, creative, funny, curious, and determined, she quickly developed into a natural leader. Her talents, vision, compassion, and dedication made her exemplary in this role. From grade school through high school, on to college. In college is when she started pushing for entrepreneurial programs at Johns Hopkins. She realized, you're a great institution, but this is what's missing. And that later blossomed into Fast Forward University. So she was great as a student, an entrepreneur where she started her own company, and a mentor. During those undergraduate years, Pava started several companies, TCO Labs, Innovate Maryland, and most successful and still running today, EcoMap Technologies. It's a company that employs over 30 Baltimoreans, 50% of them women and 50% people of color. Pava cared a lot about the disadvantaged. She accomplished so much for so many, from fellow students to community leaders and business professionals, in her 26 years and 9 months. There's no wonder at the abundance of accolades bestowed on Pava's brilliant life and legacy. She was a gifted, productive leader who had that rare ability to bring to fruition the talents of team members. Her colleagues and friends tell me that she was color, age, sex, and ethnicity blind. What better example could be set from Pava, whose mission it was to build not just a company, but a company that was equitable and accessible in her chosen city of Baltimore. You'll hear about the Place Builders Fellowship Program, which is designed to give equal access to entrepreneurs in Maryland. Pava's beaming in heaven about this. And Governor Wes Moore introduced the Pava-LaPere Legacy Act to provide startup grants to Maryland college entrepreneurs, again, to help fulfill Pava's dream. She herself was in the situation where she had a company, didn't know how she was going to meet her payroll, but was lucky because it came through. But when I'm here, I'm share how proud I am, but also most unfortunately, I'm here as a victim because my daughter was assaulted and murdered in Baltimore while she was in the process of pursuing her dream of inclusion and empowering entrepreneurs. She's gone, but her legacy must continue. Next month, her murder trial will be given a date, and many sad facts will be brought up. But what's most impertinent to all of us here is that Pava's brutal assault and murder was perpetrated by a convicted first-degree criminal. He was too dangerous to be on the streets of Baltimore, but had been given early release due to dim credits. This tragic consequence cost us our daughter's life, and Baltimore lost a prolific leader. So I implore you to prevent this from occurring again. I'm very grateful for this opportunity to speak to you, not only for my daughter, but for other victims of this crime. Further, I remind you that there are victims who will never have an opportunity like this to be heard. So I speak for them as well. Make Baltimore a safer place to live and build ecosystems. Thank you.
Good afternoon, Chairman Smith, members of the committee. Thank you for the opportunity to speak about this important legislation. Caroline, thank you for being here for Pava today and every day. And thank you to State's Attorney Bates as well for supporting this legislation. My name is Corey Bailey. I am the CEO of Upsurge Baltimore, an organization focused on building a thriving tech hub in Baltimore and startup growth across the state of Maryland. I'm here as a representative of the Baltimore tech community, of which Pava-LaPere was a beloved member, but also as a friend. My 3 sons, in fact, were born at the exact same hospital in Tucson that Pava was. She was an exceptional talent, one of the many talented women founders and leaders that we have in our tech community. Women who faced far too many challenges launching and scaling their companies, access to networks, resources, and funding, all challenges Pava faced herself and was helping our entire community overcome through EcoMap, the startup that she co-founded in her dorm room at Johns Hopkins, led admirably as its CEO, and a company that is still thriving today in Baltimore, now employing close to 30 Marylanders. Despite these challenges, women-led companies are some of the fastest growing for our growing tech hub. And in terms of hiring a diverse, well-trained workforce and the commitment that their growth has an impact on the economy, both at a local level and at the state level. The number of outstanding women leaders we have in our tech community is one of our biggest advantages. Governor Moore has said repeatedly that people deserve to feel safe in their own neighborhoods and in their own skin. Providing these exceptional leaders with the basic safety and security required to build game-changing companies in the state of Maryland is the absolute least we can do. It is important that we support any legislation that would remove those barriers that Pava and other women leaders like her faced in creating strong companies that build cultures of belonging in tech. Senate Bill 1098 recognizes the importance and impact that women have on our state's economy and in our communities. And for that reason, I humbly urge the members of this committee to deliver a favorable vote. Thank you.
Good afternoon, Madam Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of Senate Bill 1098. I met Mrs. LePere last week, and my heart is still so broken hearing your story, and I cannot begin to imagine the depth of your loss. And I'm so sorry and grateful for your advocacy. This committee knows that sexual assault is deeply personal. It shatters your sense of security, it injures your spirit, and conviction and sentencing can help give survivors some measure of support. And listening to this bill, we say, oh, first-degree sexual offense or first-degree rape. And I think it's important that we just take a moment and think about what that actually means. In addition to the rape itself, in addition to the sexual component, these are people who are employing or displaying a dangerous weapon. They're inflicting serious bodily injury, suffocation, strangulation, disfigurement, or they're threatening to do so. They're gang rapes. They are cases committed in connection with a burglary. These offenders, they should never be released automatically. This is a very modest bill. It doesn't say, oh, no dim credits at all. It says, let's have other human beings look at whether or not this offender should be released into our communities. This is the very least we can do for sexual assault survivors who have experienced these heinous crimes. And for these reasons, the Maryland Coalition Against Sexual Assault asks for a favorable report on Senate Bill 1098.
Thank you very much to the first panel. Thank you, Senator Smith, for bringing the bill. Ms. LePere, I'm sure that I speak for all of us in expressing our deep condolences to you. There's everything that we know about your daughter. She was a bright light, definitely taken from this earth too soon. So thank you for coming. Are there questions from the committee for this panel?
Thank you. Sure.
I don't know if you can answer, State's Attorney Bates, but you're the closest person that might be able to answer. I understand the dim credit issue and the connection to the alleged assailant here in the murder of Pava LePere. But there's another part of this that I think needs to be fleshed out as well, which is, as the chairman said, the story that's in the paper today with the other young lady that was brutally assaulted. And there was apparently, can you speak to was there a failure of the police to investigate? Why was there no follow-up with the first victim, which could have possibly prevented the tragedy with Pava? Are you aware of what happened? And if you are, can you speak about it?
I'm very aware of what happened, but unfortunately, out of fairness, everybody's innocent until proven guilty. And I feel if I talk about the specific cases, that's unfair to that individual. So out of fairness to everybody, I'm not here to also speak on the investigation. I think the police department spoke on the investigation, but I do feel if I go too far and reference to any facts, that that's not fair to that individual who we've charged. Regardless, I have to make sure that the criminal justice system treats everybody fair and everybody's innocent until proven guilty. I do think some of those facts will come out later, but unfortunately, I'm not at liberty to give them right now, and I do apologize.
Are there pending charges for both cases?
There are pending charges for both cases. And then I think it's already been stated that next week they'll actually have trial dates for both cases.
Okay, thank you. Any other questions from the committee? Senator Sidnor.
Thank you very much. And good afternoon. I did have a question I'm looking at Maryland Alliance for Justice Reform, and they put forth testimony unfavorable. And they state that the real problem, which SB 1098 does not consider, is this: Maryland's prisons don't have an effective risk assessment tool to identify which sex offenders will pose future dangers. We also don't have effective treatment programs within the prison system for sex offenders. It says while 667 sex offenders were incarcerated, according to the most recent DPSCS statistics, only 33, less than 5%, received treatment at the Patuxent institution. Fiscal year, addressing these gaps could protect future victims and reform sex offenders. Would you mind speaking to that? I'm just giving your experience.
Well, I think we're saying two separate things. Well, we're saying, no one's saying that individuals charged or individuals convicted and doing time division correction should not have programs. And I, without a doubt, agree there needs to be better programming, but that's something DPSCS needs to look at. But really, I think they make our argument they make for us. We're saying that the programming needs to happen. And what we're saying is that the parole commission will look at these individuals, look at their background, look at their history, hopefully with the individuals that have the programming, and then we'll make the determination they should be released. Diminution credits say it doesn't matter what you've done and what you didn't do. We're just going to release you when your time is up. And so clearly what they're saying to me is, look, there's no programming. And I agree, there is no programming. So we need to get programming for them. But what we're saying is, you need not be released on diminution credits. There needs to be a checks and balance of individuals who committed these heinous crimes before they are released.
Now, and one of the other things that was mentioned was, and they quote the Maryland Parole Commissioner who talks about, it says that David Blumberg has recognized rewarding good behavior lowers the threat of violence on our prison staff.
Well, I've actually had conversations with Commissioner Blumberg, and I do understand that. However, we're not saying that it's without the possibility of parole. And this isn't the largest group of individuals. It's a relatively small group of individuals. We're not here today saying that individuals who commit murder should not receive diminution credits. We're saying individuals who commit a first-degree sex offense, first-degree rape, that they should not be able to receive diminution credits, that the parole commission. So I understand there needs to be hope for individuals to say, hey, we can still be released. We're still giving those individuals hope. There's just a level of checks and balances where we're not just releasing individuals. And you've already heard some of the testimony that in reference to the recidivism rate, it's a little more difficult sometimes with the sex offenders. All we're saying is that we've really made sure that these sex offenders who've been found guilty, either by a jury of their peers or pled guilty previously, all we're saying is that there has been a system of checks and balances. These individuals have gone through the programs, and these individuals, based on division of correction of parole, are able to come back home into the community.
Back when I first met you back in, I guess it was in 2000, the first docket that we dealt with when I was clerking for Judge Quarles was sex offense. And
I want to tell everybody my age, man.
I'm just saying. and my time being down here in the General Assembly, it's what struck me is that I think we tend to be when it comes to sex offenders, I think people tend to seem to have a more open mind dealing with murderers than they do sex offenders. So sex offenders, they tend to bear the brunt of many of these more harsher penalties. And you were mentioning just the rate of recidivism with them, and I guess their ability to be treated for whatever it is that they carry within them. Do you think that this bill would be helpful in dealing with that, really?
I think this bill does a couple of things. I think it definitely protects the public. I think also what it does, it allows the Division of Correction to really focus on the sex offenders. I think my colleague said it best. When you sit down and look at the elements of the crime, it's not just the rape, but it's the violence implored with the rape. If you sit down and maybe look at a murder, it could be impulse control, has a gun, gets scared, boom, pulls the trigger, and it's a murder. And so, but here, when you think about what actually happens with a first-degree rape or a first-degree sex offense, the number of different steps that are employed by that individual who partakes in that crime. Therefore, to me, you need to have a strong system of checks and balances to ensure that this individual does not slip through the cracks into the society and has not been properly treated to deal with the issues that they may have.
And just the last question that I had, the person who did the crime that we were talking about,
always say alleged, always say alleged.
All right, you say alleged.
Look,
you say alleged.
Look, I have to say
that. It was deplorable. My heart goes out to your family as well to the other alleged victims. But the other question I have is, outside of him, have there been other instances where people who have been convicted of that's with that same charge? I mean, are they also out? I mean, what have you seen with these folk? I mean, have there been other things that maybe we didn't hear about in the news that you might be aware of?
Well, I've had opportunity to speak to our sex offense unit, and they did tell me that there was an individual that they dealt with a number of years ago. I believe that individual was later convicted, Mr. Clifford, if I'm not mistaken. And so this has happened in the past, but my feeling is one time too many.
Understand. Look, thank you very much.
Thank you, Senator.
Senator West.
Thank you, Madam Chair. This is just a question from Mr. Bates. It's more.
They saw beat me up today.
Our poor committee chair.
No one's beating me up. No one's beating me up.
Our poor committee chair is standing there on the feeling useless. But if you want, I can ask you questions. It's a more general question about DIM credits in general. I see the need for JIM credits, and they serve a useful purpose in terms of encouraging prisoners to behave while they're in jail. What I can't understand is why you'd have up to 30 days of DIM credits a month. That effectively halves the sentence. So someone's sentenced to jail for 20 years, they end up serving 10 years because of the DIM credits. Don't you think that's excessive?
You know, it is in some ways, and it's not in others, because you do want to make sure that you give individuals who have made mistakes an opportunity to look and to work toward getting home a little more sooner.
Sure, but cutting their sentence in half, I can see reducing it a certain amount in order to encourage good behavior in jail, but cutting it in half?
No, I didn't. Look, having also been a criminal defense attorney, I understand. To be honest, one of the things sometimes when you're trying to negotiate a plea that you use to convince your client as to why they should try to take a plea. And so, you know, I think the criminal justice system is very complicated. I've seen good things, I've seen bad things, I see things that work that don't make sense, and vice versa. For me, the big thing up here is when I look at diminution credits, I specifically, once again, Senator, focusing on this particular bill, because you have the need to have a parole commission really look to see what this individual has done within the institution. Have they applied themselves? Have they done the programming? And have they gotten the services that they need inside the institution to ensure that they're not going to violate their parole and not do this type of behavior? That's why I really have focused on diminution credits on this particular bill with these particular crimes.
I got it. Thank you so much for answering my question.
Thank you so much. Any other questions from the committee? Mr. Chair, if you don't mind, I think I have a quick question for you. And so
now I invite the question.
some, a couple of so for several years, we had a bill that before this committee that would have attached DIM credits, not merely to the sort of signing up or participating into certain programs, but upon completion, people would be rewarded for not just being involved or starting something, but actually finishing something that could be of value. And so I'm wondering if you think that we could, not necessarily saying not on this bill, but if it would be smart to tie incentives to actual programming that would help the person be rehabilitated in the way that they need to be rehabilitated. And then, I'm not saying that I agree or disagree with the elimination of DIM credits. I think I'm mixed on it because of the fact that I do think that they're going to come out eventually. And what we should be focused on is that they come out prepared not to wreak havoc on society or anybody individually, not necessarily the amount of time they spend. So what if we actually required certain specific programming, treatment, therapy, and the completion of it for these particular offenders?
I would absolutely be amenable to that. And as I said, and Senator West wasn't here when I opened up with my remarks, but I've worked with, Senator West, Senator Sidnor, and yourself to expand opportunities for diminution credits in the past for obtaining an associate's degree, other credentials, vocational training. And so, yes, that's definitely in line. I think all of us are probably in favor of the expansion of those opportunities so that people are equipped to succeed when they do get out. This situation, as I mentioned, is more nuanced, and it's a very trimmed down bill that allows for that discretion of the parole board to exercise some analysis as opposed to just you hit this tick mark and you're out. And I think that's a good policy, a limited, very nimble policy choice that this committee can make, and that's before us. And that's why I drew that line between the distinction of having to develop new opportunities for DIM credits, but also understanding that this situation is different.
Thank you very much. Any further questions from the committee? All right, that would conclude the testimony of this panel. And next up, I'm calling in order this time. Meredith Riley, Amanda Rodriguez, Eden Ryan, and Amanda Grantham is who I have listed next. Oh, but wait a minute. Did I say Councilman Conway?
Madam Chair, I am Meredith Riley.
Okay.
It's my staff.
Well, that's new. Thank you very much. You may proceed. Are you first, Councilman?
I'm happy to be first. Once again, my name is Mark Conway. Oh, forgive me. Good afternoon. My name is Mark Conway. I am councilman for the 4th District in Baltimore City and the chair of the Public Safety Committee. I'm here to strongly support Senate Bill 1098, diminution credits and sexual offenses. I won't repeat a lot of what was already stated because I think it was well said, but I will give a little bit of perspective on why I'm here today and why I think it's so important that this committee move this bill. I had the opportunity to meet Pablo LaPere the night of her death. I took the last photo of her. She was a wonderful person, and I felt like that happened for a reason. That reason is for me to actually do something about it. I happen to be the chair of public safety and happen to have the responsibility of thinking about how we can be smarter about our laws and make sure that they reflect the will of the people. So we all heard about the person involved in this case, Jason Billingsley, and his long history, and Senator Carter alluded earlier to an article that went into deep detail of some of the crimes that he committed even before the night of Pava's death, or he allegedly was involved in. This was a person who should not have been on the streets, flat out. If all that is said is true, he should not have been on the streets, and we should be doing everything in our power to make sure that we don't make this mistake again. In 2013, Billingsley pled guilty to a charge of first-degree sex offense and was sentenced to 30 years in prison But he only served 9 years of that term, in part to diminishing credits. And as we thought long and hard about what we could do to adequately address this concern, in conversations with State Attorney Bates, diminution credits did come up as a major opportunity to be more thoughtful. And as this bill was crafted, making sure that there was still that opportunity for hope for folks that did commit a crime, were found guilty, and are in the prison system and do want to work towards rehabilitation, and do want to work toward being ready to once again live within our society. We still want to provide that opportunity, in which this bill does. The Parole Commission can still provide parole. And so I think, to the questions that were asked earlier, I think it's important to consider that these are things that the Parole Commission should be considering when they're evaluating whether or not an individual is prepared to go back onto our streets. And I would hope, and I can't guarantee, none of us can guarantee this, but I would have hoped that in this instance, that would have been considered. I do agree, there definitely needs to be additional resources put into our prison systems to make sure that people are rehabilitated. But I think that is a question separate from what we're here today to discuss. And I'm more than happy to advocate for that as well. So I urge a favorable report for Senate Bill 1098 and open myself to questions. Thank you, Mr. Chair.
Thank you, Mr. Councilman. We'll take questions at the end of the panel.
Good afternoon. My name is Amanda Grantham, and I am here to speak today to express my support for Senate Bill 1098, Correctional Services Diminution Credits, the Pava-Murray-LaPierre Act. I have had the privilege to serve and lead in the Baltimore County and Baltimore City State's Attorney's Victim Witness Divisions for a combined 15 years. Currently, as the chief of the Victim Witness Division in the Baltimore City, I believe that this bill is central into addressing the serious issue of early release of first-degree rape and sexual offenders from our state's correctional facilities. A lot of the focus here today has been about safeguarding these individuals that they do not reoffend. But I would like to shift the perspective and represent all of our survivors. Being a survivor in the criminal justice system is a gruesome and terrifying process for most. From the moment that crime is reported, the system tends to re-traumatize our survivors. We ask them to endure safe exams. We ask them to spend countless hours being interviewed by law enforcement. We give them time to heal and calm their systems, but as the process begins to materialize, they receive a call from the state's attorney's office. We want you to come in and answer more questions, talk about plea offers, talk about what you would like to see happen in your case. We ask them to sit on a stand directly in front of the person that hurt them, that shattered their lives into tiny pieces for them to put back together. If we get a conviction, we ask them to invoke their right to a victim impact statement. All of this is done in sporadic spurts of time. They begin to find peace, and then each time they start to heal, we ask them to relieve the trauma front and center. We try our best to ensure the process is as smooth and affects them as little as possible, but regardless, we know that our survivors will be negatively impacted. After all of this, there are still appeals, modification hearings, parole hearings. Years after the offense, we are still reaching out and dredging up these horrific memories. Then one day they receive a call or a letter from the Department of Corrections. Your offender is being released. I want you to picture all the hardship that just the system has put on our survivors through. After everything they've had to tolerate, sustain, I believe it is our duty to secure that they have every day that they can of knowing that their offender is still incarcerated, that there's no way for that person to hurt them or anyone else for that time period. They have walked the long path and met each requirement, met each ask. Therefore, it is our duty, our responsibility, and our privilege here today to ensure that our survivors receive the safety and security they deserve for every day possible. Thank you for your time.
Mr. Chair, Mr. Vice Chair, members of the committee, my name is Amanda Rodriguez. I am the Executive Director of Turnaround, which is the Rape Crisis Center for Baltimore County and City. I want to just start by showing appreciation for the survivor's family, or for the victim's family, and then also for Mr. Bates for testifying on this bill and leadership of yours, Mr. Chair, in sponsorship of this bill. I just want to start with the word accountability. We often hear this word usually in reference to someone not doing their job or a lack of transparency. But for those of us who work with survivors of sexual violence, intimate partner violence, and human trafficking, accountability is almost always in reference to an abusive person not being continuously enabled and allowed to escape consequences. This horrific event is not isolated. And turnaround, we know of multiple cases in which rapists have been released early and then reoffend. And these are crimes that never should have happened and victims that never should have to be. This piece of legislation is a tempered and common sense way to address this issue and to make our community safer. The greatest tragedy is that it took this horrific crime to get us to pay attention. Thank you so much for bringing this bill, Mr. Chair, and we ask for a favorable report.
Hello, my name is Eden Ryan. And I wanted to say thank you to Chairman Smith and members of this committee for hearing us today. So I'm supporting SB 1098, the Pava Marie LePere Act. I believe this reform is essential to ensuring justice for victims, preventing further harm, and protecting public safety. Pava was a guiding light in my life. I met her first as my employer, and she quickly became my best friend and mentor. She brought me to Baltimore to work at her company. A transplant herself, she loved this city with such a passion. I didn't even realize she wasn't from Baltimore until 6 months into knowing her. She convinced me quickly that Baltimore was exceptional, and I became a champion for the city just like her. Tragically, both Baltimore and I had her light taken away from us too soon. More sadly still, her death was avoidable. Pava was always great at finding flaws in systems, and today we can correct the flaw highlighted by her death. I would be remiss if I didn't share that Pava's death did take away a layer of security for me. Pava and I would often go see shows together in Baltimore. Now, when I try to plan those activities, I debate with myself if I should walk or if I should get an Uber. I text my friends as soon as I get to my car, and I lock the doors right away. This bill has given me hope. It provides a concrete data point on where the system can be fixed. We must pass this bill so that all current and future citizens of Baltimore and I can feel safe in this city that Pava fell in love with. Thank you.
Thank you all very much for your testimony. Any questions from the committee? All right, seeing none, thank you all very much for taking the time.
Thank you.
All right, have I missed anyone that's here to testify in favor? All right, we'll now switch to the opposition panel. Is Gabriel Ellenberger here? Marguerite Luneau? Marguerite Luneau. And then we have someone testifying virtually. Annie Kirsch is testifying virtually. Welcome.
Good afternoon. My name is Gabrielle Ellenberger, and I'm coming to you not just as a supervising attorney in the Public Defender's Office, but also as someone who has lost a loved one to violent crime. It is not lost on me the serious nature of these kinds of charges, but this bill will not improve the safety of any of us in the community. All it does is increase sentence lengths. This bill is focusing on the wrong thing to fix a serious and very real problem. People convicted of sexual offenses need real treatment. Right now, we incarcerate them, release them without therapy and treatment, and hope they will get treatment after they are released. The real way to decrease recidivism and improve our safety would be to actually offer evidence-based sexual abuser intervention in the DOC itself before release. This bill simply de-incentivizes people from engaging in the kind of rehabilitative conduct we want in the DOC. Diminution credits only come into play once someone has been denied parole. You only get released on diminution credits if you're not getting released on parole. So these individuals will still be released from prison eventually, but having engaged in what programming? Diminution credits are earned for staying out of trouble, but also for engaging in drug treatment, anger management, victim impact classes, education, and working important jobs in the DOC. Behavior that keeps people positively engaged and makes the DOC a safer and more rehabilitative place for all incarcerated people, and as a result, our community as they re-enter society. The number of diminution credits people can earn for crimes of violence are already limited. It's not the same as for not crime of violence. This bill, all it does is increase sentence lengths. The targeted people are still going to be released, still without any kind of discretion, just without the incentive to engage in important rehabilitative efforts beforehand. I urge you instead to think about proactive steps that could be taken that would actually achieve the goal here. Using the money it would cost for lengthier detention to instead institute programming that would make our community safer. Without having diminution credits, even if we instituted therapy and training, individuals who are incarcerated for these offenses would have absolutely no incentive to attend it. Thank you.
Good afternoon. My name is Marguerite Leno, and I'm the District Public Defender for Baltimore City. We are asking for an unfavorable report on this bill because it will fail to improve community safety in any meaningful way. The bill considers only the front end of the harm sought to be addressed. Diminution credits in practice only matter if you have been denied parole. As an example to illustrate why this legislation does not reach the harm it seeks to address, consider a person convicted of rape and sentenced to 30 years at age 21, serving day for day that they will be about 50 or 51 years old upon release. Locked away for 30 years, this person's incarceration will reinforce that there is no benefit to taking steps to improve and understand the behavior that charged their offense. They will not be encouraged to acknowledge and address the role in the harm that was caused to others. As they reintegrate back into society, this bill achieves nothing to ensure that the safety of the community is improved. To the contrary, eliminating diminution credits will have the unintended impact of increased likelihood that interventions are provided, thus increasing the possibility of recidivism. How is removing diminution credits contributing to reducing recidivism in this instance? It is not. Delaying harm is not diminishing harm. There is a need to be forward-thinking and not only address the front end and punitive portion, but look to address what is implemented to reduce recidivism for those who are going to be released. We know that interventions work with individuals who have committed sex offenses and that these interventions discourage recidivism. Diminution credits can be tied to programming, as you heard. Currently, individuals are not being offered or required rehabilitative program or therapy while they are committed. In my experience, this results in people that are sitting idle and not earning the category of DIM credits based on programming. They are then eventually released. To best serve the community, the victims, and prevent the focus, and prevention, the focus should be looking to thoughtful and holistic interventions that satisfy the victim's desire for consequences, but address the community's need for safety upon re-entry.
Excellent. Thank you. We're going to hear from our virtual panelists and we'll take questions. Ms. Kirsch.
Thank you, Mr. Chair and members of the committee. I've heard a lot of focus on what happens behind the walls. And I want to say, first of all, that life sentences are imposable on every first-degree rape charge. So when somebody has less than a life sentence for first-degree rape, that was a judicial choice. Life sentences would require them to be released on parole under any circumstances. And the only thing that diminution credits do is slightly change that parole eligibility and give motivation to participate in the in-house programming. So moving through the in-house programming, which has been exhaustively spoken about, there is also a serious problem in the community with a lack of treatment for people who are convicted of crimes of a sexual nature, including first-degree rape, but really including anyone that falls into that entire category. And that is a serious issue. There are incredible barriers that are faced by people with housing, with work, and with a very old system that we use that was based on a 90s containment model and hasn't been reviewed in decades. I would urge, instead of trying to somehow make a life sentence even more harsh than it already is, which really is not possible and will not make a meaningful change to time served, that we really invest in the system, both behind the walls, as has been said, but really outside the walls. What is the COMET supervision system really like? What type of resources do those officers need in order to conduct that supervision? What type of treatment is being offered and how effective is it? We need to talk to clinicians. We need to talk to parole agents. We need to talk to community service workers. We need to talk to survivors, and we need to talk to people with lived experience and reevaluate a system that has been sitting in Maryland for decades and clearly is not working.
So thank you very much. What questions from the committee? Senator Folden.
Thank you, Mr. Chairman. If you want to, I have a question for you, ma'am.
Yes.
So you mentioned that on more than one occasion during your testimony, you said extends the sentence length,
Yes.
extends the sentence length. That's what I took away from your testimony. My question is, are they ever serving the sentence length that they're imposed ever? Is there a chance they can serve the sentence given at court?
If you remove diminution credits, yes, they will serve.
No, I'm not asking that. I'm asking now. You're saying extending the length. What I'm saying is that they're never actually serving the length that is imposed.
They are serving it minus diminution credits. So if an individual doesn't engage in any programming.
It's not just diminution credits though. There's other things like you're.
So there's only two ways to be released from prison. One is through parole. And as we heard from the state's attorney, 11 people made parole out of how many hundreds of people. So in the vast majority of people are not receiving parole for these kinds of crimes. That is one way to be released early. The second way to be released early is through diminution credits. And that's it. There's no other early release.
Correct. So if they're not being released on parole, because clearly there's there's a feeling by the people evaluating this person that they still present a danger to society. We have these diminution credits that reduce these sentences significantly.
They do not reduce the sentences that significantly for crimes of violence. You see the 30 days, I believe.
Did you just miss the testimony that I heard?
Well, so there's a distinction between crimes of violence and non-crimes of violence. So the maximum that you can earn diminution credits for a non-crime of violence is 30 days a month. I work in the post-conviction division. So my clients are all clients who have been serving very lengthy sentences. I've never seen someone earn that many days, even on a non-crime of violence.
Crimes of violence are accrued at what rate?
It's they get 5 days of good time credit per month, and then they can earn up to 15. Again, I have never.
So they can get 20 days.
No, they can earn 15 total.
A month.
Yes. But again, in my experience, I have never seen someone earn that much.
Mr. Billingsby must have done that because he got a 14-year sentence. He got out in 7 years. He must have hit every single tick mark on that.
I unfortunately, I don't believe
that was an accelerated course. He got every single dim credit available.
That's my point. Is that there's accelerated measures in place, and you keep talking about extending sentence length. Here's an idea. Why don't we hold people accountable to the length of the sentence that they get and incentivize good behavior by outdoor rec time or commissary privileges or things of that nature? Why are we doing it by putting the community at risk and reducing these sentences of these violent offenders in such a significant manner? That seems reckless to me that that's what we're basically advocating for.
Every single person that's in the prison is a human, and they all deserve to be outdoors and see the sunshine.
Sure.
And it sounds like what you are recommending is that we only let some people do that.
No. What I said was incentivize good behavior by adding outdoor time, rec time, commissary privileges, because they are a privilege. So you and I will have to agree to disagree because you feel that everybody is a human being, but some of these people have been, and you clearly haven't been on some of these cases where these people are the worst perpetrators and assault people and victimize their victims in a manner that is so gruesome and brutal that there is no excuse for them. There's no reason to ever reintegrate them back into society.
Well, but the reality is that every single individual affected by this bill is coming back to our society. So the question is,
yes,
are they coming back having done this kind of treatment and these kinds of programs, or are they just going to the expiration of their sentence with no treatment and no?
I think we do. This state does a great job of providing treatment to inmates, our inmate population. We provide them with education opportunities. I know my tax dollars go to pay for some of that. I don't know about yours, mine do.
With all due respect, my clients are not getting sexual offender treatment in the DOC.
Okay, so, and then I guess I just don't understand when you're saying how it fails our citizens by keeping these people that are these worst perpetrators that prey on this vulnerable part of our community out of our community. How does that fail us?
I believe Ms. Leno put it the best. You're delaying it. You're not stopping it.
So we're still keeping people safe during the delay.
But in the meantime, instead of delaying, we could be implementing policies that would actually make them safe when they are released.
Or we could do what this bill recommends and provide those services that everybody wants to talk about, all the wonderful things that the feel-good services of mental health and everything else, and that people know how to answer certain questions, and and there's no real results until they're reintegrated back into society. And I'm not saying there aren't people that go back in and reintegrate just fine, but what I'm saying is the people that are assaulting and preying on vulnerable people within our communities and committing these horrific acts should be punished, and they should be punished to the extent that the law will allow. Because if you get a 20-year sentence, or like this, the chairman said, gets it knocked down to a 14-year sentence and only serves 7, there was never a chance to serve him 14 years, not ever.
And with all due respect, that's not actually what happened in this case. And I will just say that these are not feel-good measures. These are measures that actually affect an individual's thought process, the way they are engaging with other people. There are victim impact programs that make them think about what they have done and engage with it in a very real way. And these are all things that the DOC is a society in and of itself, right? And so if you have people in there that are not in any way engaging in any kind of programming, working, or anything, it makes it less safe for everybody else in the DOC. And the better environment that it is, the better it is for us as a society when other people are released as well. It is not, we don't isolate violent offenders in one tier and have everybody else somewhere else. It is an entire universe where there's a large number of people. And so if we are just having a group of people sitting and not having any incentive to do anything.
So is it your testimony today that there are no services being provided to these people that
I have
commit
never
rapes?
seen a client get sexual offense intervention in the DOC.
Okay. And then there was a comment made about, and I'll just close on this, the comment about that it's a very old system. I agree. It is a very old system. These DIM credits should never have come out. They need to go away. It's for these most violent people. We tried it. It's failed. It needs to be a reduced amount of, we don't need to do 1-for-1 to where you can get up to 30 days. You can still incentivize good behavior, but the rate of 1 to 30 days in a month, or 15 days in a month, it's way too high.
Again,
So I
that's
appreciate
not
it.
what's happening in reality.
And what you're speaking
Well,
to,
apparently I don't
what you're
know what's-
speaking to is a sentencing issue. What you're speaking
No,
to
ma'am.
is.
No, ma'am.
You're speaking to is that with a sentence that was imposed of.
Could you come to the, I'm sorry, can you come to the podium so we could,
Sure,
thank you very
my
much.
apologies. What you're speaking to is where there was a sentence that was imposed with a certain period of time that has been
So-
suspended, and that the amount of time for the suspended sentence that has been served. Those factors are considered by the judge when they are imposing the time. So when your suggestion that the diminution credits, that a judge is not considering that in their calculations of what they are sentencing a person to, along with the sentencing guidelines, fails to consider the whole picture. In addition, I might remind you that Maryland incarcerates more Black men than most other states in this country. So where you're saying that diminution credits will be just totally taken away and not utilized, where are we housing all of the
So,
people when
I
when
appreciate
part
your
of
comments. I
of
appreciate your
diminution
comments.
credits are
I
utilized
appreciate your
as
comments.
a
That's not my
population
question to you.
control?
It's not my question to you, ma'am. You're trying to go off on and create this narrative. Let's focus on my question. My question is that we have an old system that these diminution credits are failing. I don't care about it. These aren't applied according to anything other than the offense. My question was, when we have a judge that gives a sentence, there is zero chance that subject, the convicted person will ever serve that amount of time. That's a flawed system. There is zero chance that they'll ever serve the full term. Is there?
And respectfully,
Is there any chance?
Senator, let's
And
let her,
respectfully,
the
my
witness
an-
answer the question,
My
please.
answer to you is that is a sentencing issue in the calculation of the amount of time served. That is a sentencing
Ma'am.
issue that diminution credits are considered in the calculation of the sentence. So you are right.
That's all I needed to hear,
Because
because that's right.
this state-
All right,
Thank you.
Okay, hold on. Let me just create some space. We'll let the witness please respond. Thank you very much. Let's give her some space. Thank you. Please.
Because the state utilizes diminution credits, that is something that is considered in the calculation of the sentence. What this bill is speaking to is not going to eradicate diminution credits. So again.
Yeah. I'll just say what I was going to ask you earlier, and I think I'm still right on this, because you're right. It's a blend, right? The sentencing decision and then also the application of the dim credits, of the diminution credits. Mr. Billingsby was sentenced to 30 years with all but 16 years suspended, which means he was basically going to serve 14 years. Then you subtract the diminution credits from that 14 years. And what I meant when I said this, because he must have hit like every tick mark because he was out in 7 years. So tell me what I'm wrong about on that.
So if
How did he get out in 7 years when he was, because I know it's a sentencing thing, because he was really sentenced to 14 years. Then you apply the diminution credits and he's out. So maybe we're just talking about the same thing in a different way. I'm just trying to understand.
And I just want to make sure that, again, this is an active case, so I'm not going to speak to the directly to an individual. During the time of the pandemic, there were no programs being offered. One of the ways to earn diminution credits is through programming. Another way to earn diminution credits is the good time credit that you receive that is differentiated based upon whether you have a crime of violence or you do not fall into a crime of violence. That pool of credit is utilized for safety within all of those things. What you are asking about, again, not speaking specific to any case, is in addition to the credits that you earn just for showing up, just for being sentenced, adding to that by engaging in services and things of that nature. And what Ms. Ellenberg was speaking to is that in order to receive the maximum number when you have been sentenced to a crime of violence, you would have to engage in programming. From the experience that Ms. Ellenberg is speaking to with past clients that have for post-conviction, there is no amount of programming that is offered that should, or we have seen, get you to that place.
Understood. Yeah, but somehow, some way, Mr. Billingsby got 7 years knocked off through dim credits, and I mean, so he earned them somehow. I mean, it wasn't just like hence, yeah.
I'm sorry, I don't mean to cut you off.
No. I'm sorry. Yeah, that was a question. I'm actually genuinely curious about this because somehow this happened.
If I may.
Yeah, of course. Yeah.
It's delicate. I would suggest that it is.
Can't answer it. Yeah.
It is possible. It is possible to get his time credit record and see what happened. And I would
suggest
from the commissioner's office, and I would suggest that may answer your question.
Got it. And then just for the record, I wanted to make sure that because for the fiscal note says that it's about they receive about average 14 incarcerated individuals annually convicted of first degree rape with an average sentence of 26 years. It's 14 people annually. And then Department of Corrections sent us over some information. It says between FY24, and I think you referenced some of these numbers, and FY23, there were 199 incarcerated individuals who were released due to diminution credits who have had their charges of rape, first degree sex offense, first degree or rape or first degree sex offense and or both. And then there were, you mentioned this number, 11 incarcerated individuals who were released on parole between FY2014 and FY2023 who had rape in the first degree or first degree sex offense or both. So
yeah, may I respond to that?
Yeah.
I do think that statistic is a little misleading. It sounds like so many people are making so many diminution credits and getting out early, but the reality is it's just only the small number are getting out through parole, and so everybody else is being automatically released.
No, yes.
Yeah, the question is, are they doing that? I mean, in my experience on a 30-year sentence for a crime of violence, my client is maybe getting 5 years of diminution credits if they're doing amazingly, if they're engaged in programming. And so we're not talking about huge differences. We're just talking about they're getting automatically released, but what are they doing in that time, in that, quite frankly, small percentage of the sentence.
I think we agree on one thing. That's exactly what I was saying. This bill applies to a small percentage of people. Was my
No, it applies to a huge percentage of people.
14 people a year coming in.
14 people a year are getting paroled. The remainder of them are
14 people a year incarcerated on average every year. New people coming into that system.
I'm sorry.
Yeah.
I misheard. I'm sorry.
Yeah. So 14 new inputs every year putting into that cycle. So
that is every
small.
Human is.
I understand that, but I'm just saying that relatively speaking.
Yeah. And the number of, it may be 14 per year on average, but again, they're not getting paroled. They're a large portion of who is serving long sentences in the DOC, a big portion of who is there the longest.
Yeah, I was just referencing the fiscal note that as this bill applies, it's 14 people coming in every year that this bill would apply to, because this bill only applies prospectively, not retroactively. So the people that are in, this bill doesn't apply to.
Yes, I agree with that. It does
Yeah.
not apply retroactively.
Okay, excellent. Thank you very much. Thank you. All right, with that, that'll end the hearing for Senate Bill 1098. We'll now move on to Senator Watson, Senate Bill 351.
Good afternoon, Chair Smith, Vice Chair Wallstreicher, and colleagues. This is the easiest bill of the day for you. Senator from the 23rd District, here to present and ask your support for Maryland Senate Bill 351. This proposed legislation seeks to clarify the Maryland first-degree assault statute, which is Criminal Law Article 3-202B. Specifically, the bill seeks to add a single word, intentionally, to 3-202, so that it would now read, a person may not intentionally commit an assault with a firearm. So let me just bring your attention to that statute. B1, a person may not intentionally cause or attempt to cause serious physical injury to another. B2, a person may not commit an assault with a firearm. B3, a person may not intentionally do something with respect to rape. And so you may have seen that the U.S. Court of Appeals in the Fourth Circuit recently ruled that Maryland law was ambiguous as to the mens rea required for violation of 3-202B. And that was identified in United States versus Red. So as a result, the court held that prior Maryland first-degree assault convictions could not be used for federal sentencing enhancements for recidivist criminal offenders who are prosecuted in federal court. This ruling appears to be at odds with Maryland law. Specifically, Maryland courts have held categorically that first-degree assault is a specific intent crime, although admittedly, this analysis did not distinguish with B1 and B2, which I just read to you. My written testimony has a few cases in here that you can look at, but the bottom line is that the Fourth Circuit ruled that there was not a Maryland case directly on point as to the mens rea required for a B2 offense. Further, because B1 and B3, which I also just read, expressly required intentional conduct, but the statute for B2 was silent on the issue. The court held the statute was ambiguous and perhaps purposely omitted an intentional mens rea. Accordingly, we presently have a situation where Maryland courts are interpreting B2 in one manner, and the federal courts are interpreting the mens rea requirement in B2 in a different manner. This bill, Senate Bill 531, would bring clarity to the issue and would harmonize Maryland's first-degree assault statute to have a unitary mens rea requirement. The bill will also hopefully distinguish first-degree assault from second-degree assault and reckless endangerment, both of which require a lower mens rea requirement, bringing federal law into harmony with state law regarding sentencing enhancements, which require enhancements under state law for prior first-degree assault conditions. Thank you for the opportunity to provide this information and ask for your support.
Excellent. Seeing no questions, thank you very much, Senator Watson. And God bless you for being quick. That's awesome. All right. All right. We have one witness signed up in opposition. Let's hear from Christine Rickard.
Thank you, Chairman, Vice Chairman, and members of the Judicial Proceedings Committee. My name is Christine Dula-Rickard. I'm the Deputy State's Attorney for Queen Anne's County. I'm also here on behalf of the Maryland State's Attorneys Association in opposition to Senate Bill 351, and I'm here to respectfully request an unfavorable report. While I understand the overall goal of the bill is to achieve sentencing enhancements, it's putting the cart before the horse. You need a conviction before you can proceed to sentencing. The addition of intentionally is wholly unreasonable and unnecessary as it relates to the assault of someone with a firearm. The element of a firearm in and of itself sets it apart from a second-degree assault.
As the Maryland appellate courts have stated, the firearm itself aggravates the offense upward from the misdemeanor. When someone aims a misdemeanor at another, the intentionality is inherent. What else can be construed from the action? Why add the word intentionally? Shooting the firearm and aiming the firearm are two different actions. The aim itself is one first-degree assault and the shooting is a separate crime. There is a reason for the expression, it's like there's a reason for the expression bringing a gun to a knife fight. The gun has the inherent advantage. Guns are deadly weapons. Unfortunately, as a prosecutor, domestic violence is a routine crime in the criminal docket. All too often, abusers have firearms at their disposal as they terrorize their victims. Sometimes fists and feet are surpassed by fear. If an abuser has a gun, the state needs to be armed with the law. And if we want enhanced penalties, we need to get the conviction first. Adding intentionally reduces that ability. For these reasons, I respectfully request an unfavorable report on Senate Bill 351. Thank you.
Thank you very much. I was trying to grasp all of that. The senator is saying that the court, I guess, had some opinion where they thought it was some gray area. So he's trying to, I guess, to minimize the gray area. And you all are saying by adding the intent of this, it makes it worse?
I do. Specifically because of juries are a part of the problem. And not they're part of the problem, but when you are having to get a unanimous verdict, when you add an additional element, that's one more thing to consider. And intentionally, it's inherent.
You say it's already there.
I'm sorry?
It's baked into the statute.
It is.
So what was the court that he referenced? Because I'm not familiar with the case, and I don't know if you are, but
I'm not the specific case that he's talking about, but just that it bridges that gap between the federal sentencing enhancement. And I'm just saying we need a conviction first before we can get to the sentencing.
gotcha. All right, thank you.
Thank you.
All right, seeing no further questions, thank you very much.
Thank you very much.
All right, with that, that'll conclude the hearing for Senate Bill 351. Thank you, Senator Watson. Is Ellis here? We'll go on. We're going to move on to Senator Carter, Senate Bill 729.
Thank you, Mr. Chair and members of the committee. I do have some proposed witnesses, but they may not be in the room, so I'll say their names. So if they're listening in the hall, they will know that it's time to come in for Senate Bill 729. So that's Dolores Sanchez or Jane Krienke from the Maryland Hospital Association, Andrew Nicholas from Adventist Healthcare. And with that, I will go ahead and begin my testimony. So, Mr. Chair and members of the committee, last year we passed Senate Bill 729, which ensured proper reporting of physical interventions for security guards. And the bill required that the Maryland Police Training and Standards Commission identify or establish certain training programs for certification of security guards. Here they are. Prior to the passage of this bill, there were no real standards, and there were unlicensed and unregulated, largely, security guards. There were no training requirements unless a security guard applied for a handgun permit. There was also no tracking requirement or system to monitor a security guard's appropriate use of force. The purpose of the original bill was to establish these minimal standards and oversight of private security. As you know, we have seen multiple people that have lost their lives at the hands of security guards in Baltimore and other places over the past number of years. The broad language of last year's bill included hospitals and hospital security, and so in contrast to most of the establishment covered by the bill, Hospitals are regulated at the state and federal level by Centers for Medical and Medicaid Services, the Joint Commission on the Office of Health Care Quality. The intent of Senate Bill 729 is to address these concerns raised by the hospital field with complying with the law. There is concern that the definition of use of force includes actions that security guards are routinely to take when they are doing their jobs and to protect health and well-being of patients, staff, and visitors. Without modification to the law, there could be unintended consequences, including reporting patient information that should be protected under federal law, increased reports submitted to the state that do not meet the spirit of the original law due to the frequency with which hospital security guards use force at the direction of clinicians to preserve a patient's health and well-being or to protect patient staff and visitors. Duplicative reporting from hospitals, which are already required to report to the Maryland Office of Healthcare Quality when a level 1 event occurs, meaning a death or serious disability. Working with House sponsor and proponents on amendments to address these concerns, we need to make some changes to this bill, but this is a necessary step in furtherance of the intent of the original bill, but also to make sure that we don't have unintended consequences for hospitals and medical services, healthcare facilities. So I would urge a favorable report. And with that, I will call the witnesses. Thank you.
Good evening, Mr. Chairman and members of the committee. My name is Delora Sanchez-Ficalche with Cornerstone Government Affairs, representing MHA on this bill. So the impetus for this legislation last year, you've heard from Senator Carter, she laid it out nicely. But as you also know, healthcare is heavily regulated. And the same is true for the requirements that hospitals must meet for security guards. Hospitals complete background checks. Healthcare security is under the scrutiny of CMS and the Joint Commission and the Office of Healthcare Quality. Training hours for hospital security guards exceed the 12-hour minimum in last year's bill, and reporting and investigation requirements are already well established and used, including to the Department of Health. This legislation is desperately needed because hospitals will face a framework unique to what others under the purview of the legislation do not. Incidences are also unique in the hospital setting as emotions often run high. Healthcare interventions or instances where, for example, a person is not a patient, but assaults a patient that's in the hospital from a conflict that has now rolled into the hospital. There's different reporting requirements that hospitals would be subject to under the current framework that we would like to see changed. And so we're working through that with the sponsor in the Senate and also the sponsor in the House. We're working very diligently, and we appreciate you hearing this bill today, and we hope that you will support it with amendments that will come in short order from the sponsor. So we do urge a favorable report with those amendments. Thank you very much.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Andrew Nicholas. I oversee government relations for Adventist Healthcare. We are headquartered in Montgomery County and operate 3 acute care hospitals in the state. First, I'm going to start off by thanking the bill sponsor very much for putting in this bill and for working with us and recognizing that hospitals are a little bit different in this space. I'll start off by saying for Adventist Healthcare, we approach security trying to strike a balance, right? We run hospitals. We want to have a welcoming environment that promotes wellness and healing. But we also must ensure that we have adequate security presence to ensure the safety of our patients, our visitors, and our staff. And so that's the balance we try to strike. We do that by having a well-trained security force that has advanced training from an internationally recognized organization in de-escalation and person-centered behavioral management. That training does have annual continuing education every year, either 4 or 8 hours each year. And the entire security system for us and all hospitals is overseen or operates under the purview of various regulatory bodies, as you heard.
Both CMS and the Joint Commission have training requirements for security guards and other staff members. And the patient safety program operated out of the Department of Health is really a comprehensive oversight where when incidents occur, it's not just a training regimen, but there is reporting. And it's not just reporting, oh, something happened, file it away. There's an in-depth root cause analysis that is done and reported along with any, remedial action steps that must be taken. And then the Department of Health collects that data from all of the hospitals and they publicly report it. So it really is very comprehensive, and there is teeth in that legislation. Not that we wouldn't comply, but it is there, fines and up to hospital license revocation. And the thing with that program is it's specifically designed for hospitals, so it is HIPAA compliant. It considers the other factors that hospitals face as far as restraints that need to be used as part of medical care, particularly when you get into behavioral health care and other patients. And those are the issues we're looking to address right now through amendments, working with the sponsors and others. So thank you again, and we'll hope you'll support this bill with a favorable report with the amendments. Thank you.
Thank you, Mr. Chairman. Peggy Townsend on behalf of the Maryland Hospital Association. We too are in support of this bill. As you know, well, you may not know, but hospitals experience the most amount of workplace violence amongst any industry that's out there. It is very, very dangerous place, and it's getting worse. Our staff is getting hit, kicked, spit, stabbed. So we have that to deal with. And so we take our security officers we treat their training requirements very seriously because of the incidents we serve. It's not like the mall situation where you have security guards and they're not, having people run in the emergency room and therefore and so forth. And as the previous panel also said, we have a lot of regulatory requirements already for hospital security guards. We also do background checks. So many of the requirements in the bill are already something we do, and having to do it again would make additional administrative burdens. And I do mention the workplace violence because I'm not sure people have an appreciation of how many reports would be sent from a hospital to the state police. This is an everyday occurrence. It's not a one-off in a shopping mall. So for those reasons, we would ask for a favorable report.
All right, thank you all very much. Questions from the committee? All right, seeing none, thank you all very much. Thank you, Senator Carter.
Thank you.
I think is anyone else here to testify on this bill? I think we've got everyone. All right, that'll conclude the hearing and testimony for Senate Bill 729. Senator Ellis is here. We'll move on to Senator Ellis with Senate Bill 817. I think I saw you on TV on this bill. Did I see you on TV on this one? I saw you.
I've had like 4 interviews with
Mr. Hollywood. All right, here we go. All right.
Put my best suit on.
It was good stuff. All right.
I have my panel here.
Sure,
Mr.
of course.
Chair.
Yes, please.
Good afternoon, Chair Smith, Vice Chair Wallstrike, and members of the Judicial Proceedings Committee. I'm Senator Arthur Ellis, representing Charles County District 28. I'm here today to present Senate Bill 817, Public Safety, Missing Persons with Cognitive Impairment, the Purple Alert Program. The Purple Alert Program. The purpose of this bill is to establish a Purple Alert system to disseminate information to assist in locating a missing person who suffers a cognitive impairment, intellectual or developmental disability, or brain injury who's not eligible for the Silver Alert Program. This system will expedite the ability for law enforcement to find a disabled missing person who does not fit into the categories of Silver or Amber Alert. In order to qualify to have an Amber Alert activated, the individual must be a child and abducted, 18 under. For a Silver Alert, the Maryland regulations state that an individual must be at least 60 years of age and have a cognitive impairment and be in danger. Let me divert a little bit from my written testimony to reiterate this phrase. For the civil alert, the Maryland regulations state that an individual must be at least 60 years of age. Maryland regulation. I repeated that because there's testimony information in our packet from state police saying that there is no law stating the age for civil alert, and they are true. So I know you committee members know the difference between regulations and laws. The laws are passed, so generally more guidance, and the department will take the law and create regulations. So both statements are true. The law does not say you have to be 60 years old, but the regulations of the state police says you have to be 60 years old to implement the Silver Alert program. So that's why we are here today to codify the requirement that individuals under 60 will get the benefits of the similar Silver Alert program. So let me get back to my written statement. So hopefully we will have a national Purple Alert system soon. That initiative failed in 2019 at the federal level, but Maryland can join other states, which I'll mention a little later, who have a Purple Alert system. I just want to go a little deeper into what brought us here. And we have these tremendous newspapers and TV reporters who do a lot of research in these areas. And I want to give a summary of a Washington Post article written last year, November 1, 2023, by Teresa Vargas. Give a background. As Jimmy Hall tells it, this is from the article, and this is Mr. Hall right here. After nearly a week of searching for his son, he no longer expected to find him alive. Mr. Hall said, "I had pretty much given up all hope," he told me in a recent afternoon. "I started checking in the woods and in the creek. My parents started looking in the dumpster. At that point, I was searching for a body. I was searching for my son's body." Mr. Hall had plenty of reasons to let the dark thoughts settle in his mind at that time. He knew the odds were against his son, Rashawn Williams. Rashawn is right here, this beautiful gentleman right here with his great suit and beautiful tie. He said, "I had plenty of reason to let that dark thought settle in his mind at that time. He knew the odds were against his son, Rashawn Williams, 31-year-old man with Down syndrome who doesn't speak much and wouldn't be able to ask for help." After Williams slipped away from his caretaker and boarded a bus, then a train, Hall and other family members searched from Maryland to DC for him. They searched through the night and woke up early to start searching again. And as they searched, they watched one day turn to 4 days, turn to 6 days. The gap just widened and widened and widened, Hall recalled. We were just waiting and waiting and waiting. If you follow the Williams story at the time, and I'm still reading from this Washington Post article, folks, you will know that it ended unexpectedly. On the 6th day, he was found in a room down the corridor at a metro stop. He had gone without water or food for nearly a week. But miraculously, he was alive and he was healthy. Yes, praise God. It would be easy for the Williams family to focus on that happy ending and move on. But they're here. They're here to support the passage of this bill. Mr. Hall said they can't because they can't just move on. They know how the search started unacceptably. Mr. Hall and his wife, Ms. Hall, Christina, right here to my right, said after they learned that Williams was missing, they expected their phones to buzz with an alert that would let the public know to keep a lookout for him. When that did not happen, let me say again, that did not happen, Christina Hall asked an officer to send one. The couple said that's when they learned that Mr. Williams did not meet Maryland's criteria for Amber Alert because he was over 18, which is for abducted children or did not meet the requirement for silver alert, which is for adults over the age of 60 based on regulation, their regulation interpretation of the law we passed. The couple is now trying to bring attention to that gap in the state's alert system in the hopes of pushing officials to find a way to send public alerts when disabled adults who are at risk of serious harm go missing. I want to say, we are fortunate, Mr. Hall said, but what about the next family? What about the next family? What with the next individual who goes missing? What will happen to them? Hopefully, because of these bills you're hearing today, that they will get the help they need. He would have been found that night, Mr. Hall said. People look at their phones when they ride the bus. So those people on the bus with him would have seen the alert. I know when I get those alerts, I look up and I look around. It's just natural. So too would have the people who rode the metro with him. I just want to remind you that Mr. Williams was on the bus and on the metro for hours and hours and hours. And he was found many days later in a metro station. Thousands of people went through the metro system during those almost week period. So here we are, where the family calls for expanded alert system is one that warrants our attention, especially when we consider how easily the Williams story could have ended differently. Let me fast forward to double asterisk this part of the article. It says the Maryland State Police, which established the state's Silver Alert program. Actually, we established it here, and they administer and write the regulations. The Silver Alert program lists among the required criteria, the missing person is at least 60 years old, unquote. Now that's a quote from the state police. You have to be 60. So that number is in their regulation. You have to be 60 years old to trigger the system. The national requirements for Amber Alert, which is aimed at helping abducted children, lists at least one criteria: the child is under 18. So we have that gap between 18 and 60. And the regulations of the Department of State Police says there's no help for those individuals. And the parents here can tell you that is what they told them. And that's what they told the reporters here for the distinguished Washington Post. So therefore, I'll just say Rashawn's disappearance, Mr. Williams, emphasized the urgent need for an updated Silver Alert law that explicitly address and protect individuals with disability. So we'll take this from the discretion of the department and the regulations and codify, put it into law, saying that individuals between 18 and 60 is covered by the Silver Alert. They are right. They can easily cover these individuals under the Silver Alert program. So they chose not to do it for whatever reason. So with hearing the testimony, ladies and gentlemen, colleagues, I ask for a favorable report on Senate Bill 817. Thank you, colleagues.
Thank you very much, Senator. We'll turn to whichever guest you'd like to have up first. That's your pleasure.
Mr. Williams.
Good afternoon. Before I get started, I would like to give a special thanks to Ms. Tara Augustine of the Cold Case Missing Persons Unit for Montgomery County Police Department, and Ms. Andrea Bell for WMATA Metro. Without their help in the latter days of my son being missing, I do not believe he would have been found alive. My name is Jimmy Hall, and this is my wife, Christina, and that is my son. I'm addressing a distressing incident involving our son Rashawn Williams on October 20th, 2023. Rashawn, who has Down syndrome and is nonverbal, wandered away from the care of We Achieve staff at a hotel in Silver Spring, where they were temporarily housed at. What ensued was a series of challenging and frustrating events from We Achieve staff. In our quest to locate him, shedding light on systematic deficiencies in our response protocols for vulnerable individuals. Despite immediate efforts in the first critical hours, Rashawn's disappearance plunged us into desperate searches. Our attempts to coordinate with We Achieve, the Montgomery County Police Department, and WMATA Metro were met with obstacles at every turn. Communication breakdowns, delayed responses, and bureaucratic hurdles hampered our ability to access critical information and footage that could have expedited the search and found him that very night. Throughout the ordeal, we encountered numerous roadblocks. Despite our pleas for assistance, our efforts to coordinate with law enforcement and transit authorities were met with inefficiencies and inadequate response. Our anguish was compounded by the lack of timely updates and cooperation from the relevant agencies. Leaving us feeling frustrated and anxious about Rashawn's safety. This experience highlights systematic gaps in handling cases involving vulnerable individuals. The disjointed communication and response mechanism exposes vulnerabilities in our system, underscoring the urgent, I repeat, the urgent need for reform to ensure a more efficient and collaborative approach in similar situations. Please, please, we urge your attention to this matter and request your support in advocating for policies that prioritize the safety and well-being of individuals like Rashawn. Improved coordination, communication, and training protocols are essential to prevent such distressing incidents in the future to safeguard the rights and dignity of individuals with special needs. It would be insensitive for this bill not to get passed because the Purple Alert can be the voice for future families. That voice that Rashawn didn't have. When other entities failed him, the public will definitely show up and show out. And that was proven when all the search parties was formed to find my son. Please, please pass this bill so no other family will have to endure the pain and anguish that we went through. I thank you.
Mr. Williams, thank you very much. And Mrs. Williams, thank you very much. And Rashawn, I followed this, and Senator, thank you for bringing it up. I followed this story on the news. I remember, and then we were praying every night and finally found in Glenmont. We were all very, very thankful that Rashawn was found okay. So Senator, thank you for bringing the bill, and for Rashawn and for Mr. Williams and Miss Williams, thank you all for spending the time to come down and testify on behalf of this piece of legislation. Are there any questions for the Senator? Senator Sidnor.
Senator, I know that you had talked about a gap.
I'm sorry.
I said you talked about a gap from the 18-year-olds to, I think you said 65.
Somehow I can't hear you, Senator.
You had talked about a gap.
A gap,
I think
yes.
you said 18 to 65-year-olds.
18 to 60, sir.
60. The question I have, because when you look at the letters of information from the Department of Disabilities and Maryland Developmental Disabilities Coalition, my read of what they're saying is they have the silver alert, and that's something that can be used. What do you see as what's the gap there that this family wasn't able to make use of the silver alert versus what you're attempting to do here?
Yeah, excellent question, Senator Sidnor. So that piece of information was also given an information statement from the state police. They can use the silver alert, but they don't because, as I said earlier, the regulation they put in place, which guide the officials who make these decisions, they put an age limit in there and saying under 60, no. Over 60, yes.
And if I might ask, so you said that's in the regs.
That's in the regs. So I looked it up. So the law we passed
doesn't say anything about it.
Doesn't say anything about it. So they're telling
they decided to narrow the program and that we passed.
Correct.
Thank you.
Yeah, they just narrowed it with the regulation that agencies pass and have to go through ALER.
Thank you.
Sure.
Thank you, Senator Sinner. Thank you, Senator Ellis. Further questions from the committee?
Thank you, Mr. Chair. Thank you, committee.
Thank you all very much. All right, with that, that'll conclude the hearing for Senate Bill 817. I see Senator Reedy is here, so we'll go on to Senator Reedy at Senate Bill 842.
I believe I have. Oh, yes, come on, I have a panel, Mr.
Yes.
Karen, I know you had to skip over me earlier, had a little situation to pick up a car repair. So I ran out and ran right back. Got here as fast as I could. So thank you. It's that time of year when our cars decide this is the best possible time to have a breakdown, is in the middle of the busiest period. So thank you very much. Mr. Chairman, Mr. Vice Chair, and members of the Judicial Proceedings Committee, Senator Justin Reedy here to present Senate Bill 842, which deals with protecting our sports officials here in 2024. And I don't know, I don't think I have to tell members of the committee or anybody that happens to be watching, we are seeing over the last several years, there has been an escalation of really bad and dangerous behavior aimed at people who are simply trying to help our children and teenagers and even in some cases recreationally adults have a good time and play a sport or play sports. And there are unfortunately some very bad examples, and a lot of us have seen it with our children in different ball fields at times, where sports officials are being abused and berated. Now, sometimes it just rises to the level of maybe some cranky comments, but other times it's risen to a point where an official is being verbally castigated and perhaps even physically assaulted at times. According to the National Association of Sports Officials, the NASO, close to 90% of all sports officials report being harassed while before, during, or after a sporting event. Over 50% of officials have said that the harassment has made them feel unsafe while officiating, and there are 13% of sports officials have been physically assaulted by a fan, coach, or player. What we're doing with Senate Bill 842 is specifying that a crime of misdemeanor second degree assault includes an assault against a sports official. Misdemeanor imposes a fine of up to $2,500 and or imprisonment not exceeding 10 years. Obviously, in this particular case, if it was a relatively minor assault in the second degree, we're not looking at that much time. But this would put them in a category where it's already, of course, illegal for any individual to assault a sports official, just like it would be illegal to assault anybody. But currently, sports officials are not included in Criminal Law 3-203, which authorizes police officers to make a warrantless arrest with probable cause under Criminal Law 2-203. So what SB 842 would do is specify that assault against a sports official can lead to an immediate arrest with proper probable cause. Team sports, particularly sports for our kids at every level, cannot exist properly without officials. And most of these officials are either doing it either sometimes even as a volunteer, but certainly or very lowly paid, banking $50 for umpiring a couple of baseball games or $25 a soccer game, or that some of them maybe, depending on the level, may make more than that. But quite a few of our sports officials are making a tiny little stipend to help our kids out and to make sure we have fun and kids can learn to play and be outside. So we're asking for Maryland to join 18 other states, including Pennsylvania, West Virginia, and California, in specifying that sports officials are included in second-degree assault. So I'd respectfully ask for your favorable report on SB 842. I'll make one more comment. Years ago, we considered this bill as a committee. I believe I was on it. And I was supportive, but I understood that there's hesitation sometimes with making these kind of changes. But I really believe, based on what we've seen, coming out of the pandemic period, it seems like a lot of folks have forgotten how to act in polite society. And we want to be sure that these are authority figures in the commission of trying to preside over a sporting event with lots of moving parts and kids particularly. So I think this is an appropriate step to take to protect these officials in our communities. So with that, Mr. President, of course, I'm happy to answer questions, but I assume we want to hear from our panel beforehand. So I'd like to hand it over. Who wants to go next? You want to go ahead? Yeah.
Well, first of all, good evening, Mr. Chair, Mr. Vice Chair, members of the committee. I'm here to ask for your support in Senate Bill 842. We came in 2021 to have the bill brought to you, and I made a promise to 103 sports officials that work for me under Baltimore's best umpires and 36,000 sports officials that reside in the state of Maryland that I will not stop until this bill passes. It's time. I have some updated numbers that 28 states now have walls that protect sports officials. In 2023, Arkansas, Texas, and who would know, the state of Hawaii passed a law to protect sports officials. The Commonwealth of Pennsylvania just passed a second bill. Their first bill protects us against physical assault. They've now passed an additional law that protects us against verbal assault. So we need to make this change, and this change needs to happen. We're losing too many sports officials at an incredible time. These two gentlemen are going to testify to their horrific actions that happened against them as being assaulted while they were trying to work baseball games. So at this point, I'll turn it over to these gentlemen. And again, I want to thank all the members that over the last 2 weeks, it was a great honor to meet some of you personally or meet some of your aides and talk to you through email. And again, we look for your support in this bill.
Good afternoon, Mr. Chair, Mr. Vice Chair. My name is Dave Collier. I was assaulted at a baseball game, a rec game, by a parent. I was knocked down, hit my head against the fence there, never went to the hospital. Even went to the Baltimore City state's attorney the next morning, and they said there was nothing they could do. So I am all for this bill. This bill needs to be passed to keep the officials that we have, including the new ones that are coming in who are being berated on the field. So I really do encourage all of you to pass this bill. Thank you.
Good evening, everyone, and thank you for your time. My name is Ryan Adamski. I've been part of BBUA for 12 years now. We joined an organization called RBI Baseball last season, which is an organization ran through the Baltimore Orioles to help inner city kids, instead of being out in the streets, get them into some organized programs and organized sporting events to have them excel that way and get a recognition on that. What happened was, in the championship game, this was at Northwood Field, which is on the edge of the Morgan State campus. Mind you, because of the RBI baseball, this is a free league to any team that want to participate. So instead of Northwood combining their tournament team into one team, they wanted to get all their kids exposure and split their team up into two teams. Both of these teams made it to the championship game. So you have a team playing against their own guys. Everything is fun, fine, dandy during the game, end up being a close game at the end. I ended up walking back to my car with me and my two partners. I am getting undressed at my car. The way my car is parked, I pulled into the parking spot and my umpire bag is in the trunk of my car. I am now currently getting undressed. This gentleman walked up to us. My other two partners are standing right next to me in their cars getting undressed as well. I have all the umpire gear on, so I, of course, have to take the most amount of time to get undressed behind the plate. He walks up, he asks for our names. I give him my name, blah, 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 and all the good stuff. Next thing out of his mouth was, I came over here just to tell you, you bleeping suck. I took it with a grain of salt at first, and I said, sir, I appreciate your opinion. Thank you so much. I went from me going from behind the truck to my side door to get undressed to try to de-escalate the situation. The gentleman continued to stand right behind my car. My two partners started stepping in between saying, sir, you've made your point known. It is okay. You can leave now. This is the part I think you guys that irritated me. That is the reason I came here today. He said verbatim, I have the right to stand here. And then he leaned over the car and said, and you bleeping suck. That's when I turned around to him and I started taking a few steps toward him, and it would have been an altercation if the two umpires did not step in between us and was able to separate us. Not only that, on the way home, I was definitely driving aggressively, just because I was so angry, shaken, and everything, to a point where I even called him and told him I want no more games at all. But me being as strong as I am, I was able to de-escalate over a little bit and able to come back. And this year I'm actually joining the high school organization, get more recognition as well, and hopefully to get more protection and get more advancement in my mechanics as well. So thank you for your time.
Excellent. Thank you, Senator Reed. Thank you all for your testimony and for sharing your stories. Questions from the committee? All right, excellent. Thank you all very much. Thanks.
Thank you.
Got two bills. I'm going to go real quick, and then we two senators. So we're going to go Senate Bill 1101, and then we're going to go with Senate Bill 758, and then 905, and then we'll wrap up with 1097. Oh, which bill is she here for? Okay, let's do that then. So we'll go Senate Bill 758, and then I'll jump to, and then we'll kind of say, absolutely.
Give her support and then run out the door.
Of course.
She's got to be able to.
Thank you for joining us. Good to see you.
Yeah, okay. She's being very patient and kind with me. Thank you so much.
Excellent.
Thank you, Mr. Chairman, members of the committee. Great to see you all here today. This is Senate Bill 758, Sex Crimes, Definition of Consent and Repeal of Force. I would like to thank all the 9 co-sponsors on this committee, and especially the chair for agreeing to be the lead co-sponsor of this bill. I think most of you here know that I never want to do sex crimes bills for a lot of complex reasons. We've been talking about them all day. They intersect with race and class and gender and power and history in a way that's really uncomfortable for a lot of us. And I never wanted to get caught up in this morass because people feel these issues really deeply and personally, and yet here I am. I'm here because I think there's kind of a fundamental moral flaw in the construction of our second-degree rape statute. And I think that the law really needs to be modernized. The statute is stuck back in a kind of old-timey victim blaming frame that puts the burden on the victim to prove that they were threatened with force instead of putting the burden on the court to determine if consent was present. So this bill is going to codify a definition of consent based on existing case law and remove the required force or threat of force language. Many states already do this. You can see this in the written testimony. So it's not revolutionary. Members on my panel are going to give you examples of cases that could not be brought because of Maryland's outdated law. There's really a gap between the public belief about what constitutes rape and what's in our statute, which is what this bill is trying to address. I am a mother of a daughter and a son. We've been talking all day, I think, from that lens in multiple perspectives. I really do think that what we teach our sons about consent, when we teach our sons about consent, we're not teaching them that they can, I don't mean to be graphic, but we're not teaching them that they can try to do whatever they want, whenever they want, so long as they don't threaten force. We're teaching them to make sure that everyone is consenting. And in fact, in 2018, we passed legislation the Senate voted for unanimously to ensure that consent was taught in our sexuality education curriculum. That was a bill that my daughter, who was in middle school at the time, came up with. Just a little update, because my daughter's now in college, as is my stepdaughter. My stepdaughter, within 1 month in college, had a good friend who was raped. My daughter, within 1 week of entering college, had a good friend who was raped. So this is something that I think we really do need to address. You're going to hear testimony from experts in sexual trauma who talk about the fact that there are multiple responses. One is fight, one is flight, and another is freeze. We need the law to acknowledge that freeze is a reasonable response. If a victim freezes, that can't be prosecuted in Maryland right now. I think that's just not right. I want to make clear that this is not an affirmative consent bill. It doesn't require a written contract. It looks at the totality of circumstances. We have, I think, 6 people to speak on the first panel. So I want to run through them before we do a round of questions, so you get the full sort of perspective from both the state's attorneys and the victims. And I will have, if it's okay, State's Attorney Brayboy go first, since she has to run out to Baltimore.
Thank you. Thank you so much.
Thank you.
Thank you so much, Senator. Good evening, Chairman Smith and members of the committee. For the record, I'm Aisha Braveboy, State's Attorney for Prince George's County, here to express my strong support for Senate Bill 758 and urge a favorable report by this committee. A prosecutor examines many factors in making a determination as to whether he or she can prosecute a rape case. These factors may include how the assault occurred, where the assault occurred, and what was said by either party during or before the assault, amongst other details. However, under the current law, a lack of force or threat of force is a full stop to prosecution. No matter what other factors are present, the state will not be able to prosecute cases where force is lacking. This, of course, includes the well-documented and well-researched scenarios where a victim freezes as an involuntary response to a traumatic situation. Senate Bill 758 strikes the absolute requirement of force or threat of force for the state to proceed with a prosecution. This allows prosecutors to examine and give appropriate weight to the totality of the circumstances in every rape case we investigate. Please let me reassure you that this change in law will not open the floodgates. Unfortunately, Prince George's County is one of the jurisdictions in Maryland with the most reported rape cases on an annual basis. The ASAs in my special victims unit carry an average caseload of between 50 and 80 indicted cases. However, they are skilled prosecutors who are already engaging in totality of the circumstances evaluations when making charging decisions in all cases. It's just that those decisions are currently limited by the requirement in the cases of rape to force or threat of force. I am confident that my attorneys will continue to exercise good judgment when making these decisions. Thank you very much, and I urge a favorable report. And so I'm so sorry, Mr. Chair, that I've got to run, but thank you so much.
Hey, thank you for hanging in there with us. Safe travels.
Yes. Oh. I'm just going to introduce and make sure the rest of the panel is called up. So we'll hear from Lisa Jordan, Asia Rodriguez. I believe we have Ivan Bates is still here, and Joyce King, and that will be the first panel.
Good afternoon, Mr. Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of Senate Bill 758. Thank you, Senator Kelly, for your continued leadership despite your distaste for sex crimes bills. Thank you, Chair Smith and the other co-sponsors, but thank you especially to the survivors who have come here today to share their stories. The bill corrects a very real problem in our sex crimes laws, and Senator Kelly's provided an excellent description of the problem. My role today is to talk about how Senate Bill 758 fixes it. So currently in the second-degree rape statute, 3 things have to be proven: the sexual conduct involved, the lack of consent, and either force or threat of force. And so Senate Bill 758 strikes the words force or threat of force from second-degree rape, and it provides a definition of consent. But rape would still require vaginal intercourse or sexual act. So this is not about making fondling part of rape. I want to be very clear because that was suggested across the street. Opponents have really suggested they somehow merge, but that is not true. The only cases that can be prosecuted as rape require vaginal intercourse or sexual act. There have also been suggestions that the bill's not needed because of jury instructions, but jury instructions, I mean, you guys know this, jury instructions follow the laws you pass. They don't lead policy. They don't provide the basis for charging, and they don't give Marylanders a notice of what conduct is permitted or not. That's the responsibility and the privilege of the General Assembly. There were also suggestions that instead of defining consent, you should define force. But I think the General Assembly, without me describing any more, can say that sex can involve force, even vigorous force. And what makes it rape is the lack of consent. And really, the definition of consent that is proposed is pretty much from case law. It's the totality of the circumstances, as Ms. Braveboy said. You're going to hear about freezing. You're going to hear about more about education. This really is a modernization of sex crimes laws that brings the law into conformity with what people expect in your communities. And also really helps survivors who freeze, which is a physiological response. So for those reasons, we urge a favorable report on Senate Bill 758.
Good afternoon, esteemed members of the JPR Committee. My name is Asia Rodriguez, and I'm here to offer my personal testimony in favor of Senate Bill 758. Many of you may recognize me from my role within the Maryland General Assembly, often described as a vibrant Californian known for her positivity, outspokenness, and lively demeanor. Yet, there was a time when I was 16 years old when I found myself silenced by an experience that has since profoundly affected my life. Today, I stand before you to advocate for this bill because, to my understanding, it seeks to acknowledge and address experiences like mine through legal statutes. The natural response to threat, fight, flight, or freeze are particularly pertinent in cases of sexual assault where victims may experience varied reactions. I want to share a personal account. One night, I'm hanging out with a friend, or at least that's what I thought. We were both under the influence, and then things took a really messed up turn. He started groping me. I vocalized, "I'm not comfortable," as he was crossing boundaries. But he didn't stop. I spoke up again, saying, "This doesn't feel right." Despite my discomfort, he persisted, taking off my clothes, and my body froze. I couldn't process what was happening, and I'm thinking to myself, was this rape? Is this what being raped feels like? I didn't want this. I knew I wasn't into this guy, and I said I wasn't comfortable. Processing my assault was tough because even though it was not violently forced, my body froze, and it made it difficult to wrap my head around what had happened. This left a lasting impact on my perceptions of intimacy, and it has been a critical factor in understanding my trauma responses as I've grown. My decisions not to report this assault was not because I was worried about legal definitions or consent laws, but was a necessary step in acknowledging my own experience as valid, clearly recognizing the absence of consent. Although this occurred in California, I'm compelled to share my most personal and vulnerable story in hopes that Maryland can lead by example. It is crucial for our state to establish clear statutory language that recognizes non-consent as a fundamental element of sexual crimes, offering support to victims and survivors who choose to come forward. I respectfully request a favorable report for Senate Bill 758, hoping it brings much needed recognition and support for similar experiences. Thank you.
Thank you, Chairman Smith, Vice Chair Wall Striker. Thank you very much, Senator Kelly. That's very hard testimony to listen to, especially as a father of a 7-year-old little girl. So, father, you never want to have your daughter go through that. And it's one of the main reasons I've decided that I think it's extremely important that you hear my voice as the state's attorney for Baltimore City, supporting Senate Bill 0758, Sexual Crimes Definition of Consent and Repeal of Force. As Baltimore City State's attorney, as an advocate for justice and equality, I believe this bill is a crucial step towards ensuring protection and rights of individuals in our community, which aims to redefine consent and amend certain provisions related to sexual crimes in Maryland. Senate Bill 0758 proposal essential changes to the definition of consent considerations for determining the absence of consent in cases of sexual crimes. By explicitly defining consent as a clear and voluntary agreement, the bill establishes a necessary standard for sexual interactions. Moreover, the inclusion of various factors to consider when assessing consent, such as absence of consent in cases of fear, threat, coercion, underscores the importance of respecting an individual's autonomy and their agency. I think furthermore, Senate Bill 758 addresses the issue of sexual violence against vulnerable populations by expanding protections to individuals who are substantially cognitively impaired, mentally incapacitated, and physically helpless. By recognizing the vulnerability of these individuals and prohibiting sexual acts without their consent, the bill strengthens the safeguards against exploitation and abuse. In addition to these substantive changes, Senate Bill 758 clarifies that a previous or existing relationship does not imply consent and emphasizes that consent may be withdrawn at any time. These provisions are essential for dispelling harmful misconceptions about consent and ensuring that individuals have the right to control their own bodies and sexual experiences. Overall, Senate Bill 758 represents a significant advancement in the fight against sexual violence and the promotion of consent culture in our state. By enacting this legislation, Maryland will send a clear message that sexual consent is non-negotiable and that perpetrators of sexual crimes will be held accountable. I urge you to support Senate Bill 0758 and work toward its swift passage into law. Together, we can create a safer and more just society for all Marylanders. Thank you.
I forgot to list Jennifer Johnson, who signed up, and she needs to speak.
Good evening, Chairman, members of the committee. My name is Jennifer Johnson, and I'm speaking on behalf of my daughter, who at the age of 18 was a victim of sexual assault by her pediatrician. Riley was a patient of the pediatrician since she was 1 week old and sought his mentorship in her pursuit to become a physician's assistant. When Riley developed anxiety, she sought his advice and treatment as she felt comfortable and trusted him. On April 26, 2019, Riley was scheduled for a quick prescription check. However, I was unable to attend with her. Unfortunately, the appointment lasted over an hour, and unbeknownst to Riley, all the staff were sent home for the day, leaving Riley and the doctor alone in the office. The appointment started routinely with vital checks and questions about how the prescription was making her feel, and then the doctor told Riley to lay down on the examination table. Riley was uncomfortable and did not expect this and started to experience an anxiety attack. The doctor put his ungloved hands in her pants and touched her lower abdomen and then lowered to her vagina, where he stood over her and digitally penetrated her. The assault lasted 2 to 5 minutes, during which time Riley was hysterically crying, choking, and hyperventilating. He only stopped assaulting her because Riley told him she could not breathe. Riley never at any point gave the pediatrician consent, nor did she deserve to be sexually assaulted. During the trial, the judge found Riley extremely credible, but could only find the pediatrician guilty on second-degree assault and fourth-degree sex offense. The judge found the doctor not guilty of second-degree rape because under Maryland law, in order to find guilt, there needed to be proof of actual force. I am here because Riley is no longer mentally able to discuss the trauma she experienced. As she now fears going to the doctor's office and of doctors, Riley is no longer pursuing a career in the medical field and struggles with panic and anxiety attacks on a daily basis. Please remove the force aspect and codify consent, and please vote favorably for Senate Bill 758 to pass to give my daughter and other rape victims hope for justice in the future. Thank you.
Good evening, Mr. Chair, distinguished committee members. My name is Joyce King. I'm Chief Counsel at the Frederick County State's Attorney's Office. I'm here on behalf of the Maryland State's Attorneys Association in support of SB 758. More importantly, this evening, I'm here on behalf of another victim from Frederick County, Kayla Caliscan. Kayla was 17 years old when she was attending a Christmas Eve party in 2019. She admittedly was impaired by marijuana and alcohol, but not considered substantially cognitively impaired under the law. Kayla had consensual sex with a friend in a pitch black room. That male left the room, went into the party, and said she's not going to know the difference. A different male entered the room and began to have sex with Kayla. Kayla initially thought it was her friend. When something didn't feel right, she reached for her cell phone trying to get the flashlight. The male said, no, 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 no. She was able to turn on the flashlight and realize that it was an entirely different person. She was frantic. She began screaming and crying, fled out of that room, out of the house, got in a car, fled to her home. She told her family. Her parents took her to the hospital. She endured a safe exam. She was interviewed by the police. Kayla did everything right. When this investigation reached our office for charging decisions, our SVU team struggled. Under current law, that's not rape. Although there was clearly no consent, there was no force. And obviously that was very shocking and disturbing to the victim and her family. How could non-consensual sex not be rape? Kayla said it best in her testimony, which I know that you all have received. She said, quote, "He was a boy I had never met, a boy I had never spoken with, let alone permitted him or given him any indication that I wanted to have sex. We cannot teach teenagers like Kayla about consent in school and tell them in something entirely different when they come to report their rapes to us. The justice system failed Kayla, and I hope not to let her and other rape victims down. Consent must be codified and force removed. MSAA asks for a favorable report."
All right. Thank you, Senator Kelly and the panels. Before we open up the questions, I know we have Senator Sidnor and Senator Folden have a couple questions. I just wanted to say to Ms. Johnson and to Aisha in particular, look, public speaking is really hard. Coming down to your state capitol to present is also very difficult, especially here, where it's the majority men here sitting in judgment, hanging off of every word you're saying is extremely difficult. But sharing what has to have been one of the worst moments of your life in front of all of us in furtherance of enacting some sort of change in the state is extremely difficult and is commendable. And I just wanted to say thank you to you and to Ms. Johnson for sharing those stories. Greatly appreciated, and just want to say thank you. We'll move on to Senator Sidnor and then Senator Folden.
Thank you very much. And I heard State's Attorney Brave Boy mention something about the number of cases not being great, but the fiscal note seems to give an entirely different story, where it reads, the state effect is that general fund expenditures may increase significantly depending on the bill's overall effect on prosecutions, convictions, and incarcerations for second-degree rape. Local effect, the bill is not anticipated to materially affect local government operations, but or finances, including the workloads for state's attorney's offices. Ms. Jordan, would you mind commenting about that?
Thank you, Senator Sidnor, for that question. Yeah, I did notice the difference in the fiscal note between the Office of Public Defender's estimates and then the state's attorney's report. And the Maryland Coalition Against Sexual Assault, we're a federally recognized state sexual assault coalition. So we have sister coalitions all across the country. And so, you know, like all of us, we have listservs. So we reached out to all of our sister coalitions. There's not a study I can present to you. However, we got a lot of helpful information. In California, where they actually went further and they did an affirmative consent law, they reported that they did not have a huge increase in cases. In Pennsylvania, where they actually have recognized non-consensual sex as a sexual crime for a longer time, they assured me that they still don't prosecute most rape cases. And in Maine, they, I think, provided the best description when they said that sexual assault survivors approach prosecutors when they believe that they have been sexually assaulted. They don't go and check the code first. So I think that we can be totally confident that there will not be a sea change in cases. What we will find is we're going to find that cases that you've heard about, cases involving freezing, are going to be able to prosecute. And if I may, I know my colleague, Ms. King, also looked at her jurisdiction in particular and found in the past, I believe, 1 year, there would only be 2 cases that would have changed, that they had declined to prosecute, but now that they would. So this is really important for some rape survivors who can't get justice right now. But it's not going to be a huge number of cases.
Thank you.
Thank you, Mr. Chairman. Before I have a question, I do want to commend and echo the chairman's sentiment. You ladies are very, very brave for coming down here and speaking about something that would literally makes you feel so vulnerable and violated. And I want you all to know that that is courageous, and I admire your courage. So thank you all for bringing these messages forward of your experiences and how give us a better understanding. I guess, Ms. King, can you explain, like, in this bill, what we're going to need or what you would need to prove that the defendant understood about consent if there was something to move forward?
Yes, so rape is a general intent crime. The state needs to prove that the accused intended to commit the sexual act without consent. So the accused is not required to read anyone's mind or anything like that. It's based on the totality of the circumstances. This bill is not creating any new standard of consent or a different analysis of consent. It's really just memorializing what's already established in case law, so it's clear for the public and clarifies everything. And again, I mean, there's no reading of the mind. I think the best, Ms. Jordan and I were speaking about it earlier, if a victim's action demonstrates consent, but in their own mind, they are not consenting, that is still not rape. Their actions and everything surrounding the circumstances must demonstrate that lack of consent. And to use Kayla's case as an example, a woman laying in a dark room is not indication of consent. That is not an invitation for any male to come in there to have sex with her.
So this prompted some discussion in my house. I mean, I'm the father of 2, a 17-year-old daughter and a early 20s daughter, and I have a 21-year-old son. So we had some really healthy dialogue about this, because I wanted to be clear on what their interpretation of what the current law is and how I have been a part of enforcing that standard versus what the intent of this bill was. So I find it very, it's an important measure. There was a concern expressed, and there has been, that there had to be an affirmative consent. And I just want to make sure that we're clear that that is not the standard, that it is a totality of the circumstances that would, and it's almost like the standard of totality of circumstances, but also would a person, everybody's on their, individually minded, but would a like person in a similar situation deem that, for example, the Kayla, would a like person not consider that they had been violated? And the answer would be resounding yes, that it was unwanted and it was not appropriate. So I thank you all for bringing this forward. And again, I guess I'll close with, isn't that so? Thanks.
Thank you, Mr. Chair. So I guess I should start talking to the sponsor of the bill. As you know, I'm one of the co-sponsors of the bill.
Yes.
And I totally agree with the part of the bill that gets rid of the requirement of proving force. So that we don't have to talk about that, because I'm with you 100% on that. I am somewhat troubled by the definition of consent and what it would require in individual circumstances. And let me, I found in the testimony, a testimony from an organization called Prepare, and it's the director of advocacy, and it put into writing the concerns that I was inarticulately musing. So I thought I would just read 3 sentences as a prelude to my conversation with you. It says, second-degree rape conviction carries with it up to a 20-year sentence of incarceration
and a lifetime on the sex offender registry. This is an extremely severe punishment. I do not think, this is the director of advocacy talking, I do not think that the punishment for misreading social cues should be 20 years in prison. And then she finishes by saying rape is a serious and stigmatizing crime. And the most basic element of it is ignoring a communicated objection to sexual conduct or obvious inability to object, such as unconsciousness or mental impairment. So she uses the word objection, which is not really contained in the bill. The bill rather requires clear agreement by the individual to engage in vaginal intercourse. So with that as a prelude, let me say, this bill would apply to a married couple, would it not?
Yes, we removed that last year. Yes.
Okay, so that anytime a married couple engages in sexual intercourse, both members of the married couple under this bill are required to engage in clear agreement to engage in vaginal intercourse. Clear agreement. That's what the bill requires. And if one member of the married couple fails to demonstrate clear agreement to do it, that person could be prosecuted by the state's attorney and put into jail for up to 20 years. Correct?
So I appreciate you directing this question to me because I am the sponsor of the bill and I'm thankful for that. But as you know, I'm not an
Would you like
attorney.
to call a friend?
I do think that Joyce King is the appropriate person to answer this.
Okay.
But you know, just speaking from personal experience, rape does happen within married couples. I will say that,
Yeah.
and then I will toss it to Joyce.
I think in response to your question, first, I do want to clarify because I did go through the exercise of going through each of the prongs that were added underneath the definition of consent and compared it with the case law. And there is nothing additional that in addition to anything that already exists in case law. It's the same exact analysis, and I can provide the listing of cases to you all if you'd like to see it regarding that the guidance from the courts that it is still a totality of circumstances, married or not. I think, you know, we don't need to go through a plethora of scenarios, but I think that in different types of fact patterns, it is either clear that there's no consent or it is unclear that there is consent. So I'm happy to provide that case law that itemizes this list and trues it up to what exists under the judiciary's analysis of it.
Well, let me continue along this line. So the bill specifically says that a current or previous sexual relationship by itself does not constitute consent.
Correct. And that's Rhodes v. State 74 MD 680. That's already law.
So if you have a married couple, after this bill's, assuming the bill's passed, if you have a married couple and they have been engaging in sexual relationships for a period of time, and they're in bed at night and one member of the married couple decides to initiate sex, does this bill require that person to obtain from the other married partner the clear agreement to engage in vaginal intercourse as a predicate for commencing sex?
It is not an affirmative consent. You do not need to ask for an agreement. It does not need to be explicit. But I think given the circumstances of whatever that is that evening, the course of the marriage, and I think what has been referenced here, freezing and the state of the victim at that time needs to all be put into consideration and analysis.
It sounds like a complicated thing for a married couple to do in the middle of the night, probably in the dark. So would it be possible for one of the two spouses who to the next day to go to the state's attorney's office and say, I froze, I did not consent, my spouse raped me, and I want you to prosecute my spouse and try to put my spouse in jail for 20 years for engaging in rape?
We've received all types of allegations and different types of offenses that capture situations. And what we do is look at the totality of the circumstances. That one evening, I mean, we look into communications, we look at the context of what transpired. It is not as simple as someone coming forward and making that allegation. And I know that you're saying it's a difficult analysis, but it's an important one that I think that is already exists within this statute and within our case law.
Do we have any sort of research which indicates what percentage of the time a person who is about to engage in sexual relations freezes as opposed to verbally articulates an objection? I mean, if it were me, I can't imagine I would not object verbally and say no. It's hard for me to imagine freezing under the circumstances. So is there research indicating what percentage of the time the sexual partner freezes as opposed to articulates a verbal no?
I think you heard testimony today that captures an individual that was hysterically crying and, I think multiple. So I don't have a data point, but I can tell you that in my jurisdiction, there are these scope of cases where it is absolutely undeniable that the individual froze.
Okay. I was asking for some sort of research. With
I'll defer to Ms. Jordan if she
data
has
as
any
opposed to
data points on
anecdotal
that.
information. Clearly, it does happen. My question is it rare? Is it frequent? Is it prevalent? What are we talking about? What does the research show?
So, Senator West, with the magic of texts, I'm told 70%. And I would say that Ms. Tanya Araya is an expert who will be testifying on the next panel. And she can give you kind of the clinician's perspective on that.
What is the 70%?
I believe that the 70% is the fight or freeze. And so 30% is, yes.
70% of victims who have been sexually assaulted reported experiencing tonic immobility, which is a type of freeze that we've Tanya Araya will be speaking to. And I don't know the study off the top of my head. I can get it to you. There's the source of that information.
Okay, great. Well, we'll wait till you come up, but I'd love to get the source of the information. That would be helpful.
I can try and pull it up right now.
It's that number surprises me, but I've been surprised before, and I'd love to take a look at the research. Thanks.
It is an extraordinary number of people that we're simply not helping. And I appreciate your questions about a married couple, but honestly, the totality of the circumstances, Senator West, we're going to be looking at what has happened throughout the relationship. You're going to be looking at what happened, in that circumstance. Was someone saying to their spouse, don't touch me, get away from me? Was it, I mean, certainly we've all talked about our personal experiences. I don't ever remember saying, yes, honey, we can have, vaginal intercourse right now. Like, that's just not the way couples work, right?
Well, that's what I was getting to when I referred to the objection versus consent. My guess is that couples typically don't affirmatively consent, but if one member of the couple doesn't want to do it, there is an objection that's lodged. No, I've got a headache. I just don't feel. I'm exhausted. I want to go to sleep. Some sort of an objection which would stop it rather than an affirmative consent.
But Senator West, that is because that's what that couple has agreed to. You're allowed to agree to things in advance. You're allowed to have a massage in advance saying someone can touch my buttocks. You're allowed to have a marriage where you can say, yeah, we can touch each other without asking first. You could also make an agreement that, no, you're not going to touch me without asking first. They can do that. The question is what is the criminal law going to support? The criminal law needs to support the fact that somebody needs to have an agreement before they have sex.
So last question here. If I were a young man, not yet married, active, socially, would I be remiss if this bill passes for believing that the only way I could protect myself either from a state's attorney indicting me or from a sexual partner suing me for liability under this bill would be to obtain a written agreement of this partner before we engage in sex. Without that, aren't I at risk of being indicted or sued by the sexual partner because I didn't read the signals correctly?
You would be remiss because the bill specifically says that a written agreement is not required. The
But
document,
that wasn't my question. My question is, how can I assure myself that I'm not going to be indicted by the state's attorney or sued by my sexual partner other than obtaining a written agreement from the sexual partner in advance of the sexual relationship?
Senator, if you're not sure, then you should ask. But if you are sure, then sexual relationships will still continue on. This is an adult bill for adult circumstances. It is not, can I touch you here? Can I touch you there? That is absolutely not this bill. This bill allows and requires, in fact, the totality of the circumstances shall be determined based on a totality of the circumstances, including the words and conduct of the victim and the defendant.
But here's my question. If I do not get such a written agreement, is it not possible that the state's attorney could indict me? And is it not possible that the person with whom I enjoyed an evening in bed, that person would not sue me for a great deal of money for having violated this bill?
So I think this is an excellent question. I think it's important that we talk about liars, right? Because it is important that the bill respond to liars. So right now, the law has a duty to refuse. Like that's really kind of what the law has right now. So if I'm a liar and I want to get someone falsely accused, I lie and I say to Ms. King, hey, this is what happened. And I said, no, don't touch me here. And so then she's got a he said, she said case, and she has to figure that out. If you pass this bill, instead of lying and say, I said, no, don't touch me there, I lie and say, he didn't have my consent. And it's still a he said, she said. So as a liar, I don't really have any more burden on me as a liar. Ms. King has exactly the same burden. She has to look at credibility. She has to look at the totality of the circumstances. And as she so aptly said, she has to make sure this is not a situation where the young man in your example was expected to read someone's mind. He had to have the intent to have sex without consent. There is that general intent requirement. So I would respectfully say, Senator, that we can all be sued by someone. We can all have charges brought against us by someone. Like there are always going to be bad actors. There are always going to be liars. But the public policy of the state of Maryland should not be that we are walking invitations to have sex until we say no. The policy of the state of Maryland should be that people shouldn't have sex with you without your agreement.
Okay. Thank you so much for your answers.
No, Senator West, I appreciate that. Look, we since we've started live streaming hearings, a lot of the questions kind of tend to fall offline, but I think it's important to have some things for the record because even though they're a little bit more uncomfortable to talk about. So I appreciate that. A question for Joyce King, Senator, with Joyce, for Ms. King. And Mr. Bates, if you have to go, I don't want to hold you all folks have to go. So your scenario of in the dark, there was, I think the victim thought she was engaged with someone else, and then someone else came in. It was dark, and she had no idea that there had been this kind of element of deception. And the question is, because I remember we passed a bill last year. It was not in this committee, but it was Senator Lamb's bill, the stealthing bill. Do you remember that bill?
No, it did not pass. It did not pass.
It didn't pass. Interesting. Well, I remember, was it on the floor? I remember this bill very well, but you're familiar with the concept. Okay. If that were in, I guess, well, is that considered rape, or is that fourth degree sex offense? Because there is no, in that scenario, force, but there is deception. And so I guess applied to your circumstance, is there, under current law, wouldn't that be rape when there's someone else coming in? It's even though she had thought she was engaged with someone else, and then there was deception, right?
No, under current law, it's not rape.
Under current law, that's not rape,
Correct.
even though she had not consented.
Correct.
Because there was no force.
That's right.
Okay, so then under the stealthing bill that didn't pass, that then is not rape. That's 4th degree. Under this bill, then under the definition of consent,
It would be rape.
it would be rape.
Correct.
Okay. That's my question.
Thank you.
All right. Further questions from the committee? Thank you all very much. Thank you. All right, is Judge O'Malley or here? We hear from Kristen Rickard, right? Kristen Rickard. Tanya. Aria. And then Jer Welter. And then Debbie Feinstein's up here. There she is.
Good evening. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I also am the co-chair of the Maryland State's Attorneys Association Special Victims Subcommittee. And I also have the privilege in Montgomery County as serving as the chair of our Choose Respect initiative, which is a education initiative for high school and middle school students to talk about healthy relationships and consent. And one of the things that is discussed as a part of that curriculum is, what is consent? What is not consent? A lot of the same questions that have been raised in this committee hearing are raised by students in class. And what we talk about in that is exactly what the legislature has actually determined consent to be. In section 7-445 of the Maryland Education article, consent is defined as the unambiguous and voluntary agreement between all participants in each physical act within the course of interpersonal relationships, including respect for personal boundaries. Now, this is a requirement under Maryland law that this definition of consent and that consent is taught to high school students as a part of their health curriculum. So right now, our law, what we criminalize as rape, is inconsistent with what we are teaching and what is otherwise defined in a different part of the code. When I was teaching this class actually last week, I was at a program with 10th graders, and I was teaching this class, and some of the students had clearly had this education before. So I went on to ask them, what do you consider to be consent? And I asked them to throw out different definitions. Yes is not a requirement for consent. It's certainly one of the possibilities, but not a requirement. One of the students actually articulated back exactly what we define consent as, and as is known as consent. And she used a FRIES, F-R-I-E-S, as an acronym. And she recited back to me and to the class, what does FRIES stand for? And FRIES stands for freely given, reversible, informed, enthusiastic, and specific. That's what consent means. And that's what our law should reflect. It should not require force or threat of force. It's exactly what the other statute defines it as, and exactly where we should be in the criminal law, and exactly what we're teaching every week in high school classrooms, certainly in Montgomery County, and I know around the state. I urge this committee's support of Senate Bill 753. Oh, excuse me, not Senate Bill 758. I apologize. Thank you. Thank you.
Good evening, Mr. Chair and members of this committee. My name again is Katie O'Malley, and I am the Executive Director of the Women's Law Center of Maryland, and we urge a favorable report on Senate Bill 758. So our clients at the Women's Law Center are all victims of intimate partner violence. Many of them have also experienced sexual assaults. And in our representation of mostly women, our goal is to ensure that our clients have physical safety, economic security, and certainly bodily autonomy. By removing the requirement of force and threat of force and focusing on whether there was a clear and voluntary agreement between the individuals, it's essential because of all the things you've heard this evening, the stories that we heard about Kayla. There's so many other stories of individuals where there was not force or threat of force, but there wasn't consent. And so when you're evaluating what consent is, just like everyone has said here this evening, it's at the totality of the circumstances. It's the behavior of the parties, and an evaluator of that, an assistant state's attorney, will look at all of the circumstances surrounding the alleged assault to make a determination as to whether or not they can proceed on a second-degree rape charge. If there is no force or threat of force, they simply cannot. So you have these
situations where you have the young girl who had consensual sex, and then after that happened, the young man walks in who she had no idea who was, thinking it was the same person, and had non-consensual sex, but there could be no prosecution for that because of the way Maryland law stands now. 28 states in our nation have adopted this definition. I think it's the statute in Vermont. It says unambiguous and voluntary agreement to engage in a sexual act which can be revoked at any time. It's the behavior of the parties, whether you're a married couple or not. It depends on the context of the relationship at the time when the situation is happening, when the sex act is about to happen or not about to happen. So thank you. I again urge a favorable report on this bill, and I defer to my colleague.
Thank you. Good evening. My name is Christine Dula-Rickard. I'm Deputy State's Attorney for Queen Anne's County, as well as a member of the Maryland State's Attorneys Association, and I'm here respectfully requesting a favorable report on Senate Bill 758. In my role as a prosecutor in a largely rural and close-knit community for over 16 years, I've had too many conversations with victims of sexual assault. Unfortunately, in a lot of these conversations, I've had to tell victims who've been sexually violated that the crimes that have been committed against them, because there are no force, are not rape, and even though they said no and did not consent to the conduct. My most recent case involved a 17-year-old female who was sexually abused both orally and anally, penetrated by her father. The construct of her household was one in which her father was the supreme authority. The children, especially female children, did not disobey, and my victim did not disobey. On an August afternoon in 2022, the victim was instructed by her father to perform oral sex on him. She did. Her other choices would have been to say no, resist, and run away. But that is not how she was raised, and she knew that there would be consequences for that disobedience. She was fearful of being physically disciplined. She was fearful of not being able to attend school. She was fearful he would do it to her sisters. So she did it. She gave him oral sex. Ultimately, this victim's father was charged. He was tried by a jury and they hung. There was a retrial and she was cross-examined to the point of victim shaming. Why didn't you resist? Why didn't you run? Ultimately, this man was convicted of sexual abuse of a minor, but he was acquitted of rape because there was no force, and that is not fair. The rape statute as currently constructed requires the element of force. It's as if the statute puts the onus on a victim to resist a sexual assault in order for force to occur. Again, that is not fair. Taking someone sexually, penetrating them without their consent is already too much of a violation. Asking for the additional element of force is not fair. It equates a vaginal, anal, and oral penetration without consent to fondling, and it is not. It is so much more. And I ask for a favorable report on Senate Bill 758. Thank you.
Good evening, Mr. Chairman, members of the committee. My name is Tanya Araya. I'm the Director of Programs at Turnaround, Inc. Turnaround for the last 45 years has been the designated rape crisis center for Baltimore County and Baltimore City. In my 34 years as a victim advocate, I have served thousands of sexual assault and abuse survivors. Some I've served immediately after their assault, and others days, months, and even years later. I and my colleagues, other advocates and therapists, often hear survivors' stories about being unable to move and speak during an assault, when in fact they wanted to run and scream and fight back. Many of these victims agonized about freezing and why they didn't defend themselves. Blaming themselves or being blamed by others for not fighting back poses even more difficult of a road to recovery. This increases the likelihood that a survivor will experience shame, embarrassment, anxiety, depression. Freezing during a sexual assault is common. This is supported by researchers who study the neurobiology of trauma and who argue that freezing is an involuntary response to a threat, who also estimate that somewhere around 70% of survivors experience this. This can prevent a victim from actively resisting during an attack. It is beyond conscious control and decision-making, and is especially true for those who have previously experienced trauma. While some victims fight, others are immobilized during an attack. The body becomes rigid or limp and is quite literally paralyzed by fear. Victims are unable to speak, to cry out, or to move. It's time we understand that to freeze during a sexual assault in no way connotes consent. Turnaround respectively requests a favorable return on Senate Bill 758. Thank you.
Good evening, Mr. Chair, members of the committee. My name is Jer Welter. I'm the Chief of the Criminal Appeals Division in the Office of the Attorney General, urging this committee to support and issue a favorable report on Senate Bill 758. As we've discussed, this bill would do two things. It would prescribe how consent is determined, as my colleagues, particularly Ms. King, have already testified. Those considerations for determining consent are established already by case law. The bill would codify case law in that respect. And then most importantly, the bill would amend second-degree rape to remove the element of force. There is currently no law in Maryland that criminalizes vaginal sex or other penetrative sex acts without consent, full stop. Both degrees of rape additionally require force or threat of force. And Senator West, in response to your line of questioning earlier about, could someone just go to the state's attorney and say, I didn't consent, charge my partner. I think the question is not just what can the state's attorney charge. The question the state's attorney has to be asking is, what can I prove beyond a reasonable doubt in court? And the issue with this bill is, as all the factual examples that you've heard, those are circumstances where lack of consent can be proved beyond a reasonable doubt in court, but it's still not enough under current law because there's no force. And that's what this bill would address. We urge a favorable report. Thank you.
So thank you very much. Questions from the committee?
We have one more member.
Oh, sure. Yes.
Okay.
Yep. And then Senator West and Senator Sinner have questions. So.
Good evening, Chairman and members of the committee. My name is Yasmin Bryant. I am a junior sociology major, political science minor at Morgan State University. And I am the founder of Students Against Sexual Harassment and Assault, a student-led organization that I founded in high school after being sexually assaulted. In Sasha, we are dedicated to creating a safe haven for student victims of sexual violence, connecting students with the necessary resources to promote healthy healing and recovery, and most importantly, educating the student body on the vast umbrella of sexual violence, as well as the state and federal legislation regarding all manners of sexual assault, rape, and domestic violence. In my high school sexual education class, excuse me, I was taught that consent is defined, excuse me, as the clear and otherwise enthusiastic agreement to engage in a particular sexual act. This was the same class that my classmate was in. We learned the same definition, and yet I was still assaulted and was not believed. Excuse me. And the further action I attempted to seek justice was not successful because there is no legislation regarding consent at this time. Excuse me. The discrepancy between
I'm sorry. The discrepancy between what is legally recognized as consent and what students are being taught in schools not only creates confusion, but hinders the effectiveness of consent education and young students' understanding of the real meaning of sexual violence. As students engage in relationships and navigate their understanding of intimacy, it is critical that the information they receive is aligned with legal standards, not only for their personal understanding as they step into adulthood, but also for those who have been victimized to have a clear understanding of their experiences and have the legal backing to seek justice. In closing, we, the students against sexual harassment and assault at Morgan State University, we urge you to vote favorably of Senate Bill 758. Thank you.
All right, Senator Kelly I think that's at the end. Thank you very much. Yasmin, thank you. I know we said this to some of the other panelists, but again, just on behalf of the committee, just want to say thank you for hanging in there with us and providing difficult testimony. Senator West.
Thank you, Mr. Chair. I'll be quick. The lady from Turnaround. So you're just the person that seems to have the information that I seek. I will say that in my life, the women with whom I've associated and become friends are almost without exception intelligent, articulate, and strong-willed. Ladies, it's hard for me to imagine, given my experience, that 70% of women freeze when they get unexpected and unwanted sexual approaches. So I'm very interested in what you had to say. I would love you to provide me with any information you have on that. The source authorities that you used in order to come up with those statistics. I really would like to read them because I will tell you, it came as a surprise for me to hear that this evening. It is this evening. And I would like to further inform myself about it.
Thank you, Senator West. I appreciate your curiosity and your willingness to listen to us. I'm going to tell you that I am not an expert on all of the research. I rely on our sister coalition, the Maryland Coalition Against Sexual Assault. They're really the ones who help provide training and technical assistance and education to us. I speak mostly from the perspective of someone who's worked with so many survivors. But if I could at least, and so I'd be happy to work on making sure that we pull a list of references together for you. I can tell you I did some research, found some data on the National Institute of Health's website, but I'm sure that MCASA has more. If I could just point out to you that since we know the prevalence rate of sexual assault is so high for women as well as men, but particularly so for women, when individuals experience trauma, particularly sexual abuse as a young age, that really impacts their ability to protect themselves, to care for themselves.
Oh, no question. No
Yes,
question. No, I'm interested in learning more about this subject. Obviously, I was ill-informed, and it would be great to read whatever you can put in my way.
Be happy to. Thank you.
Thank you. And this is for anyone on the panel. I'm curious, who, if you were to give a description, who's likely to be the perpetrator, or the person that would likely and be the perpetrator of, or the violator for this bill? Who, if you were to draw a picture, are we talking about middle-aged men? Are we talking about young men? Are we talking about Juveniles, who are we talking about?
We're talking about anyone.
No, I understand that, but I'm talking about statistically, who are we talking about that likely is doing this, the act that you all are,
Right.
that the bill is attempting to capture?
I don't actually know the statistics off the top of my head, but there is a significant percentage of people that are known to one another. I believe the number of stranger sexual assaults was somewhere in, if you look at 100%, was somewhere around 19%. And then the others were broken into familiar relationships, non-continuous intimate partner relationships sort of thing. And then sort of those intimate partner relationships. I believe that's the way it breaks down. I don't know if, does that sound right?
19% are strangers.
Yeah, the 19%. Okay, so it is accurate what I just said. 19% strangers, and then the rest are people that are known to each other in different capacities, whether that's an ongoing relationship or a friend or an acquaintance. But it's the 19% is sort of that example of someone on the street being pulled behind a bush. That's the 19%. And unfortunately, we do see cases like that. I certainly see them come through my unit.
I guess those tend to be the easier cases to kind of, for most people to understand, is the stranger cases, but we're talking about 80% is generally people who have some sort of relationship with one another.
Sure. I would say yes. And I mean, we look at the situation that was described by one of my colleagues where this individual unknown to the person came into the room and had sex with her while she thought it was someone completely different. So I think that there's a variety of different circumstances that can arise. And I certainly, when you think about the cases where someone's pulled, on the street, I've seen those cases where that victim has frozen just the same way someone else might have frozen, even when they're pulled off the street. They don't say no, they don't physically fight. They certainly didn't consent. And they could just have been, we saw one, I remember watching a video of a case that happened outside of a metro station. So there was video, and literally the person who was being assaulted was, you could see she sort of froze when the person came to them, and he just led her away. Just walked her away. There was no overt sign of force, just walked her away behind a bush, literally. I went off camera at that point, but there was no overt force used in that circumstance. Certainly there was a lack of consent, and she had no idea who this person was.
I'm assuming that person was likely
Pardon me?
prosecuted. That person was successfully prosecuted, I would assume.
They were successfully prosecuted based on the totality of the circumstances, but I think that goes to exactly what we were talking about earlier. We're always looking at totality of circumstances when we're evaluating this case, which we unfortunately do on a daily basis.
Thank you.
Thank you.
All right, no further questions. Thank you all very much. Thank you. All right, did Maria Ahmad go? Okay, as she went. Oh, Miss Ahmad. Yes, come on up. And then we've got two virtual favorable with amendments, but are favorables. And then we'll switch over to favorable with amendments. Welcome.
Hello. Can you guys hear me? Good. Okay, perfect. Good evening, members of the committee. My name is Maria Ahmad, and I'm a senior at the University of Maryland College Park, where I serve as an outreach peer for the Campus Advocates Respond and Educate program, also known as CARE to make it easy. The CARE office is dedicated to ending power-based violence while also providing resources that allow individuals to navigate assaults and leave dangerous situations behind. We advocate for students, faculty, and really anyone in the campus community who has been a survivor of assault, while also educating the greater campus community about what consent, sexual assault, and power-based violence looks like. Some kinds of resources, just as an example, that we provide include transportation to safe exams, housing and legal resources, and free therapy. I'm here today to show my support for SB 758 that would provide a clear definition of consent. As peers, we teach consent as an agreement between two individuals with clear communication and mutual respect, and that consent cannot be given in cases of physical, emotional, or mental incapacitation. We are very conscious of the language we use so that survivors feel welcome and validated, not ostracized. The current legal definition of consent does not reflect what we as CARE peers teach, especially with the phrase threat or force of threat. In CARE, we learned that during sexual assault, neither fight nor flight is the reaction. Rather, survivors often freeze, unable to retaliate against their attacker. To question the severity of an assault based on whether the survivor resisted or if there were a threat of force is harmful and often deters survivors from even reporting their assault. In fact, out of every 1,000 sexual assaults nationally, only over 975 of the perpetrators will walk free. Understanding and empathizing with survivors is just the first step. Recognizing the power language holds and changing the legal definition of consent will accommodate survivors and legitimize their experiences. On behalf of CARE, I urge the Senate Judicial Proceedings Committee to report favorably on Senate Bill 758 and show their support for survivors of assault. Thank you.
Thank you very much. All right, we're gonna hear from two people joining us virtually, both of whom are in favor. Wendy Novak and Shivati Sit. Are you signed up in favor?
I am signed up, but in favor with an amendment.
Yes, that's the next panel.
Okay.
Thanks. All right, Wendy, welcome. Can you hear us?
Can you hear me?
Yes, we can. Welcome.
Almost 8 years ago, my oldest became one of the 1 in 6 that were the victim of an attempted or completed rape in her lifetime. Through my daughter's experience, I learned more than I ever wanted to know about the legal system and sexual assault. Our laws are out of date, along with the public's understanding of sexual assault. The removal of the word for force from the definition recognizes all that we have learned about trauma. We understand that it is not the survivor's responsibility to prevent trauma assault from happening. In my training with Healing Care Center, I learned that the response to danger is not just flight or fight, but freeze is another response. The current bill ignores this fact. The current law ignores this fact. People may shut down, they cannot move or speak, they may disconnect from emotions, possibly pass out. This bill defines consent in a way that is necessary for understanding incident. Without it, my daughter and other survivors' response is on trial, not the perpetrator's attack. Many of the people in prospective jury pools received formal sexual education decades ago, if at all. They may not have been taught that consent can be withdrawn at any time, that consent should not be assumed based on prior encounters. A clear definition of consent is needed. There should be a focus on whether there is clear and voluntary agreement. The current rape law reflects the time when we believe that how a victim dressed counts as asking for it, and a sexual encounter on a date without consent was simply considered a bad date. The vice chair of an extremist parents' rights group, which is supported by my local representatives, posted on social media that survivors should only share their stories with professionals. Sharing with others opens them up to a lifetime of ridicule. We need to stop putting survivors on trial and hold the rapists accountable. Survivors need the removal of force or threat of force and clear definitions for consent. It is not enough to simply have it in the jury instructions. The definition of consent should be in the law. I urge for a favorable report for SB 0758. Thank you.
Thank you very much, Ms. Novak. We'll hear from Annie Kirsch.
Thank you. I am concerned really about the broadness of some of these provisions, and you'll see there's a 1 through 6. And when I'm looking at something like fear, threat, or coercion, deception, things like that, things that are clearly behaviors that you can tell someone to avoid, I'm really confident in that language, that clearly communicates. Don't put someone in fear, don't threaten someone, don't coerce someone. That's something that I can tell somebody, don't do that, and know that they know what not to do. The language that I find problematic and that I'm afraid that if this passes, I will have an influx of confused and particularly young clients, because let's not forget that people can be charged with this as teenagers, and even high school kids can be elevated into adult court for this conduct. Consent, lack of consent, or withdrawal of consent being inferred from words or conduct, and that you can use conduct or words, and what kind of conduct that doesn't require force to overcome, that doesn't use any words, that doesn't say no, that doesn't pull back. What kind of conduct is that? And my concern is when you look at something that's very, very broad like this, and you look at somebody who might be very young or socially inept, that you might have some issues with that 1, 2, 3, that top bar that you have there. So I think my greatest hope would be that you would look at each conduct. And I hear a lot of people giving examples that were successfully prosecuted under the current law. So what examples of things that couldn't be prosecuted under the current law do you want to see? And then let's not forget minimum conduct. What the minimum conduct is the law we're passing. And that's what we need to be careful of.
All right, thank you very much. Questions from the committee? All right, thank you all very much. We're now going to move on to favorable with amendments, and then we'll switch to the opposition panel.
It looks like that's just me. Thank you, Mr. Chairman, members of the committee. Thank you for the opportunity to address you today. My name is Jennifer Ritter. I'm a senior assistant state's attorney in Howard County, and I am the deputy chief of the Special Victims Unit. I've been with the office for over 18 years, and the last 15 years I've specialized in the prosecution of sexual assault and child abuse cases. I'm here today on behalf of the state's attorney, Richard Gibson, and the Howard County State's Attorney's Office. I want to first express our office's unwavering support of victims of sexual assault. These are some of the most difficult to prove and emotionally challenging cases in the criminal justice system, with the consequences for both the victims and the perpetrators lasting a lifetime. To that end, I'm here in support of Senate Bill 758, but to call for an amendment to Section B5, addressing the definition of submission. Senate Bill 758 proposes to add definitions of consent to the current definition section of the sexual assault article, and also to delete the element of force or threat of force from the statute. For the most part, the definitional sections codify judicially recognized definitions of consent, and we are in support of these additions. Our concern, however, is with Section 5 addressing submission as a result of fear, threat, or coercion. Case law recognizes that submission as a result of fear of force or threat of force is not consent. It also recognizes that calculated actions on the offender can substitute for the force or threat of force element. In evaluating questions of submission, the case law requires both conduct, either through words or circumstances created by the perpetrator to reasonably calculate to instill fear in the victim, and a finding that the victim's fear was objectively reasonable. This analysis, requiring intentional behavior on the part of the perpetrator and a finding that the victim's fear is objectively reasonable, ensures that the behavior being punished by the statute rises to the level of criminal conduct and not just offensive. I wanted to take it just briefly in my written submission, I had used the word regrettable. And just to clarify that, I meet with victims regularly who describe sexual encounters where the person felt taken advantage of or having been manipulated into a sexual encounter. As an advocate for sexual assault victims, I feel for them, but as an officer of the court bound by the rule of law, I have an obligation to make sure laws are written in a way that punishes criminal behavior and not just offensive behavior. And offensive does not equate to criminal. I had submitted in my written statement a proposed language to amend that section, but it looks like I'm out of time. Unless someone wanted to ask me about that.
I thank you. Good prompt. Senator West.
Would you please complete your sentence?
Thank
Your
you.
thought?
Yes, my proposal that Section B5 be amended to read, submission as a result of fear or threat as a result of fear, threat, or coercion does not constitute consent, and this would be the additional language. When based on actions of the perpetrator reasonably calculated to overcome the will of the victim, and where the victims, and I wrote fear, but I think the word would better be submission, is subjectively reasonable in light of the totality of the circumstances. This language incorporates the current case law. It protects victims by deleting force or threat of force, but it also ensures that the behavior being punished rises to the level of criminality. I think both senators had expressed concerns as to how does the perpetrator know if in the event of the freeze that they do not have consent? If you're not requiring affirmative consent, how as a prosecutor do I evaluate that? And I would look at the totality of the circumstances as indicated in the bill, but I think it requires some objective behavior by the defendant that he knew he was committing a crime, that he did not have consent. And that's what I think that language would do.
Appreciate you completing your answer.
Thank you.
I was actually going to ask the same question Senator West did, but also since you got to answer that, just wanted to say thank you for putting some words onto paper. I really appreciate you clarifying your written testimony, and we certainly the intent with drafting this bill was to stick with the case law. So we're happy to work with you offline and make sure we can.
That would be wonderful.
Okay,
because I think it's a great law. That would be my one tweak. Thank you.
Excellent. Thank you very much. Thank you, Senator Kelly. All right, with that, that'll conclude the testimony for the proponents and favorable with amendments, and I'll switch to the opposition panel. Ms. Tien, Mr. Four. And we have, is Vince McAvoy joining us? All right, here you go. Welcome.
Good evening, everyone. My name's Margaret Tien. I'm a partner with the law firm of Etheridge, Quinn in Frederick, Maryland. I'm a former public defender of 25 years, and I've been practicing criminal defense work in Maryland for over 30. In the interest of full disclosure, I was the trial attorney of record for the case where Ms. Johnson's daughter was the complaining witness. I also handled that case on appeal to the then Court of Special Appeals, and I have the matter on remand now back to the Frederick County Circuit Court. Ms. Dufour and I, who are here together in opposition, we are aware that the majority of the members of this committee are co-sponsors on that bill, and we obviously know we can do the math and we know what that means, but we do have some concerns that I just wanted to bring up. One is that to remove force or threat of force as an element in rape, second-degree rape in Maryland, there's a number of collateral effects that I think the committee should be aware of. One of them is the effect that this has on attempted second-degree rape, which is also a felony and also carries a lifetime registration. As Senator West had pointed out, referencing some of the written testimony that was submitted, we have concerns because on the Maryland Sex Offense Registry, rape and second-degree rape and attempted second-degree rape are both lifetime registration penalties. They are also crimes of violence under the Correctional Services article, which requires 50% of a sentence to be served in order to be eligible for parole. Removing force and threat of force makes this very, very close to a fourth-degree sex offense, the only difference being sexual contact as opposed to penetration. I think for all intents and purposes, if force and threat of force are removed from the second-degree rape statute, what ends up happening is you have a scenario where a young person who is not nuanced in the cues that individuals have when they're in physical relations can end up on a lifetime registry for basically digital fondling. I think that is a lot. And I think to consider this in a vacuum, we're going to remove force and threat of force from the second-degree rape statute without considering the collateral consequences. This is a 20-year penalty. This is a lifetime registration on the sex offense registry as a rapist for digital fondling. I think it's excessive. We would just ask the committee to consider that. Thank you.
Good evening, Chairman Smith, members of the committee. My name is Christine Dufour. I'm with the Law Office of Jezik and Moise, but I'm here as an executive member of the Maryland Criminal Defense Attorneys Association, and we're an association of over 400 to 500 attorneys from across all counties in the state, and we are here to urge an unfavorable report. We have a scheme in Maryland, as you're certainly well aware, and Delegate West was instrumental in getting the crime reclassification task force afoot, and it's still ongoing. We first grew rape for a reason. It's the most heinous rape crime. It involves a gun or weapon, certainly force and other aggravating factors. Second-degree rape is the sexual act or vaginal penetration, lack of consent, and force or use of force. I think it's instrumental to read what jurors are read in the courtroom about what the definition is of force, because there is no definition in the code. So the jurors are read, the amount of force necessary depends on the circumstances. No particular amount of force is required. I want to note also that so there's no overt force that's required. In 2017, this body reviewed what sex offense in the first and second degree are, eliminated it, and said both men and women can be raped, first degree and second degree. We also changed, we removed we removed Evidence of physical resistance by the victim is not required to prove rape. That was actually codified in 3-319. And we eliminated the quote unquote against will of the victim. So we've made strides in what it requires, but if we eliminate force or use of force, then we're really, as my colleague said, reducing the crime to basically the only other sex offense that requires just a lack of consent in the fourth degree. We'd urge an unfavorable report, and I'm happy to answer any questions.
I can't believe I'm asking questions of an opposition panel. I've never, ever done this before. I'm so sorry. It just, this committee brings out the worst in people. I have a question. I think your name was Mimi.
Yep.
Yes.
And by the worst, you meant the best.
I meant the
Yeah.
best. Not the worst in me. I'm ashamed of myself, but you
Hi,
said,
Senator Kelly.
hi, how are you?
I'm good.
It's a beautiful color you're wearing. I have
Thank you.
sort of two questions. One is related to you mentioned that you represented the pediatrician.
Correct.
Were
I
there-
still do. I
Okay,
still do.
so I don't know if you can share this with us, but have there been other cases against that pediatrician?
There are,
Quite a number?
I think, and Miss King probably could, because we're on opposite sides of the aisle, in that case, I think there are 30 named victims in a total of 3 indictments.
Joyce?
Yep. Okay.
Okay, so my second part of the question, I don't even know how to form this in the form of a question for you. You said something about sort of building on one of Senator West's questions about how we wouldn't want someone who can't read social cues to end up with all of these penalties. And I just, as the parent of a son with autism, who's a child who truly cannot read social cues, as a parent, society's education system, as a system, all of us are still teaching him not to rape people. And don't you think it's good not to rape people? One word answer.
Yes.
Thank you.
Further questions from the committee? I mean, well, I was going to ask you to expound upon
Yep.
some of the collateral consequences, because I thought that was an important discussion to hear about, to understand the full scope of the issue. So if you want to go ahead and opine
Sure.
about that.
Thank you very much, Chairman. And to kind of follow up on what Senator Kelly is saying, I have 2 teenage daughters. Ms. Dufour has a young daughter. I mean, we're moms as well. I'm not in favor of sexual assault. I do think, I remember years ago when the death penalty was still alive in Maryland, attending a capital defense seminar in Baltimore, and there was a presentation on autism, and one of the in relation to sexual assault, because certain sex offenses were aggravators for capital murder in Maryland when it was live. And I remember the question was that the social worker said, you know, my client said, how do you know when somebody wants to kiss you or wants you to kiss them? And I do think that there are, like, you know, human beings are a collective of our genetics and our learned life experiences. And I think that I'm not in favor of sexual assault. I'm not in favor of rape. I'm in favor of laws that make sense. And right now, and I understand why it was done, right now, the way that second-degree rape is written in Maryland, I came up at a time where it was penile penetration, however slight, of the labia majora, which are the outer labial lips of the female anatomy, for anyone that's not familiar with what that means. That's what rape meant, and that's what rape meant for a long time. And then, as Ms. Dufour said, we kind of refined it. We're catching up with the times. And we said, no, men can be raped, women can be raped. We're going to change that. But right now, if force or threat of force is removed, what this basically means is for slight penetration, because a hand just has to bypass the outer labial lips of the female anatomy for there to be a sexual act that categorizes as a rape in Maryland. That's all that's needed, as I understand the law and the jury instructions. So what we're doing, if we remove force and threat of force, is you basically have a scenario where a young person who may not be, and I understand older people of all ages commit these acts, people of all ages are victims of these acts. But what it can mean is that for basically very slight penetration with a hand or an object into either the anal cavity or the vaginal cavity of another person can now label you a rapist and put you on the sex offense registry for life, put you in prison for 20 years for a crime that under the Correctional Services article requires that you serve 50% in order to be parole eligible. And I heard the testimony and understand the concerns about the bill, Chairman, that you put forward earlier today. But I think that is excessive. I don't think you can look at this in a vacuum and say, we're just going to remove force or threat of force from the rape statute, and then everything's going to fall into place. We'll feel like we caught up with the times. I think you have to be cognizant of the fact that under the Correctional Services article, second degree rape in any degree is 50% to be eligible for parole. Rape in any degree under the Correctional Services article requires you to be on the sex offense registry for life. And I will tell you, and maybe Ms. Dufour disagrees, but I'm going to guess not. For a lot of individuals, that registry is so much more burdensome than the jail time. I'm all the time trying to negotiate for people that are like, can you get me a lower registry? I'll go to jail, I'll go to prison. I just don't want to, for the rest of my life, have to be on the registry. And if you remove force and threat of force, for very slight penetration, digital penetration with a hand, you can put someone in prison for 20 years and on the registry for the rest of their lives. I think that is excessive. And I would just ask, even though I know, and no disrespect to Senator Kelly, who's been a wonderful advocate for women's issues, I know most of you are co-sponsors on this bill. I would just ask you to pause and think about those collateral consequences.
No, I appreciate that. Thank you very much.
Thank you.
It's difficult to chew. Thank you. All right, seeing no further questions from the committee, thank you all very much. And with that, I believe that will end the hearing for Senate Bill 758. The hour is late, so I'm going to go ahead and call. I will be as quick as possible. I have two bills left, so I'm going to call Senate Bill 1101, and then we'll switch back over to Senator Kelly, and then I'll wrap up. All right. Good evening, everyone. Senator Smith here to present Senate Bill 1101. I can bring up, you guys can come up here. So Senator West, this bill actually, I think, dovetails nicely with a bill that we passed of yours, which is the Police Recruitment and Retention Work Group. And perhaps this bill would have been a byproduct of that group in an outlying year. But I thought I'd bring it forward this year as well. We passed a version of this, I think, 2 years ago. Under the sponsor then was Senator Elfreth. And so essentially what this bill is designed to do is enhance police recruitment and retention by creating a GI Bill style incentive and I think a benefit for service. And I'll just go through some of the challenges that law enforcement has faced in the most immediate preceding years. So at the mayor's conference in Delmarva in October of 2023, police shortages actually dominated the coverage and dominated the topic of discussion. And I'll just give you a few of our larger departments across the state and the shortages that they are facing. So leaders in the Baltimore BPD's police union say that staffing shortages are so dire that they need to, and that they are oftentimes requiring overtime work to fill critical shifts. They're actually struggling with a deficit of more than 500 officers. In Prince George's County in September, as of September of 2023, the department was short about 300 officers. In Montgomery County, vacancies have increased by 14%, and that means that over 176 sworn vacancies are there in Montgomery County, our largest jurisdiction. And so this shortage is not just in one jurisdiction, it's across the entire state. So with this bill, what the bill before you does is that it's essentially, again, modeled after the GI Bill. I'm still in the military, so I think this is a very good benefit. And frankly, I still continue to serve in the reserves, and my two daughters benefit from my service. And every year I accrue more points and more time. It's a huge incentive, and frankly, it is the second largest incentive for me to have continued my service in the military. Now, I have drill this weekend, and one of the reasons why I'm still in the reserves is because I'm going to be able to give a fantastic benefit to my two daughters when they go to school, when they go to college. So it's modeled after the GI Bill. It provides a level of oversight through required annual reporting, which comes to the General Assembly and to the governor. It requires also law enforcement agencies to develop recruitment strategies at HBCUs. So there are 4 HBCUs here in Maryland. And it establishes essentially a 2-tier benefit structure. So their tier 1 is for officers who have been employed for 5 years. And essentially they can get up to 60 credits. So they've been employed for a minimum of 5 years. They're current residents of the state. They haven't been reprimanded for misconduct. That's excluding technical infractions. And they will be eligible for this educational benefit, and their dependent child will be eligible for that dependent. The scholarship may be up to 100% of the equivalent annual tuition a resident undergraduate at the University of Maryland College Park would have to pay. So that's the first tier. The second tier is a slightly larger benefit, up to 120 credits, same scheme, same requirements for residency, but 10 years of service is required. And so that's essentially the thrust of the bill. It attempts to identify these gaping gaps that we have in our ranks within our law enforcement, which obviously is a detriment to public safety. I think effective policing in Maryland not only requires the requisite number of qualified officers, but also folks that are invested in the profession, because it is a profession, it is a calling, it is a public service. And so not only is this a great benefit to give to those folks, the first responders on the front line, but it will help increase the quality and the investment of those ranks in our state and in our people and in protecting our folks. So with that, Mr. Chairman, I'll let the rest of the panel go up, and I'll cede for questions. But with that, I'll ask for the committee for a favorable committee report.
Thank you. Chairman Smith, thank you very much. Mr. Chair, members of the committee, my name is Will Milam. I'm an assistant sheriff from Prince George's County, and I'm the vice president of the Maryland State Fraternal Order of Police. I don't need to tell you how difficult it is to recruit highly qualified police officers or to retain the ones that we already have. Many departments are experiencing significant challenges related to balancing their obligation to the public versus ensuring proper staffing to carry out that obligation. Many departments are forced to mandate overtime assignments or to operate short staff just to get the job done. Senate Bill 1101, in my view, is a significant step in the right direction towards fixing our recruitment issues, which will help us to deliver better service to the community. As it relates to better service, many academic studies show a direct correlation between formal college education and fewer incidents of force. The late Dr. James Fife, a criminologist and America's foremost authority on police use of force, examined this topic in Police Use of Deadly Force, a 1988 article in the Justice Quarterly Journal. Fife concluded that college-educated officers are less likely to fire their weapons. In 1996, Robert Warden, a political scientist with years of research in accountability and responsiveness of criminal justice institutions, concluded in The Cause of Police Brutality, a work published by PERF, that college-educated officers are more likely to use reasonable force. And in 1989, an article entitled State of Police Education, Policy Direction for the 21st Century, also published by PERF, Carter concluded officers with a college education maintain better communication skills with the community. Additionally, there's already a template for this sort of educational program in the United States military. As the Senator said, the GI Bill essentially does the same thing for our troops. We think this bill will help us to get more qualified applicants before us and incentivize prospective officers who have college educations to enter a profession as a way of ensuring their dependent child receives a college education. This bill would also help with the retention of experienced police officers, and it can produce a more well-rounded,
educated officer, more analytical in their thinking, more likely to employ better communication skills, less likely to receive citizen complaints, and less likely to use their firearm. Of the many benefits this bill provides, perhaps the most important are the ones it provides to the community. Our community expects and deserves the best officer we can produce for them. And the state of Maryland can set a standard across the country that we will both hold our officers accountable, but ensure they are among the most educated in America. The state of Nebraska's First Responder Recruitment and Retention Act, which provides for law enforcement officers and their dependent children to receive 100% tuition after federal financial aid and grants, already demonstrates that other states are already engaging in outside of the box recruitment and retention efforts. I believe the state of Maryland can do that too, which is why I urge a favorable report on this bill. Thank you.
Thank you.
Hello, my name is Angelo Consoli. I'm the president of Prince George's County Lodge FOP 89 and also the vice president for the state of Maryland. And I also want to thank Senator Smith for bringing this bill, but between Senator Smith and Will Malin, I think they've hit pretty much every point that there is to really to say on this bill. It's a very good recruiting tool for helping us get people interested in coming to the police department. Right now, with the issues we have with hiring incentives and everything else, they're not necessarily working. I think also when we were discussing the reforms over the last few years, one of the biggest discussions was on the education of police officers and wishing that there were officers did have more education, and there even were attempts to make college a requirement to become a police officer. While we don't necessarily agree that you can go that far because it limits the pool of what can be hired, I think it is important that we do educate ourselves. Throughout our careers, we do educate ourselves through the in-service training that we go and seeking outside help. But this would help us get a degree within it. And if the officer wanted to pass that on to a family member instead of himself, then due to the service that they provided to this state, to the county, to the citizens of their jurisdiction, then that is the good positive thing that can come out of it, and which will do well to recruit people. Prince George's County, we are staring down a 400 person vacancy right now, and it's only getting worse. We average anywhere from 20 to 70 person deficit per year. And I think this would go a long way to helping that. I encourage your favorable vote on Senate Bill 1101.
Good job. Good evening, members of the committee. Good evening, Mr. Chairman, members of the committee. I'm Frank Boston. I'm here in support of this bill. Thank you, Chairman Smith, for putting this bill in. I am the legislative lawyer for the State Fraternal Order of Police, and we certainly support this bill. And this bill is huge to the morale of all of our police officers. Recruitment and retention is down and attrition is up. This is due to a lot of reasons that this committee is all too familiar with. This bill will go a long way in giving the incentives to join and stay police officers. I don't need to be repetitive. Mr. Chairman, Will and Angelo have really articulated all of the points, and we urge a favorable. Thank you.
Thank you very much. Are there any questions from anyone? I had a few, if you don't mind. But first of all, just for clarification for the record, Mr. Consoli, you're noted as favorable with the amendment. Is it supposedly just favorable?
Yeah, I'll speak to that. We have some friendly amendments, and then I guess he was signed up with amendments. We have just actually shared them with the chairman's office, and we'll get them to the committee.
Okay.
Once Senator Smith reviews them, just some small tweaks, nothing substantial.
Okay.
Right.
Thank you.
Yeah.
And this is for anyone on the panel who cares to answer. I know in two spots in the legislation, I was curious. It notes the University of Maryland College Park is, I guess the standard on page is page 10, lines 7 through 9, and page 11, 8 through 10. I was just curious what was the reason that, it says maybe up to 100% of the equivalent annual tuition of a resident undergraduate student at the University of Maryland College Park campus. And it's repeated for the second program.
Yeah, so it's a two-tiered system for that. So it's repeated for both of them. But the reasoning there, actually, it was used to my intent was to mimic what we do for like even for our senatorial scholarships and the like. So this actually tags off of the Conroy scholarship if you look in the earlier part of the statute.
Mm-hmm.
And it's used because that's the flagship institution of our state.
That's all I need.
But I will say one parenthetical is that I think St. Mary's the tuition is actually higher. So if you wanted to be,
And that's what I
higher
was
than the
curious
University of Maryland.
if
That's
one
what
was
it's called.
higher, if one had a higher tuition than the other, and
It just mimics the earlier part of the statute, which is the flagship university.
very good. And the second question I had on page 9, lines 3 through 10, it talks about the technical infraction.
Yeah.
But as I'm going through, that was the only, I mean, maybe I was just looking too fast, but it was the only place I saw it defined, but I didn't see where the definition was used. Is that somewhere in the bill?
No, but I can pull that from the other stat. I mean, we're pretty familiar with that, but it's more like, like out of uniform, those types of administrative technical infractions that would not really flight up to the level of disqualifying someone for not being a recipient of the scholarship. So things like
someone
that.
can be disqualified.
Oh, yeah,
from
yeah. If you're disciplined, then you can be disqualified, but that's why the technical infractions is carved out, because those are, more trivial, I think, in nature. Things like
Right,
out of
right.
uniform, and I don't know, give me another one.
Who are we looking to?
Not wearing the right socks.
Right, so what disqualifies one from being able
It's an
to?
example of a small infraction.
An administrative, if you've got an administrative record.
Is that in here?
That's why this is carved out. We can be more explicit in that, though. That was a very important point to notice, though.
Yeah. Okay, thank you very much.
Thanks.
I see no other questions. So next we have Sarah Sample and O'Brien Atkinson.
Mr. Atkinson had to leave.
Okay, thank
Yeah,
you very
yeah.
much. So then it's just Sarah Sample.
He had to let his dog out,
Understand?
but he was here from Anne Arundel County.
Okay. Sample
All right,
floor is
thank you to
yours.
Senator Sidner and the members of the committee for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we support this bill with amendments. We certainly think that having a plan to recruit at historically black colleges and universities is important for diversifying the forces. We also think that having the reports so that we can have a macro understanding of the education level that we have across the force is really important. And then the establishment of the tier 1 and tier 2 scholarships, we think is a great recruitment and retention incentive. The only things we would like to add in terms of amendments are that we think that these types of incentives are only going to be as effective as they are resourced. So making sure that we have ongoing allocations and appropriations that can actually fulfill these scholarships. So that's one thing. And the other thing is just making sure that corrections officers are included in this. We have these individuals who are experiencing similar risks that they're taking in terms of the work that they do, similar issues in terms of vacancies and staffing shortages. And then also, they also have similar consequences in terms of the health effects. And so we really want to start seeing them incorporated into incentives like this. But other than that, we would support this with amendments. Thank you.
Any questions? Seeing no questions, that ends the bill hearing for Senate Bill 1101. Next. 758. Thank you very much. Senator Kelly? Yes, 905, I'm sorry.
Wonderful. I think my panel can come up. I have I think they're here. Yeah, perfect. Wonderful. Let me get started. So this is Senate Bill 905, Extreme Risk Protective Orders Review of Court Records. It's kind of a scary title, but I really don't think it's about guns. It's really about public health research. So we have folks here from the Hopkins Center for Gun Violence Solutions and UMD Progress Initiative to talk to us about why this is important. The bill allows researchers access to extreme risk protective order court records. You can see in the written testimony from Hopkins sort of how privacy is protected under the institutional review review boards, which are federally regulated. I know that's a question that was raised in a letter from the judiciary, just informational letter. We can answer questions on that. There's no opposition on this, but I do think that the existing protections make reduction not necessary, which is the question that was raised by the judiciary. Just by way of a little bit of background, I'm sure Senator West will remember this. In 2021, there was a bill that extended temporary access to this data, and it sunsets this year. So I know Senator West voted for that bill, which I'm thankful for, very thankful for. So this bill is going to lift that sunset and let the research continue. There's also in the file a GoCap letter that talks about a $5 million grant to something called the Burn State Crisis Intervention Program that's going to work on reducing gun violence at the intersection of domestic violence and behavioral health. This is the kind of work that we want to make sure continues to happen. So with that, since it is very late, I will stop talking, urge a favorable report, and have you listen to the experts on this.
Okay. Thank you for all still being here. My name is Jen Poliakonis. I'm the Director of Policy and Programming at the Johns Hopkins Center for Gun Violence Solutions. Our center supports Senate Bill 905. And thank you, Senator Kelly, for leading. This bill adds an exception to Maryland's Extreme Risk Protective Order, or ERPO, law's confidentiality clause, granting access to researchers affiliated with institutions of higher education. Current law already allows data access for CERT personnel, respondent or counsel for the respondent, the Maryland Department of Health, law enforcement. This bill simply adds researchers to that list to allow for in-depth analysis and evaluation of the law. Senate Bill 905 changes nothing else about the law, nothing about process, nothing about court proceedings. And almost all other ERPO states allow researchers access to petition and court records on ERPO. In fact, the information is actually public in many states. Temporary legislative access to Maryland ERPO petitions and data was provided in a 2021 law to support the Attorney General to complete a crime gun study. But that provision for researchers sunsets at the end of this year. This only provided data from October 2018 to June of 2020, so no one has been able to actually study the last 4 years of the law. Without access to key data, researchers are unable to evaluate the law's effectiveness, implementation, equitable enforcement of ERPO. Senate Bill 905 would help Maryland researchers contribute to the growing field of ERPO research. We would help us understand things like what percentage of different categories of petitioners, what barriers are there for petitioning. Is the bill even effective? Is this law effective? It's important to know that. This is a small change, but it could have big impact to public health research. And so accordingly, Johns Hopkins Center for Gun Violence Solutions requests a favorable report. I'm happy to answer any questions. I know, thank you.
Good evening. I'm Karen Herron, Marylanders to Prevent Gun Violence, here in support of SB 905, Extreme Risk Protective Orders Review of Court Records. As has already been explained by the sponsor and the panelists here, this is a very simple bill that enables university researchers to review ERPO-related court records and thus provide a more comprehensive study as to the implementation and effectiveness of these orders. After the passage of the ERPO bill in 2018, some jurisdictions around the state embraced the concept and others took a little bit longer to educate and inform about the use of this tool. We've come a long way since then, and in 2022, the state reports that 741 ERPO petitions were filed, and out of those, 388 were granted. These are high-risk settings where lethal means were removed from someone in crisis and catastrophic consequences were potentially avoided. Mind you that even in cases where a final disposition was not the granting of ERPOs, there are a few interim steps where the process of filing the petition may have still allowed for a pause to take place in lethal access to lethal means for these individuals. But we still have a lot to learn about getting this right. And I won't pretend that I have the quantitative proficiency to be able to crunch the numbers here, but I will tell you that Maryland District 1, as an example, has an alarmingly high rate of firearm suicides.
That district has on average 50 firearm suicides per year at a rate of 6.9%. In fact, 50% of the suicides in District 1 are by firearms. And yet the use of the ERPO tool appears to be very low in those counties. We are not done. I mean, my point here is that we are not done learning about how this tool can save lives and what we need to do in order to implement this more effectively. And so we urge a favorable report on SB 905. Thank you.
Mr. Chair, so late I lost my voice. Mr. Chairman and members of the distinguished Judicial Proceedings Committee, first, may be unusual for a witness to thank you for staying in this late hour and watching the process in Maryland and the range of challenges that you discussed today. And as a pediatrician, I particularly resonated with a lot of the conversation. My name is Woody Kessel. I'm indeed a pediatrician, professor of pediatrics and public health at the University of Maryland, and I have the pleasure of co-directing a new initiative launched by our president focused on preventing gun violence. And we'll work with our colleagues in the state to do this. And I also want to thank Senator Kelly for introducing this to enable us to evaluate and assess using science. You know, in listening all day, the benefit of listening was how many times science, research, evidence was called out, was invoked. And what this law basically is doing is allowing experienced researchers at institutions of higher learning to apply the rigor of science to analyze data, not only for the purpose of identifying solutions, but as my colleagues have identified, for looking at the question of so what, a classic public health question. What happened? What difference did it make? How did it work? Can we improve it? You know, this is key for us to be able to analyze and improve circumstances to prevent gun violence. Universities hold dear the approach to research, the privacy and confidentiality of individuals, and we're committed to all this. So we really ask for a favorable report on this. Thank you very much.
All right. Thank you very much for the in-person panelists. And we'll hear from Paul. Welcome. If you are streaming the video, if you could just, okay, looks like you got it. Just mute the web browser. Excellent. Welcome.
Thanks. And thanks for having me. Good evening, everyone. My name is Paul Nestat. I'm a psychiatrist and I'm an associate professor at Johns Hopkins, where I co-direct the suicide prevention work group. And I'm faculty on the Center for Gun Violence Solutions. I'm also chair of the state of Maryland's Suicide Fatality Review Committee, and I'm a consultant for the Governor's Suicide Prevention Commission. But I'm here today not on behalf of Hopkins or the Department of Health, but as a representative of the Washington and Maryland Psychiatric Societies. We urge support of SB 905, allowing access to data on Maryland's Extreme Risk Protection Orders, ERPOs, in order to improve implementation and efficacy of these life-saving interventions. Firearm suicide, which is the most common type of suicide in Maryland and in the country, has reached a record high in Maryland this past data year. Extreme Risk Protective Orders, ERPOs, have been proven to decrease the rates of firearm suicides on a population level, but more data is needed to be sure that these petitions are applied equitably and to determine the most effective context for their use. The mechanisms by which ERPOs save lives, including the potential mechanisms for them to save more lives, remains somewhat of a black box to us because the specifics of Maryland's petitions have been inaccessible to researchers for a few years now since the lapsing of that data allowance. As a psychiatrist, I'm deeply committed to patient privacy as a cornerstone of the Hippocratic Oath. None of my clinical work would be possible without my patients' trust that I will protect the truths that they reveal in session. When we use patient data to better understand medical interventions, whether that's a clinical trial of a new medication, or for the evaluation of a crisis intervention measure like ERPO, all of our research protocols undergo extensive multi-stage review by an IRB to assure appropriate de-identification and enforce strict rules surrounding encryption, storage, and disposal of protected health information. Having worked as a clinician scientist my whole life, I have supreme faith in our ability to keep private information private. The knowledge gained from this bill's enactment will inform legislators, policymakers, clinicians, and the public, fostering a deeper understanding of the life-saving potential of ERPOs. Supporting SB 905 signifies a commitment to public safety, mental health, and well-being for our communities. With your support, Maryland can lead the way in reducing firearm suicides, setting a precedent for the nation in effective data-driven suicide prevention strategies. The Maryland Psychiatric Society urges vital data access bill. Thanks.
All right, thank you, Mr. Mez. Questions? We have Senator Sidner has a question.
Thank you very much. And for this is for any of you on the panel. When the senator began testifying, it triggered a memory that I had. Former delegate Geraldine Valentino Smith. This was something that was near and dear to her, and I remember being on my way home one evening because of something that seemed similarly related to this. I remember something about Hopkins and research and extreme risk protective orders, and I'm wondering because I don't remember what the issue was, but she seemed up in arms about something with research. So could you provide the context again? Because I'm sure you all may have been involved.
Absolutely. Yeah. Thank you, Senator, for the question. I think she also had some of the same concerns on privacy, but more as it related to the bipartisan and multidisciplinary advocacy groups who were a part of the initial work, which I myself participated in back in 2018 when the bill passed. I have since contacted all of the variety of the different disciplinary organizations like House of Ruth and different mental health advocacy organizations who may potentially have had those concerns. None of those organizations that I spoke to had any opposition to this type of access to records, particularly when talking with them about the oversight of the Institutional Review Board and the types of privacy and confidentiality protections that those federal regulations put on the court records that researchers would have access to.
I appreciate it. Thank you very much.
All right, seeing no further questions, thank you all very much.
Great.
Thanks for hanging in there late with us.
Thank you.
I think is that it? All right, with that, that'll conclude the testimony for Senate Bill 905. We'll now move on to the final bill of the evening, Senate Bill 1097. Tempted to just say read the bill, it's out, let's go home, but I'll give the full presentation here. Senate Bill 1097, Senator Smith here to enter this into the record. You know, when I approach the work here in the General Assembly, I try to kind of adhere to three core tenets, and one is you know, to have a vision and pursue it vigorously. And Senator Walstreicher, Vice Chair Walstreicher, you've heard me give this speech a million and one times, but I try to have a vision, pursue it vigorously, because I think if you spend your time in the Maryland General Assembly with a strategic vision, every year you're here, you kind of nibble away at a section of the code and you move something from left to right, and you've actually changed the game. You fundamentally changed things, but you can only do that if you act in a deliberative and a strategic way. And I try not to be what I call a 60-minute legislator. And what I mean by that is, you know, you sit down on Sunday evening, you see 60 Minutes, and you say, oh, I got to get a bill for that. I got a bill for that. You got to get a bill for that. And you kind of chase topics, and then you don't move in a concerted manner. Whereas if you put, you know, a string on the pearl every year, at the end of your 4-year term, you're going to have a necklace of accomplishment, is what I always say. Second, I always think that you have to convene people. You've got to bring people together. Collective decision making is always preferable to making decisions in isolation or in a vacuum. I'd say you have to be radically inclusive in convening. Look to your left, look to your right, look who's not at the table, who hasn't traditionally been in the halls of power, and go out and get them and help you make better decisions. And then the third core tenet is never take criticism personally, because it'll prevent you from taking it seriously. So this evening, though, I have grossly deviated from the first core tenet, which is not to be a 60-minute legislator, because this summer I read a New York Times article that highlighted gun buybacks, and it highlighted a couple of states. Michigan was featured most prominently, which exposed an aspect of the gun buyback industry that basically hides in plain sight. Countless communities across our nation facilitate what we call gun buybacks. And they're essentially facilitated by police departments or nonprofits or churches. You've seen them all across our state. And anyone can come to these buybacks, turn in their firearm, receive money or a gift card, no questions asked. And they're marketed as a way to get those firearms off of the street with the expectation that these firearms would be completely obliterated. Instead, what has happened is that firearms have made their way to one private company or another that collects millions of dollars for taking these firearms from agencies, destroying a single piece of each of the weapons so that it's stamped with the serial number, and then selling the rest of the component parts for kits across the country. And buyers can easily replace what's missing and reconstitute a weapon. And so essentially what's happening is they call the frame under the ATF definition of firearm, it's the frame or the receiver. And what's happening is these companies are destroying the frame and the receiver and then selling the rest of the component parts. So that means the barrel, the trigger, the grip, the slide, the stock, and the springs, the entire piece, the entire firearm minus I'm looking at everyone over here. Everyone's like, Senator Carter's like, I'm ready to go. Hurry up. Sorry, I'm rolling through. The entire gun minus the piece that's considered to be the firearm under the ATF definition. Apart from this misrepresentation, these firearms are being completely destroyed. They're basically fueling a secondary market, which then can be fueled into ghost guns. So companies like Polymer 80 are buying these parts and selling them for buy, build, and shoot kits. They're ordered online. Remember, we talked about this when we had our ghost gun discussion several years ago, that you don't need a background check to have these. Now, in Maryland, we've outlawed that practice, possessing a ghost gun or an unserialized firearm, but that's not true across the entire United States. And you're all aware of the lawsuit that Baltimore Mayor Brandon Scott won against Polymer 80 just last week or 2 weeks ago. Now, that settlement is historic in many regards, and I won't go over that. But this is a Maryland problem, even though it was a 60-minute impulse on my part, and it was in the New York Times. Buybacks do happen in Maryland. In fact, in Montgomery County, we're going to have one right when we get out of session in Rockville. Anne Arundel County hasn't had any in the last 3 years, but Baltimore County PD, they've got another one scheduled for 2024. In 2023, they had 74 rifles, 130 handguns, a total of 204 firearms through a gun buyback. Rockville City has been pretty prolific in this practice. They've had 600 over the last year, a combination of rifles, shotguns, handguns, ghost guns, and assault rifles, all facilitated for that gun buyback. So what the bill does is it mandates the destruction of the firearms obtained through a gun buyback program, and ensuring that what we would perceive as the entire firearm, the frame and the receiver and all the component parts, are ground up into an inoperable state, which you would think was going to happen through the advertisement of that gun buyback. And it outlines penalties for noncompliance, including fines up to $10,000 and a potential revocation of the dealer's license. I do have 3 amendments that are not in the online version of the bill, and I have a reprint here that I'll redistribute to the committee. One is making gun trafficking a felony. Although the gun trafficking, you're clapping now, you're not going to clap for the next one though. It's an underutilized statute for many reasons. Most prominently is because the federal government handles most gun trafficking, but we could do it. So we should make it a felony as well. And if we have the capacity to do that, the U.S. attorney will take some of the burden off the U.S. attorney, and maybe we can start doing that here in Maryland. Second, it makes stealing a firearm a felony. Since Bruin, I was looking at the Maryland State Police. There he's like, thumbs down on that one. Since the Bruin decision, I was looking at some of the Maryland State Police numbers. So they've issued more than 160 HQLs, and more than 255,000 firearms have been sold in Maryland since that decision. So the reason for me saying this is that guns are just going to be in a more prominent and prevalent part of our daily experience here in Maryland. And that means that firearms are going to be more susceptible to theft. And that's why this is an important aspect of that. And then second, the third part of the amendment enhances training requirements for firearms instructors. They must prove proficiency in the program that is in any program that's already sanctioned and regulated by the state statute and regulation. So With that, Mr. Vice Chair, I know it's the last bill of the day. I sped through it as fast as I could. I would conclude and ask the committee for a favorable committee report. I do have one witness that would like to speak to the training requirement piece. Their training. Okay, there's training requirement piece. But before that happens, I can stand for questions. And if not, I'll just turn it over to my capable panel.
Questions for the chairman, Senator West.
Thank you, Mr. Chair. A simple question. I had assumed that most of the guns that are turned in are stolen, but I see an extensive inventory list from the city of Baltimore for a buyback from last August. 363 firearms were received, only 5 were stolen.
Yeah,
which struck me as surprising. But in light of that fact, I'm looking at the testimony of the Maryland Chiefs of Police and the Maryland Sheriff's Association. They suggest an amendment that the law enforcement agency operating the gun buyback program may conduct an investigation and may release the firearm to a lawful owner. I guess in the case of a stolen firearm, would you have a problem with adopting that amendment?
No, in fact, we've taken that into consideration. It is in, that's your amendment. I know it's your amendment. It's already in the reprint on.
Oh, okay.
Just for a note, I know you don't have the reprint in front of you. So it's a kind of a fluid movement here, but it's on page 3, line 5. This section does not apply to a firearm if the law enforcement agency determines that the firearm is stolen or is evidence of a crime.
Good.
I think that should meet the mail.
Terrific.
With their amendment.
Appreciate it.
But
Bye.
I'll consider it a friendly amendment to incorporate it into the reprint.
Any other questions for the chairman? All right, if you'd like any of your witnesses to come up and testify for all or portions of the bill.
Thank you, Vice Chair. And so you guys are gonna be very happy here. You've already said what we want to say. I'm Russ Hamill, Maryland Chiefs and Sheriffs. And the last amendment that was just discussed by Senator West was the only thing we were going to offer about if it's a stolen gun or a crime gun, we'd like to be able to maintain the gun for the investigation or to return to the rightful owner. So that was our sole amendment. But as a Marylander, I want to thank you all. This is kind of like watching the sausage be made, but it is, I can speak for myself and as a parent of many Marylanders, 5. Thank you for what you do and being here this late. I know you're here this late all the time. Some of you and I and the Maryland Chiefs and Sheriffs may not always see eye to eye, but I greatly appreciate your dedication, your focus to helping all of us Marylanders stay safe and really caring about what you're doing for the state. And that has nothing to do with the bill. After sitting here many days, I really feel I owe that to you all. Thank you very much.
Good evening. Thank you, Chairman Smith. Thank you, ladies and gentlemen of the chair. My name is Timothy Otwell. I'm a retired state law enforcement officer, a current certified instructor for the state of Maryland, a certified NRA instructor, certified USCCA pistol instructor, defensive pistol instructor, as well as rifle instructor. During my time in law enforcement, I was also a certified train-the-trainer with the state law enforcement agency. The amendment that Chairman Smith was speaking, which is to amend the training requirements to be an instructor to teach the wear and carry program for the state of Maryland. At this current time, it is accepted as a 3-day NRA training program or a 3-day USCCA training program in order to become a Maryland certified instructor. I feel as an instructor that this is not enough time in order to certify someone to conceal carry a firearm in the state of Maryland. I've been through countless hours of training and trained thousands of individuals, both civilian and sworn. With that said, a 3-day training program is not going to be enough to properly train a civilian to make the decision on whether or not to use force, in particular lethal force. It's a decision on whether or not you may take a human life in self-defense. I simply make a comparison to being a driver's ed instructor in the state of Maryland. To become a driver's ed instructor in the state of Maryland, after the training program, you must apprentice for a minimum of 6 months under an instructor who has been certified for at least 2 years. If we would not want someone training our children, as a father of 5 as well, to drive a vehicle that's only had a 3-day training course, I would also not want someone with only a 3-day training course teaching someone to carry a firearm. So with that being said, I feel like it's very simple and to the point that the current standard is just not enough. I would believe that a minimum of a 40-hour training course to include the use of lethal force and force on force, as well as proper firearms training and handling and gun handling would be necessary with a full review of skills, the ability to teach, as well as the ability to be reviewed in that process. Thank you.
Thank you. Questions for the witnesses? Seeing no questions, we'll move to the unfavorable. Taylor McKee, John Jocelyn.
Mr. Chairman, Taylor McKee, National Rifle Association. Primarily my concerns had to do with the potential takings with the stolen firearm and not returning it to the rightful owner. So we're glad to see that that is in there. Just as a reminder, that's a Fifth Amendment violation, mandating just compensation for private property, even if it is for the general public welfare or eminent domain claim. So as long as that mechanism's in there, that helps a lot. And I haven't seen the other amendments yet, so I'd like to see those before I commented any further, but thank y'all.
Good afternoon, Mr. Vice Chair, members of the committee, John Jocelyn speaking for 2A Maryland. This bill as currently written, we haven't seen the amendments, of course, under 5-901 and 5-902, it would allow a person or an entity, both undefined terms, to establish a gun buyback, at which point they could then purchase these, as many as they could afford, with the understanding that they would destroy them. However, this is what it doesn't tell you. There's no time frame for the destruction. They are within compliance of the statute as long as they still have them and haven't given them to anyone else. So they can use them, enjoy them for as long as they wish, but finally destroy them. It allows that they may contract with an agency to destroy them. May, not shall. There's no record keeping requirements. Nowhere in the statute does it say they have to record what they took in, as you saw with my testimony in writing that the state police, Baltimore County Police, Baltimore City Police and Rockville Police did. Therefore, you have no way of accounting for which firearms they brought in and what did they do with them? Where did they go? How do you prove they didn't transfer them or traffic them? It also means that they're not running these things through the MSP system to account for firearms that may be on file with the registry, but are now being destroyed. They're not going to check for stolen. They're not going to find out if it's stolen. They're not going to put it into the AFT system, which is a nationwide database of firearms used in crimes. Basically, we've created a sieve where firearms can find their way into the criminal elements, and I find this very distressing. The bill is fixable. As to the training requirement, I don't believe it's really germane to this bill, and I don't think it's appropriate to include it. I will reserve final judgment when I've seen the text. Thank you so much.
Sir McKay, did you have a question?
Yeah, I do. Thank you.
Please.
Sure.
And then
Mr. Jocelyn.
Sir.
I'm not sure that with your comment of the amendment not being germane on this bill, I was going to ask you about an amendment on another bill, 501, but I'm not sure that's germane. So we'll discuss that and bring that up another time.
Very good.
Thank you. Thank you, Mr.
Thank
Chairman.
you so much. Mr. Mohammed, we're ready for your testimony.
Good evening, Chair, Vice Chair. This is Galen Mohammed. I am the State Director for the National African American Gun Association. I'm definitely in opposition to this particular bill. It's actually been proven time and time again that gun buybacks simply do not work, do not decrease crime or suicides in the area where the gun buybacks are held at all. The general idea behind the gun buybacks policies is quote unquote to reduce gun violence that can be lessened by reducing the guns in civilian hands. The flaw in that is the vast majority of the law-abiding citizens who own guns are not the ones committing those crimes. The gun buybacks basically have little to do as far as reducing crime or any kind of firearms, quote unquote, firearms violence, because guns aren't violent. And I guess my research is different from the chairman's because I'm finding that no organization is co-signing these gun buybacks. Definitely ask that this bill receive an unfavorable review.
Thank you so much for your testimony, Mr. Mohammed. We know it's late, so we really appreciate it. Questions for Mr. Mohammed? Seeing no questions, that completes the hearing for Senate Bill 1097. Thank you, Mr. Chairman, for bringing the bill, and that completes our hearings for today.